Good morning, everyone.
Good morning, ma'am.
Good morning.
I, Sharanya Was, the General Secretary of Hindi Vidya Prachar Samiti's College of Law, welcomes one and all on behalf of our college management and organizing committee of VidhiTaksh. VidhiTaksh is the vision of our IC principal, Dr. Mrs. Madhura Karamkar ma'am, and other teaching faculties. This was created to develop new relations with fellow law colleges in India, trying to create brotherhood and harmony. Our motto of VidhiTaksh is to give practical exposure to the students of law. Before I make this event open to all, it's my humble request to Dr. Usha Mukundan ma'am, Director of Hindi Vidya Prachar Samiti's College of Law, Hindi Vidya Prachar Samiti, to share a few words from the plethora of knowledge that she pursues. Where's Usha ma'am? I request the Director of Hindi Vidya Prachar Samiti, Dr. Usha Mukundan ma'am, to please share a few words from her plethora of knowledge that she pursues. I request the Director of Hindi Vidya Prachar Samiti, Dr. Usha Mukundan ma'am, to share a few words from the plethora of knowledge that she pursues. Ma'am, Usha ma'am, you are not audible, ma'am. Ma'am, you are not audible.
On kar. Hello, can you hear me?
Yes, ma'am. Yes, ma'am. You're audible, ma'am.
Okay. Have you started?
Yes, ma'am. I request you, ma'am, to share a few words from the plethora of knowledge, ma'am, that you possess.
So very good morning, respected principal, Dr. Madhura Kalamkar, colleagues, faculty members from the department, members of the supporting staff, and my very, very dear students, young, upcoming advocates who will ensure that the law system in our country is as it should be as per our constitution. You will continue to give justice to one and all. I congratulate you for organizing this fest of yours, VidhiTaksh, which you have been doing very efficiently and effectively every year. And I'm very sure this year also you will come out with some new ideas. So with this, I thank you all for inviting me here today morning and wish you good luck. Have a gala time and have a great day. Thank you so much. Thank you.
Thank you, ma'am. Thank you so much. I now request our IC principal, ma'am, to please light the lamp.
A very pleasant morning to all the dignitaries, respected principals, teachers, students, and participants. I, Dr. Madhura Kalamkar, in charge principal of Hindi Vidya Prachar Samiti College of Law, warmly, heartedly welcome you all for our 3 days Intercollegiate Law Fest 2022. Today, we are having our second moot court competition under the theme of VidhiTaksh on an online mode by maintaining the social distance norm. But I assure that in a very next year, if this COVID pandemic stopped, we'll definitely come on an offline platform. The motto of conducting this law fest, which involves moot court competition, is to conduct and for the students to come out from this taboo of COVID-19 so that they can explore their potential and also strengthen their mindfulness. So these students, they can definitely can take the advantage of this kind of competition to become a successful advocate. This also college is trying to produce the efficient professionals who can contribute their knowledge to our legal system in the society. Hindi Vidya Prachar Samiti College of Law, established in the year 2017, and with the great support of our management, Honorable President Dr. Rajendra Singh sir, we are able to come up with many courses like Master of Law. Also, we have started with postgraduate diploma in 3 subjects, having arbitration, intellectual property law, and cyber law. Also, I'm happy to announce here that we are also have 120 capacity of the students for both the courses. So with this, I want to put on a record that the vision of Dr. Rajendra Singh sir, and with the great assistance and support of Dr. Usha Mukundan madam, Honorable Director, I am exhilarated to have this second Moot Fest with us. And with this, I want to welcome our 2 eminent personalities with us for our today's program. Advocate Prakash Salsingikar sir and Advocate Suvarna madam. So I welcome you, both of you, in this fest. And obviously you will impart your knowledge with our students also and participants. So the main object of this fest is to encourage our students, and but obviously with this I can say that it makes a big and huge difference if you stay positive attitude with you. So I can say that do good will come to you. So with this, I extend my best wishes to all the participants and for their future success in life. Thank you all.
Thank you, ma'am, for your valuable and beautiful insights. Now I request our coordinator, IQAC coordinator, Assistant Professor Amar Sarve sir, to say a few words on this occasion.
Thank you so much, Sharanya. A very good morning to all the dignitaries, participants, and my dear students. I, Assistant Professor Amar Salve, on behalf of Hindi Vidya Prachar Samiti's College of Law, would like to welcome you all on this occasion. First of all, I would like to say that yes, I am into the flashback, because since long people are doing preparation, practices, even demonstration has been done. We all were waiting for this moment, and today is the day of execution. So I would like to appreciate the efforts of everyone. Since long they are working for this fest, and today is the day of execution. Then we are actually going ahead with our second successful VidhiTaksh. So big clap for it, first of all. This is a platform where everyone can explore their potential. VidhiTaksh is having the motto to hunt the hidden talent among the students all over across the University of Mumbai, and we have some entries from other state also. So this is very commendable. Registration, from the registration point of view, I would like to say that we are getting overwhelming responses of the student. So thanks a lot, all the participants once again. My best wishes to everyone. But before concluding, I would like to quote here a very beautiful words of Mary Reton. Kindly pay attention. A trophy carries dust. Memories last forever. So I want to, on this note, I want to say that best of luck, everyone. And please leave every moment of this competition. I'm definitely sure you will definitely give the good memories of VidhiTaksh too. Thanks a lot. Thank you so much, everyone. And I am requesting Sharanya go ahead with the further program. Thank you so much.
Thank you, sir. Thank you so much. So we have along with us two eminent advocates of the town, Advocate Prakash Salsingikar and Advocate Suvarna Avhad. Advocate Prakash Salsingikar started his career from the year 2006 and started practicing on the criminal side. He has been a defense lawyer in several sensitive cases like Shakti Mills case, Narendra Daborkar murder case, Best Bakery case, TRP scam, Anna Bhav Sate Development Corporation scam, Malwani Bush tragedy, and several other cases. On behalf of the state of Maharashtra, he has also worked as a special public prosecutor in some of the cases. He has also worked as a special public prosecutor for the Union Bank of India. Advocate Salsingikar has also appeared on various channels as a legal expert. He has also written articles in newspapers and magazines on the legal aspect. He has also given guidance to the team of Pink Movie on the aspect as to how criminal cases are conducted. He is also giving guiding lectures at many places on the topic of women and child welfare, and especially on the POXO Act. Since last 2 years, he has been associated with the organization Dard Se Hamdard Tak and has been Maharashtra president in this organization. Through this organization, he helps the needy and the poor in the jail free of cost with his legal services. We welcome you, sir. Advocate Suvarna Avhad ma'am has started her career more than a decade ago. She is a senior advocate from the High Court, Mumbai. She has immense knowledge and experience in criminal cases. She is specialized in dealing cases of murders, NDPS, POXO, rape, family court cases, etc. In the span of her career, she has fought cases of the Dawood gang, Chota Rajan gang, Gavli gang, etc. She has also fought cases of the politicians. She has also taken up several cases of anti-corruption. She has also handled sensitive cases like Narendra Daborkar murder case, Malwani Brutal murder case, Sakinaka brutal murder case, and several other POXO cases. She has been on the panel of several companies assisting their legal issues as the Avhad Hospital, Silver Group of Companies, Rajesh Cable Network, Aditya Infrastructure Private Limited, Value Developers, Smile Foundation, SD Corporation, PM Properties, etc. She is associated with the Smile Foundation and works for the upliftment of the poor. In the recent pandemic, she has been proactively caring for the needy and poor. She is associated with the organization Vivekanand Devdasi Sangatna, and as a responsibility towards society, she seeks justice free of cost for them. I, on behalf of Hindi Vidya Prachar Samiti, College of Law, welcome you both, ma'am. Now I declare the event to be open and request the participants to join the links shared in the chat box. The Law Quiz participants are supposed to join the links of Law Quiz. The Think Logically participants are supposed to join the links of Think Logically. The event will start exactly at 10 o'clock. Moot court will be continued on this specific link only. The links are shared in the chat box.
Uh,
I request all participants to please rename themselves as their team codes. I request all the participants to rename themselves as their team code. Rushikesh Murdi Bihalkar.
Yeah, ma'am, we are from the college. I'm a team leader for this. So can I rename with VTM05? Is it okay for? Or only the team member?
Absolutely.
Because from my college, the professors also want to be there to listen yesterday as I requested. So can we rename ourselves as VTM05? Can we be there?
Let the professors be with their names.
Yeah, okay. Because they are also not being allowed right now, unfortunately. That's why. Our principal also wanted to be there. That's why.
Yeah. Please ask ma'am to join with her name. She can definitely join with her name. But the participants and the students who are joining, please join in with the team code.
Yeah. So okay, no problem.
Yeah.
Thank you. Yeah. Thank you.
Ten o'clock sharp, we'll be starting with the competition. Prior to that, I request all the participants to rename their names as their team codes. The first moot to go would be VTM 04 versus VTM 06. The first moot to go would be VTM 04 versus VTM 06. All the other team codes are requested to leave the meeting. All the other team codes are requested to leave the meeting. You will be intimated on your WhatsApp group. Only VTM 04 versus VTM 06 should be present here. We start the moot court competition at 10 o'clock. VTS 04. VTS 04. I request you to leave the meeting, please. I need only VTM 04 versus VTM 06.
You're muted. Ma'am, you're muted.
Hello.
Yeah, now it's audible. Thank you.
Yeah. So we are ready to go for the moot court competition. We shall be having the quarterfinal round today, that is the 10th of February 2022. The rules for the quarterfinal round are each team shall be given a time of 20 minutes. The bifurcation of 20 minutes would be 12 plus 8 minutes. That is 12 minutes for argument and 8 minutes for chief and cross respectively. In the 12 minutes, the mooter 1 shall have his or her arguments for 6 minutes and the mooter 2 shall have his or her arguments for the next 6 minutes. The rebuttal and sur-rebuttal shall be at the discretion of the judges. Marks shall be deducted for the extension of time without the permission of judges. If the permission for rebuttal or sur-rebuttal is granted, the time for it would be 5 minutes respectively. The participant shall adhere the black and white formal dress code when present in any moot court room during the competition. We are ready to start with the competition. VTM 04 versus VTM 06. The prosecution would go first.
Am I audible? Good morning, everyone. Am I audible and visible?
Yeah, you're audible.
Thank you, sir. So when should I start? Court officer?
You can start now.
Okay. The council seeks permission to address your bench as your lordship and your ladyship. Much obliged.
Yes, proceed.
Much obliged. May it please the honorable court, I, counsel number 1, along with my co-counsel number 2, on behalf of the prosecution, the state of Maharashtra, in the case of state of Maharashtra versus Surekha Singh and Mohan Prakash, is appearing before this honorable court. If the honorable court is well versed with the facts of the case, the council would like to proceed with the contentions. Much obliged. The council would like to submit the first issue in affirmative that the accused are guilty for the charges under section 302, 34, 324 and 201 of IPC. It is humbly submitted before this honorable court that the accused are guilty of subclause number 1 and subclause number 2 of section 300 of IPC. As per section 300 of IPC, a murder except hereinafter, culpable homicide amounts to murder if the act by which the death is caused is done with the intention of causing death. The council would like to define intention as a determination to perform a particular act or to act in a particular manner for a specific reason or aim to do it. Secondly, if it is done with the intention of causing such bodily injury, when the offender knows to be likely to cause the death of the person. The council would like to further proceed that as it is defined by the penal code, the accused are guilty of murder as he had committed a act of cold-blooded murder, which consists of the actus reus as well as the mens rea. The council would like to explain the actus rea and the mens rea in the following submissions. Actus rea is the wrongful deed that comprises of the physical component of a crime, and that is to be coupled with the mens rea to establish a criminal liability, and such an act is forbidden by law. In the present case as well, the physical conduct of the accused is by the death of the victim. It can be established by A, the witness statement, and B, the various reports. The council will be dealing with the witness statement in the examination in chief. The council would like to draw your attention in that according to the internal report, The organs did not occupy normal positions, and these organs were deprived of blood. Blood vessels have received, and they received cut from inner periphery, and all the internal organs were in the state of autolysis. According to the external report as well, the body was dismembered into three parts, and it had started decomposing, and there were no blood traces found. At the end of the postmortem, the senior doctor, Dr. Matre, held that the possible cause of death was due to slitting the throat. The council would like to draw attention to the charge sheet and the recovery report filed by the investigating officer Jayant Pawar, which he recovered from the crime scene. According to the report, there were gunny bags which contained dismembered body parts of a male, a butcher knife having a blood stain of 8 inches, sleeping pill strip, zolpidem talte 10 mg, out of which only 4 tablets were left. Apart from that, there were cement bags and tile box as well, which were used, and the broken remaining tiles were held in the tile box. Therefore, according to the charge sheet and the recovery report, it is concluded that the above items recovered indicates that the accused number 1 and accused number 2 are in tandem with the above mentioned crime, and they should be held punishable for the offences under section 302, 34, 201 and 324 of IPC. It is humbly submitted before this honorable court that PW2, an eyewitness and the direct evidence of the crime done by the accused along with the many other circumstantial evidence in the form of witnesses and deadly weapon used. And the postmortem report indicating that the death caused was due to slitting the throat. Therefore, this leads to actus reus of the physical conduct leading to the death of the victim. The council would like to further deal to establish the mens rea in the present case by satisfying two important elements, that is the intention and the motive. The council would like to submit that the number and the nature of injuries caused to the victim showed the brutality and the intention of the accused to kill the victim. The council would like to place reliance that in the case of Lakshman with the state of Maharashtra, where the Supreme Court had held that the nature and the number of injuries to the victim on the vital parts of the body indicates the intention of the accused. To further proceed, in the present case as well, the accused number 1 and the accused number 2 were well versed were fully aware that the objects they were using would cause harm and would lead to death of the person. It proves that the accused had an intention to kill Ram. In the present case, the act of accused number 1 buying the sleeping pills and a butcher knife at the outset that the victim confronted accused number 1 for the rumors he had heard about them. She and her lover planned the murder, and without even a second of thought, they slit the throat. This is proved as per the charge sheet and recovery report filed by the investigating officer Jayant Pawar. The council would like to further explain that there was a
Time up for speaker number 1.
Your lordship and your ladyship, the council would like to further proceed with 1 minute for the submission of arguments.
Yes, proceed.
Much obliged. The council would like to further place reliance that in the case of Sachin Jana and another was the state of West Bengal, the Supreme Court recognized that direct proof of common intention is rarely available, and thus such intention can be inferred by the proven facts and circumstances of the case. In the present case as well, when there are no direct evidences, the testimony and the witness statement are to be held liable. And this proves that there was a common intention between the accused number 1 and accused number 2 to kill the victim, that is Rampal. The rest of the issues will be dealt by my co-counsel. If your lordship or your ladyship does not have any questions.
Yes.
The council would like to address the bench as your ladyship and your lordship.
Yes.
Much obliged.
Yes, proceed.
Would like to state that enough circumstantial evidence is present in this case to prove the guilt of the accused. The council would first like to define circumstantial evidence as the evidence based on inference and not on personal observation or knowledge. And the situation in which are the eyes and ears of justice, but the testimony of witnesses is not always credible, and therefore facts are provable not only by witnesses but also by circumstances. The council would like to draw your ladyship and your lordship's attention to one of the most high-profile cases before the Indian judiciary system, the Arushi Talwar murder case, in which the Supreme Court of India held that all the circumstances and the evidence on whose basis it is pointed towards the accused guilty, and there is no chance of the possibility of any other way, then in such a situation, the accused can be solely convicted based on circumstantial evidence. The count which the Supreme Court of India held that the circumstantial evidence can be a sole basis for conviction with the hypothesis of the guilt of the accused. And last, the circumstances must be conclusive and tendency. Here, the council would like to establish a chain of circumstantial evidence with the help of 4 sub-issues. 1. Witness statements. 2. Medical reports. 3. The statement of the accused. And 4. Number 1 shall be dealt by the council and proved while examination in chief. The council would thus like to draw your lordship and your ladyship's attention to the fact that stated in the postmortem report that heavy traces of zolpidem tartrate, a sleeping pill drug, was found in the body of the victim. The council would also like to add that according to the statement of witness PW7 before the investigating officer Jayant Pawar under section 161 of the CRPC, it was stated that the accused number 1 had purchased sleeping pills from his shop, and he also identified the bills of the same. Also, the external examination reports stated that the corneas of the victim were cloudy and his irises were gray. The council would also like to draw your attention to the fact that there exists a discrepancy in the statements of the accused in relation to the relationship shared by them. According to the statement of accused 1, the accused shared a healthy relationship of friendship, whereas according to the statement of accused 2, they shared a healthy relationship. From the above, it is clearly evident that there was a discrepancy in the statements of the accused, and the council would thus like to submit that basis the statements of PW1, PW4, and PW6, and also the statements of the accused shared an illicit relationship. The council would also like to draw your attention to one of the most notable facts that accused number 2, Mohan Prakash, was a civil engineer working in a nearby construction company, and thus availing of tiles, gunny cement bags, and digging a hole was an easy task for him. The rest of the issue shall be dealt by the council in examination by chief. The council would thus like to state that it is proved beyond a reasonable doubt by circumstantial evidence that crime of murder was intended by the accused and are guilty as charged. The council would like to proceed to sub-issue 1.4, page 19. The council would like to state in
2 minutes left.
Am I audible? The council would like to state in affirmative that the accused are guilty under section 201 of the Indian Penal Code. The council would like to state that under section 20 offense committed or giving false information to screen the offender is a punishable offense. The council would like to bring to the notice of your ladyship and your lordship that the accused have satisfied the criteria of section 300, that is mens rea and actus rea, which my co-counsel had earlier established. From the postmortem report, recovery report, and FIR filed by the investigating officer, it can be inferred that the accused had disappeared all the evidences and left no trace of the evidences of the offense committed. They had done this by hiding the body of the victim into gunny bags inside a hole, dismembering the parts of the victim, and also at the same time digging a hole and burying it into the same. The accused number 1 had also given a false information to the investigating officer as well as the magistrate regarding the whereabouts of the victim, stating that he was in Surat for buying merchandise for his owner. Thus, the council would like to submit that the accused are guilty under section 201 of the Indian Penal Code. With your lordship and your ladyship's permission, the council would like to humbly recite the prayers.
Yes.
Much obliged. Wherefore, in the light of the issue raised, arguments advanced, and authorities cited, it is humbly prayed that this honorable court convict the accused under section 302, 34, 324, and 201 of the Indian Penal Code, declare a sentence of punishment of death or imprisonment for life and liable to fine, and pass any or relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. All of this
Time up.
the prosecution rests its case.
Do you wish to proceed with the chief examination?
Yes. With your lordship and your ladyship permission, the council would like to call upon its first witness, that is Dr. Ajay Matre. Do we have Dr. Ajay Matre present?
Yes, yes.
Am I audible?
Yes, you are audible.
Yes.
Okay. Dr. Ajay Matre, would you just enlighten your lordship and your ladyship your full name?
I am Dr. Ajay Matre.
What are your qualifications?
I am a senior autopsy and forensic.
Since how many years are you in the practice with dealing with this kind of cases?
Around 27 years.
Okay. And could you just submit before the honorable court what was the possible reason for the death of the victim?
It was due to the slit on the throat and the suffocation.
Okay. And the last question, what was the state of dead body when it was found?
It was rigor mortis. There was lack of oxygen and the whole body was swollen.
All right. The council would like to submit that, as stated by doctor in his statement, that he is into the practice since last 27 years. In cases where the dead body is found and it is sent for a physical examination for internal and external postmortem, the testimony and the cruciality of the evidence and the reliance is placed on the testimony of the doctor, considering his experience in this field. The council would like to further call investigating officer Jayant Pawar.
Hello.
Hello.
Yes.
Sir, for your lordship and your ladyship, could you please say your full name?
Investigation Officer Jayant Pawar.
And sir, can you just enlighten the court what is your rank?
Inspector of Police.
Okay. Thank you so much, sir. Apart from that, I just wanted to ask two more questions. Was the missing report filed by the brother of the victim?
Yes.
And on what date the report was filed?
22nd of November.
Did the crime spot match with the place narrated by Komal, the PW2?
Yes.
Thank you. And the last question, sir, can you describe the crime spot and the things recovered from the site?
There were 3 goonie bags with bloodstain on it, a butcher knife, a box of used tiles, a goonie of cement, and construction tools.
Thank you so much. The council would like to further submit that, as stated by investigating officer Jayant Pawar, there were there were 3 gunny bags found, as well as the used tile and other important recovery from the site. And the testimony of Komal PW2 were also in tandem with the statement as produced by the investigating officer that the crime spot and the things which occurred were in the same place. With your lordship and your ladyship's kind permission, the council would like to call upon Miss Komal.
Objection.
Hello.
For what reason you are raising objection?
Ms. Komal was not allowed for cross-examination.
So they are under now she is under in chief examination. Firstly, prosecution will take the examination in chief, then you will get the chance of cross examination. So objection overruled.
Sir, according to page number 10 of the fact sheet, witnesses can be called are only limited to 3 people. That is I.O. Jayant Pawar, Dr. Ajay Matre, and Arun Singh. If I can bring your attention to page number 10 of the fact sheet. There is no mention of other witnesses.
A clarification of the moot court has been shared and a list of 7 witnesses has been provided, sir.
Objection overruled, you can proceed.
Much obliged. The council would like to just inform the defense that the council would like to just ask few questions to the prosecution, to the Komal. As she is a minor, we can understand that it is very difficult for her to be in this situation. But the council would like to just derive few things out of her. Miss Komal?
Yes.
Can you state your full name?
Komal Singh.
All right. Do you stay with your mom and dad?
Yes.
Okay. How is your karate class going on?
Pretty good.
And can you please tell what time are your karate class? What are the timings for your karate classes?
Usually in evening.
Can you just elaborate more at what specific time is the karate class going on?
I'm not sure it fluctuates.
All right.
As per section 141 of the Evidence Act, you cannot lead the witness. Whether she has stated earlier in her chief examination that she is doing karate class, forget about this statement.
Indeed, your lordship. Indeed, your lordship. The council would like to ask, Miss Komal, have you seen Mohan uncle in your house? Miss Komal?
You cannot ask this question.
All right. All right, ma'am. The council would like to rest its case.
You have to plainly ask what she knows.
Yes, ma'am. Ma'am, the council would like to rest its case and the co-council will be dealing with the rest of the examination.
With the permission of your ladyship and your lordship, the council would like to call upon Javed.
Time up.
With your lordship and ladyship's permission, the council would like to call upon witness PW1 Javed Sheikh into the witness box. Much obliged.
Is the permission granted, my lord?
Yes.
Thank you. Thank you.
Hello.
Mr. Javed Sheikh, may I know your full name and age?
I am 45 years old and my name is Javed Sheikh.
Do you support the rumor about an illicit relationship between the accused?
I don't.
Noted. Did Arun approach you while he was searching for his missing brother?
Yes, he did.
Also, can you narrate the incident? When and in what state did you see the victim for the last time?
Well, the last time I saw the victim, that is Rampal, he called me on 9th November at 7:30 p.m. and he was quite stressed and angry. He saw Surekha and Mohan Prakash together at home. And so he asked me to meet him at Resto Bar. Yeah, that's it. And then I left him at home around 10 p.m. and that's the last time I saw him.
Okay, thank you. With your lordship's and ladyship's permission, the council would like to rest their case.
Yes.
Yes, proceed further.
Can the Council for Defense start with this application?
Yes.
Much obliged. The Council seeks permission to refer the bench collectively as your lordships, since the bench is gender neutral. Much obliged. Your lordships, I'll be dealing with issue number 1 and 2, that is section 302, and how the investigation is botched, while my co-counsel deals with section 34, section 201, and section 324 of the Indian Penal Code. Your lordships, the Council for Defense humbly states that the accused, being Surekha Singh, being the wife of the deceased, and Mohan, being the neighbor, have not been instrumental in committing the murder of the deceased Rampal, and are arbitrarily charged under the said section. Your lordships, according to accused 1, testimony of the same, deceased Rampal was supposed to go to Surat on 10th November 2021, one day post to his murder. Your lordships, the council holds this fact to be true. The council also states that we have reasons to believe that Rampal was supposed to go to Surat one day prior and he was murdered. If your lordships, I may bring your attention to page 1, para 5 of the fact sheet. It is written in page 1, 5 of the para 5 of the fact sheet that he used to carry a huge sum of money while going to Surat. Your lordships, the accused 1 was under this impression that the deceased is supposed to go to Surat. Your lordships, thus we have drawn the inference that the accused has left the deceased during the night, and the deceased had left his house for some kind of unknown work, and during the same, this incident had occurred. The phone theory, which is laid down by this accused 1, that the cellular device of the deceased had broken down, was also true and had not been corroborated by the investigating officer, pushing an issue over the entirety of this proceeding. Your lordship, the council contends that the evidence in the present case has not been examined properly. There are many areas in which the investigating officer has not conducted their part of investigation and has prejudiced the entire proceedings against the accused. Your lordship, the council holds that the accused 1 had an extramarital affair and also believed that the entire investigation is not based on factuality, but the societal view of the accused's extramarital relationship, which has put her in this arbitrary matter of investigation. Your lordship, as I move to issue 1.2, there is flaws in the documentary evidence that is present. Your lordship, the council states that the documentary evidence related to the place of commission of offense is not still placed on record. There are inferences pointing out to the fact that the deceased at the time of murder was not in the house. Your lordships, as per police report, it is written in accused number 1, with the help of the lover, slit the throat of the deceased. But at the same time, it is stated that the deceased was at his house, being in a state of intoxication as per PW1. Your Lordship, the main object displaying why the commission of murder was done outside, if I can bring your attention to page 6, annexure 2. Page 6, annexure 2, post-mortem report, which is in the external examination, it has a mention of red sneakers. Your Lordships, we in India have an unsaid practice of removing our shoes outside the house upon entering the house. And no matter how intoxicated we are, it is a prerequisite that we do it. Let alone, if we sit and eat food, we have a tendency of removing our shoes. Even if we consider we go to sleep, we remove our shoes. Your Lordship, the shoes of the deceased have still been intact as per annexure 2 of the post-mortem reports. Your Lordship, neither the prosecution nor the investigation officer has looked upon the aspect of the shoes. Your Lordship, this also indicates that the murder was done outside the house, which gives rise to the suspicion of the story made by the prosecution. There is no mention in the post-mortem report or the investigation report whatsoever regarding the time of hiding of the body. There should have been a thorough investigation regarding to when and where it had occurred. Your Lordship, this is relevant to the case because in page 11, in statement of accused 1, it has been written, since the accused 1 used to be almost 3 hours outside the house, anyone could be possibly accessible and could have hidden the body. Your Lordship, in the case of Madhukar versus and others versus Sangram, it is held by the court that the documentary evidence, if not examined properly, needs to be re-examined. Your Lordship, here the prosecution has still not given an adequate reason beyond reasonable doubt, which pushes a heavy burden still laying on their shoulders. Your Lordship, as I move to issue number 1.2, that is flaws in oral evidence. Your Lordship, the sole eyewitness, as the prosecution holds PW2 to be, cannot be admissible in the court. Your Lordship's PW2 is a schizophrenic patient in the early stages. And according to multiple origins, there have been symptoms of hallucinations as well as delusions. And these episodes are called as psychosis. Your Lordship, in the current scenario, witness hearing noises and seeing parts of things are a part of a disease. And due to the same, this inference cannot be drawn that she is a credible witness. At the time of the investigation statement being recorded, the witness's mental condition can be questioned because the examination officer is not a medical officer to take her witness. Your Lordships, in the Kerala High Court reiterated in Kanthamuddan versus State of Kerala that mentally challenged persons are not competent to testify in terms of Section 118 of the Indian Evidence Act. Your Lordship, the defense believe that the same eyewitness who was under the sleeping medication, being a mental patient, is not a plausible witness, and it is assumed that the witness has mixed variegated incidents, and the same is a figment of her imagination. Your Lordships, she has changed her testimony twice, as per Arun Singh. If I may bring your attention to page number 5 of statement of Arun Singh. It is written, "Mujhe kuch nahi pata, mummy ne jaise papa ko bed ke niche dala, mujhe bhi dal degi." This is the statement which is prior given to Arun Singh by PW2. After which, when a statement is recorded, she has again changed her statement and stated that I woke up to a screaming sound. I saw my mother and Mohan uncle having a knife. Your Lordship, this is a big difference which draws attention that she has changed her statement from first time that she had given it and the second time. Your Lordship, the entire evidence that the Mohan uncle had a knife is being brought up in the second testimony, which is not plausible over here. Your Lordships, in Ramesh Durgappa Hirakar versus State of Maharashtra, in the case, the Bombay High Court has quashed and set aside the impugned order of the trial court, stating that if the observation is based solely on circumstantial evidence, looking at the material available on record, if there is no eyewitness in the case, the court had opined that to convict an accused on circumstantial evidence alone, the prosecution needs to establish a chain of circumstances.
Time up.
If Your Lordships, I may take 1 minute to conclude. Much obliged, Your Lordships. Your Lordships, thus the following can be said that the pathway which has been taken by the prosecution is flawed and not viable. Your Lordships, moving to issue number 2, that is miscarriage of justice done by the investigation officer. Your Lordships, in this, the entire investigation is based on the public opinion. Your Lordships, the council humbly states and submits that the opinion of others had been taken during the conduction of the investigation, and there are several points which have been missing from the investigation officer, being the presence of the red sneakers on the deceased, questioning the shopkeeper regarding whether the accused was supposed to go to Surat or not, place of commission of crime, signs of forced entry, sound heard by PW2. These are aspects which have not been covered by the investigating officer. As held by the Union of India versus Prakash P. Hinduja and other, an error and illegality or defect in investigation cannot impact the miscarriage of justice, and it is brought about or serious prejudice is caused to the accused. It is also held in Abu Thakir versus the state of Tamil Nadu, represented by the inspector of police, where if the investigation is illegal or suspicious, the rest of the evidence must be scrutinized independent of the impact of faulty investigation. Otherwise, the criminal trial will descend to the investigating officer. Your Lordships, we all know the legal phrase, let 100 guilty be free rather than one innocent suffer. Your Lordships, I will rest my case and let my co-counsel deal with the remaining issues. Thank you.
The council seeks permission to address the bench as Your Lordship.
Yes.
Much obliged, Your Lordships. Your Lordships, I'll be dealing with issue 3 and 4. The issue 3 states that charges not in consonant with section 34 of the Indian Penal Code 1860, in which the counsel for defense believes that the accused being charged under section 34 of the Indian Penal Code 1860 will not be held, since none of them both had any common intention. While dealing with the issue 3.1, which states the common intention, the counsel, while admitting that the accused did have extramarital affair, the stand put forth by the prosecution regarding the commission of murder with common intention by the due is one of their far-fetched imaginary stories which do not have any supporting evidence. Now, section 34 of the IPC states that acts done by several persons in furtherance of common intention. Now, in the case of Sankaram Nagare versus state of Maharashtra, it required a pre-arranged plan and presupposes of prior concert. Therefore, there must be prior meeting of minds. It is also reiterated in the case of Shamal Ghosh versus state of West Bengal that common intention means a pre-oriented plan and acting in pursuance to the plan. Thus, common intention must exist prior to the commission of the act in a point of time. In the current scenario, both the accused did not have any intention of killing the deceased and are merely made the scapegoats. After being caught by her husband, accused 1, she assured her husband that she will stop having any relations with accused 2 if her husband is uncomfortable with it. At the same time, there is no sole oral or documentary evidence pushing forth the fact of the existence of accused 2, that is Mohan, on the crime scene apart from a schizophrenic witness. In Krishna Govind Patil versus state of Maharashtra, the Supreme Court held that while it acquitted accused 1, 3, and 4 under section 302, read with section 34 of the IPC, it convicted accused 2 under section 302, read with section 34 of the said code, for having committed the offense jointly with the acquitted persons. That is a legally impossible position. That is a legally impossible position when accused were acquitted either on the ground that the evidence was not acceptable or by giving benefit of doubt to them. The result in law would be the same. It would mean that they did not take part in the offense. The effect of the acquittal of accused 1, 3, and 4 is that they did not conjointly act with accused 2 in committing the murder. If they did not act conjointly, then accused 2 could not have acted conjointly with them. Thus, as mentioned in the above case law, if the acquittal of crime under section 302 is proved, the same would result in the collapse of the subsequent section 34 of this act. Now, moving ahead to the next issue, that is issue 4, which talks about charges not in consonant with section 201 and 324 of the Indian Penal Code 1860, the counsel for the defense humbly state and submit that the accused would not fall under the said section 201 and section 324, since the same have not been instrumental in commission of the said murder of deceased Rampal. While looking at section 201 in sub-issue 4.1, section 201 says that to bring home a charge under section 201 of the IPC, the prosecution must prove that an offense has been committed, that the accused knew or had the reason to believe the commission of such an offense, that with such knowledge or belief, he caused any evidence of the commission of that offense to disappear or gave any information relating to that offense which he knew or believed to be false, and that he did so aforesaid with the intention of screening the offender from legal punishment. And lastly, if the charge be of an aggravated form, it must be further proved that the offense in respect of which the accused did, as in 3 and 4 supra, was punishable with death or imprisonment for life or imprisonment extending to 10 years. Now, in the case of Kalavati and others versus state of Himachal Pradesh, it was held that the borderline between abetment of the offense and giving false information to screen the offender is rather thin. In the case, it is prudent to err on the safe side and hold her guilty only of an offense under section 201 IPC, as she suppressed the evidence, screened other accused, and gave false information in respect of the murder. Keeping in reference the above case law and the unreliable testimony of the prosecution witness, it can be said that body was not hidden by the accused, and at the same time there is a huge 3-hour gap when accused one was leaving the Komal, her daughter, to the karate class, in which anyone could have accused the house, accessed the house and placed the body of the victim under the bed. The prosecution, using the sole unreliable eyewitness, cannot consider the same as a stance and still have the onus upon them to prove beyond reasonable doubt. Moving to the next sub-issue, which talks about section 324 of the IPC 1860, it can be said that the counsel humbly state and submit that the accused have neither committed the said murder of deceased Rampal, nor have they in any manner caused hurt using butcher's knife. Because according to section 324 of IPC, it says that voluntarily causing hurt by dangerous weapons. Now, in the case of the state of Maharashtra versus Balu Sitaram Javare and others, the accused were acquitted on the grounds of the evidence being insufficient that were presented by the prosecution. Keeping in reliance the above mentioned case, there is no evidence of oral and documentary evidence putting the question on the accused of their actions by the butcher's knife. Keeping this in mind that there are other ambits for the said crime which have not been fully investigated, the counsel humbly states that the due cannot be charged on the grounds of lack of evidence and lack of common intention. If your lordships are satisfied with the issues, may I move to the prayer? Much obliged, your lordships.
What is your explanation regarding the last injury?
Sorry?
You were lastly seen with the accused, with the deceased. What is your explanation about that?
Regarding, sorry, so your question is a little...
You and deceased were seen lastly by the Javed. What is your explanation about that point? That is link, that is useful link in the chain.
So I'll let my co-counsel deal with this issue if...
Okay.
Thank you, sir.
Am I audible and visible?
Yeah.
Thank you for the question. Your lordship, just because the accused are seen together does not make them guilty of a murder. Your lordships, we have already stated that the accused have been instrumental in committing an extramarital affair. But sir, just because an extramarital affair is in the place does not justify them committing the said murder.
Why have you admitted on your own self that you have an extramarital affair?
Ma'am, in the fact sheet, it is humbly stated that both of them have confessed their feelings to each other.
People, as said by you in the case, all the witnesses, counsels, people have seen them in the bazaar, or people have seen them talking, or then he tells his friend, the deceased, that when he went home, his wife was there and the other person was there, right? But she is the tuition teacher of his daughter or son, whatever, right?
Your lordship, sorry to interrupt, but we are just trying to show the judgmental side of the society, which is that if two people...
Yes, the judgmental side of the society is different. Now we cannot go on suspicion. Now that you are fighting the case, the accused should be have committed crime in legal parlance, no moral conviction. That's the bottom line. So you shouldn't have admitted on yourself there is an extramarital.
Your lordship, as per the fact sheet itself, it is stated that both the accused have been confessing their feelings to each other. It is not a denial of fact, and your lordship's mere acceptance that there is an extramarital affair is not the acceptance of commission of crime.
This was stated. Okay, okay. This was stated
Yes,
by
Your
the
Lordship.
witnesses to one another, right?
Yes, Your Lordships. It has been stated in the fact sheet, and Your Lordships, just stating that there is a extramarital affair is not amounting to them them committing an offense of murder. This is not a co-relevance thing. This is just a
It may be
factual
one
thing.
of the motive behind the crime. There is a reason for committing the crime, and it is a case of prosecution that there was a illicit relationship.
Your Lordships agreed. Your Lordships agreed. Your Lordships, in India, we have multiple adultery cases, but for the same, we do not go out committing murders. There are other legal options for both of them, for the wife especially, for getting a divorce and then marrying this guy again. But for the same, we cannot just convict them. And as I stated earlier, there have been flaws in the evidences itself.
Your Lordships, if even if there have been any extramarital affair, but later while if when her husband he asked her about the rumors, she was ready to leave the accused too and happily stay with her husband, like for the same. So even if there may be any illicit relations, but still there was like she was ready to leave all that and still stay with her husband.
Yes. Now, Counsel, Madam, you emphasized more on section 34, right?
Yes, Your Lordship.
Yeah. So it is about motive of pre-planning, and there was no pre-planning, you said. If there is extramarital affair, it gives a motive. And in extramarital affair itself, there comes a question of pre-planning and minds meeting together, bodies meeting together.
Your Lordship, this is a very good question that you asked, but I might as well say that there are other options as well with the wife. Even if their minds were meeting, they could have opted some other means such as divorce, filing for a divorce. Why will the accused go for such a
This appeals to your noble mind, because you could think on the right track. The crime is committed.
But nowhere it is mentioned that her relation with her husband was such rough that she will commit murder. And she had kids with, they both had a kid, I think, they both had a kid, Komal. So nowhere it is mentioned that they had constant fights going on in their marital relation.
So do you feel those who have kids never commit a crime?
That's not what I meant to say, Your Lordship. I just wanted to say that nowhere it is stated in the facts that they were having any rough patch going on in their marital life, or they were having any fight sort of thing. She was ready to leave accused too if her husband was uncomfortable with the fact. So she might as well could have opted for divorce if any problem, or if she would have been so irritated, or if she would have wanted to go with accused too, then she would have just filed for a divorce. And I don't think that I don't think that Rampal was so rich that she'll, just murder him and take all his wealth and go. So that was also not the case. So mere option of divorce would have also been key to her.
The motive of extramarital affair, isn't it enough? There should be another motive of money also.
In India, Your Lordship, we talk about if we want to flee away from our husband, we talk about the financial aspects also, that what I'll get from my husband. So
good attempt.
Yeah. The permission of Your Lordships, can I move to the prayers?
Yes.
One more thing, how the body received from your bedroom?
Your Lordship, in the 3-hour gap, that when the accused one, that is Surekha, when she was going to she was going to send her kid, like Komal, to the karate class, anyone could have just come and hid the body there and just might have left. My co-counsel, he stressed on the fact of having red Snickers in on the body, it was on the body. So it is stating that the murder was committed outside the house, and maybe in that 3-hour duration, anyone could have accessed the house and could have dug the hole and done the due diligence, whatever that is.
A question to your co-counsel. my brother judge has asked this very correct, sensitive question.
Yes, Your Lordship.
About the body, right?
Yes, Your Lordship.
Right. Yeah. So, what was the timing when his friend left him in the house?
Your Lordship, his friend left him at 7:30 p.m. of the
Just check
day of
again, if you can.
So, Your Lordship, I meant the friend along with him left at 7:30 and they both reached the house at 10 o'clock. I was concluding.
10, after 10, 10, 11, something maybe.
Yes, Your Lordship. 10.
Right,
Yes, Your Lordship.
right. Yes. So karate classes and this timing, could it match or does it match classes?
Your
and
Lordship,
timing?
no. That is where the moot point comes into picture. Your Lordships, I have never stated that the murder did not occur at 10 to 1 p.m., which is prescribed as the post-mortem report. I am conferring to the facts and I'm stating that the murder has occurred between 10 to 1. But at the same time, I am not stating that the murder has not committed outside.
The post-mortem report? Are you challenging the expert?
No, Your Lordships, I am not challenging the post-mortem report. I am stating.
At night?
Your Lordships, I'm not challenging the post-mortem report. I'm stating that the murder has been committed between 11 to 1 p.m. My point is that after the commission of murder, the body has been later on displayed in the bedroom. Your Lordships, there is no...
Your Lordships, the time of digging is nowhere mentioned in the report.
One sec. Taking forward the contentions of both you counsels that 3 hours after the murder, there was no one in the house.
No, Your Lordships. I'm not stating that 3 hours after. Your Lordships, according to the fact sheet, it is stated that the wife, along with the kid, used to go for 3 hours to her karate classes every day.
After that's I put my question again. I could put it to the chief counsel, taking the chief also. 10 p.m. and 3 hours ahead. It's unbelievable. Any karate class of a little girl, 10, 11-year-old.
Your Lordships, I believe there's a difficulty in the mode of our understanding. If you may allow me to rephrase what I'm trying to suggest. Your Lordships, I am agreeing to the fact that the murder has been committed between 11 to 1 a.m. 11 p.m. to 1 a.m. the murder has been committed. Your Lordships, I am just stating the fact that every day the house used to be free for 3 hours. During those 3 hours, if the murder has been committed by me yesterday, can I not place the body tomorrow, day after tomorrow, someday later on, during those 3 hours?
Murder time is given in the post-mortem report, the time of death. And secondly, you all are taking the plea of alibi, maybe, I could say, that you're not on that position at that point of time.
No, Your Lordships, no plea of alibi has been taken in this case.
That you are not there at that point of time. You are somewhere else.
The accused one, yes.
Right? Yes. Then you are somewhere else. So when you say that you are somewhere else, you have to be convincing that at that time you were for this reason. Because no karate classes go on after 10, 11 p.m. to 1 p.m.
Your Lordships, there is still misunderstanding. If I may just give the timeline to you again. Your Lordships, I commit her murder between 11 to 1 a.m.
Yes.
After I commit her murder,
so
which
you
is
admit?
somewhere... No, in a hypothetical situation, Your Lordship, this is not an admission of guilt, Your Lordship.
Say that, counsel, say that.
In a hypothetical scenario, I commit her murder between 11 p.m. to 1 a.m. After I commit her murder, I am not disposing the body at the same time. That is what my moot argument is, that the body has been killed outside the house. And after that, each day, the accused used to go with her daughter to the karate classes. Each day, the accused used to go. The body can be hidden during this entire duration, whenever between those 3 hours. I am not stating after the murder. I'm stating each day there used to be these karate classes where the accused used to go along with the daughter, and during those 3 hours, the body could have been hidden. That is my statement.
Your Lordship, this statement can be supported by the fact that the time of taking is not mentioned anywhere in the reports. So we can assume, we can say that the body can be digged the day after the murder taken place.
Your Lordships, if you may allow us to go on with the cross-examination of the witnesses, we may forward our point ahead.
Yes.
Much obliged, Your Lordship. Your Lordship, I would like to call out the investigating officer for cross-examination.
Yes, yes.
Much obliged.
Sorry to interrupt. The defense will have full 8 minutes for cross-examination.
Much obliged. Thank you so much. May the witness please state their name and designation?
Investigation Officer Jayant Pawar.
Thank you so much. So when you recovered the dead body, was there the shoes on the dead body?
Yes.
Thank you. Is there any sort of evidence which states that the murder has occurred inside the house?
No.
Thank you. Has the shopkeeper been inquired about where the phone was kept by the accused one?
Yes.
I repeat my question, has the shopkeeper been inquired whether the phone has been broken by Surekha?
No.
Thank you for the clarification. Another follow-up question, has there any inquiry placed whether Rampal was supposed to go to Surat or not?
No.
Thank you. Is there any sort of proof or evidence putting accused number 2 on the spot of crime during the crime?
Yes, because according to the witness, Komal.
If I may suggest, you refrain apart from prosecution witness to testimony.
Let him answer, give the complete answer to your question.
All right, sir. All right, sir. Thank you so much. Please.
So, according to the witness, the daughter of the deceased, she had clearly mentioned that she saw Surekha Singh, accused number 1, and accused number 2, Mohan Prakash, with a knife.
Okay. Has there any other evidence apart from the testimony of PW2 proving that accused number 2 was on spot? Do you want me to?
There was a butcher's knife which was found.
We still did not, I think, connect over the question. Is there any other evidence proving that accused number 2 was on the crime spot apart from witness testimony? The butcher's knife is a part of evidence.
No.
Follow-up question. Has there been any fingerprint evidence found on the butcher's knife which relates to accused number 2? Has there been any fingerprint evidence putting accused number 2 on the spot of crime?
No.
That would be all. Your Lordships, if I may bring your attention that the investigating officer has still not questioned whether to the shopkeeper regarding the condition of the phone. He has still not inquired whether Rampal was supposed to go to Surat or not, which is also in my main submission a major issue. Because as I stated earlier, Rampal used to carry a huge sum of money whenever he used to go to Surat. Your Lordships, as your Lordships mentioned earlier, that apart from extramarital affairs, can money be a factor as well? Your Lordships, yes, money can be a factor to killing as well. When it comes to money, anyone can kill. Your Lordships, if I may go on with the prayers. Much obliged, Your Lordships. Your Lordships, the Council humbly prays and submits that the Honorable Court adjudge and declare that the prosecution has failed to prove beyond reasonable doubt the commission of murder by the accused, and to hold both accused 1 and 2, that is Surekha and Mohan, not guilty under section 34, 201, 324 and 302 of the Indian Penal Code, and acquit them of the above mentioned charges. Your Lordships, also to hold the investigation officer has not conducted the entire investigation comprehensively and direct them to conduct the entire investigation in a fair and non-prejudiced manner so that justice can prevail. Much obliged, Your Lordships.
Your Lordship and Your Ladyship, the Council would like to rebut certain points of the defense.
Yes.
Much obliged. The Council would like to submit that, as my learned friend of the defense had rightly mentioned that there were red sneakers found on the body. The Council would and also mentioned that they must have dug the body or hidden the body later in any days from 10th November. The Council would like to state that they used to reside in Mohalla and Chaul system, where if a body is being carried from any place into 3 different parts, it can be visible by anyone. But according to the witness statement, or anyone could have seen that. The counsel for the defense failed to explain that part of the thing, that if they are relying on the defense that the body could have been carried on a later date during the karate class in the evening, basically, as mentioned by the council, that the karate class were in the evening and they used to hit the body during that 3 hours period. In the evening, when a mahalla is always occupied by people, won't it be evident for the other peoples to witness the same? Apart
Yes,
from that,
Counsel, a question for you now, that your witness, the IO, the investigating officer, was put in the box. You asked him about to describe the spot of crime. And he has described like gunny bags and knife and this and that, etc. But he has not described a house or bed or anything. So how do you say it is a house when your witness itself has not described it?
indeed, your ladyship, the council would like to answer this question in a way that the crime spot, which was the recovery rate, in the recovery, it was mentioned that they recovered the body from the house of the accused, and there was a manhole dug that was 3 by 4 feet. It is mentioned in the charge sheet filed by the investigating officer.
Yes, that is the documents of evidence, but now he was put on oath. When he deposed on oath, he hasn't mentioned the spot at all. And this question, another question was for you, that the timing of Javed dropping him home, it was, as the council's witnesses said, 10 or 11 p.m. Right. So this question was for you about the classes of the little girl and the timings. How do you proceed with that?
Indeed, your ladyship. As we correctly, the council would like to answer this, that when the PW2 Komal was asked about her karate class, she mentioned that the classes were in the evening. According to the statements of accused number 2 and the facts of the case, the Rampal had taken a half day on that day and he had returned home seeing Mohan, Prakash and the accused number 2 Surekha Singh together in home. After that, he immediately left, and thereafter he met his friend Javed, who met him after his namaz time at 7:30, and they returned back at 10 o'clock. Till 10 o'clock in the evening, they were together. After that, they ate their dinner together, and later, after having the dinner together, later the alleged crime, which murder was committed by the accused, had occurred.
Now the little girl, whom you all have put forth as a witness, she is with some mental illness. Have you had the certificate or a witness or a doctor to prove that she is mentally stable?
Yes, your lordship. Yes, your ladyship. There are various documents which can be presented, and there are various documents in which they are mentioning. The accused number 2 herself is mentioned that I can submit the relevant medical documents of the daughter.
But her documents would prove that she is a schizophrenic patient. Schizophrenia is an illness of mind, brain, right?
Indeed, your ladyship.
The person goes on the feelings that she is feeling this way, so she's telling this way. kind of.
Indeed, your
So how do
ladyship.
you
But the
rebut
council would like
for your
to
case?
state that the council would
You
like to
haven't
state
taken
that
you haven't taken a medical expert advice and document to support your case that she's
indeed your
stable.
ladyship. But in the fact sheet and the statement of the accused, it is mentioned that she was facing from early stages of psychopathy. So if there is an early stages, it shall not lead to a high level of dilemma or high level of hallucination, or it is not that her mental capacity is so less that she cannot differentiate between a right and wrong.
That's a presumption.
Indeed, your ladyship. But according to the medical documents, if there is early stage, if it is mentioned that it is an early stage of psychophrenia, so there are various relevant documents as well for the same that it has been detected as an early stage.
Right. Good.
Indeed, your ladyship. Much obliged. The council would like to restrict.
Your lordships, if you may permit me to go on with the rebuttal.
I think the time is up now, right?
Your lordships, each individual get different amount of rebuttal.
For the cross-examination and arguments,
Not the cross-examination, ma'am. For the
let me
rebuttal.
complete. VTM 06, please let me complete. The time is up for argumentation and cross-examination. If the bench permits for rebuttal, every team would get 5 minutes for rebuttal.
Not 5 minutes, but conclude it as soon as possible. Conclude it early. Start it.
Sorry, if I'm not mistaken, the prosecution just did the rebuttal right now. So I would like to use my privilege for the same.
Yes, please. But conclude
Much
it
obliged,
sooner,
Your
not 5 minutes.
Yes, Your Lordships, definitely. Your Lordships, the prosecution is not a medical examination officer to state the reliability of the witness. Firstly, I would like to place this on record. After this, the prosecution has also wrongly stated that PW2 is an eyewitness. Your Lordship, the witness has not seen the commission of murder and nor has seen the body being thrown down the bed. The prosecution has just repeated the inferences from the charge sheet and has not drawn any inference, which is proving beyond reasonable doubts. Just by citing case laws and repeating facts does not lead the prosecution free from the onus of proving beyond reasonable doubts. Your Lordships, in the cross-examination, the prosecution has reiterated the fact and nothing additional has been procured from the same. Your Lordship, the prosecution also stated itself that the body could be hidden any time during the later hours and thus pushing forth our theory, which is the body can be put out later on in the stages. Your Lordship, that would be all from my side. If you have any questions, I would be obliged to answer.
Your ladyship, I would want to answer this part of the statement. The PW2 Komal had seen Mohan uncle had a butcher knife and they had a gunny bag which was open. So she must have not witnessed the whole incident by putting each and every part of the body, that is 3 parts. But she had witnessed that Mohan uncle had knife and there were gunny bags present in their hands. So it is relevant to state that they the PW2 is
Can
a credible witness.
you rely on a witness who is mentally unstable?
Your ladyship, the council would like to state that if she is intoxicated, if the PW2 Komal is given a certain medication, that time she must not be having a mental capacity to make or understand the things. But in the current state, there is nowhere mentioned that there is any
Does your
medication.
investigation show that she was not intoxicated or she is not under the influence of drugs? You cannot take the point that in the current situation, it is nowhere shown that she is under the influence of drugs because she's been given those drugs and she is kept on a medication, on a prescription. So it is but natural, maybe 3 times a day she may be taking or 2 times a day she may be taking. You now have to clear it or prove it that she was not on the drugs.
Indeed, your ladyship, but being an early stage of the disease, no doctor would prescribe such heavy doses to a minor such that it can impact the health of the person.
It was your version that at that moment of time she was not intoxicated or she was not drugged. These are the effects of the drugs. Hence this question was put to you.
Your Lordships, if I may go on with the proceeding, conceding of this. Your
Let him,
Lordships,
let him complete. Let him complete.
Sorry.
The council would also like to state that the jurisdiction point in which the defense has brought before this honorable court is vague because they are asking for a death penalty, and a court of session cannot issue any award any death penalty to any person, any accused, where there is a punishment which is more than 7 years. The council would like to rest its case.
Ma'am, the defense counsel has not come under the jurisdiction of death penalty. It is the prosecution who lays down the case. My learned friend has been misguided on the fact. And apart from the same, I would like to state that even if early stages of psychosis is there are hallucinations and delusions according to multiple learned officials of the World Health Organization. Your Lordship, the counsel for the defense would also like to humbly rest their case upon your
My brother judge, with the permission of my brother judge, I would like him to address this issue. Am I audible, sir?
Yes.
Salsingikar, sir. Am I audible?
Yes, you are audible.
He says, the prosecution says that Sessions Court cannot give death sentence.
The council would like to stand corrected for this. The council would like to state that they can award death penalty or punishment more than 7 years in confirmation with the High Court.
You mean to say the Sessions Court independently cannot award that punishment, death sentence?
Indeed, your ladyship. Indeed,
My
your ladyship.
my brother judge will.
Session court after the trial can give the capital punishment, death sentence, and after that it will goes to the High Court for the confirmation, and only after confirmation of the High Court it will be decided whether to award death sentence or it may be converted into life sentence. Recently in the Shakti Mill case, you may aware about that. Initially 3 persons awarded death sentence, and during the confirmation their sentence is converted into life imprisonment.
So with his profound knowledge, my brother judge has said that Sessions Court can independently award death sentence, and it has in its jurisdiction and power to award death sentence because it is the trial court. It does not require confirmation when the trial is going on, when the trial is finished, and when the judgment is to be given. No confirmation is required. Confirmation goes after death sentence is awarded. Then the matter goes to the High Court. That is it.
Indeed, your ladyship.
Yes.
The council stands corrected.
Good. So I think this is over now. Yes. So I think the arguments and the prayers are over now.
Yes, my lordship.
Yes, we move ahead.
So thank you, VTM 04 and 06. Your results will be declared after the moot court competition. You will be intimated on the WhatsApp group. So we'll have next coming up. I request VTM 04 and 06 to please leave the meeting.
Can we have a break of 5 minutes?
Sure, my lordship. Sure. Shall we resume at 11:20, my lordship?
We can resume early, just 5-10 minutes break. Yeah, 11:20, fine.
Yes, my lordship. VTM 01 and 2.
Yes.
We shall resume the competition by 11:20. Let me read out the rules for you by then. So we shall be having the quarterfinal round today, that is 10th of February 2022. The rules for the quarterfinal round are: each team shall be given a time of 20 minutes. The bifurcation of 20 minutes would be 12 plus 8 minutes, 12 minutes for argument and 8 minutes for chief and cross respectively. In the 12 minutes, the mooter 1 shall have his or her arguments for 6 minutes, and the mooter 2 shall have his or her arguments for the next 6 minutes. The rebuttal and the 8 minutes are for chief and cross examination respectively. The rebuttal and sur-rebuttal shall be at the discretion of the judges. Marks shall be deducted for the extension of time without the permission of judges. If the permission for rebuttal or sur-rebuttal is granted, the time for it would be 5 minutes. The participant shall adhere the black and white formal dress code when present in any moot courtroom during the competition. We shall be starting with this competition by 11:20. Till then, I ask you to please wait here. VTM 2022, I request you to please rename yourself with the team code. Both the VTM 2022s, I request you to please rename yourself as a team code. My lordship, please let me know when to resume.
Yes, we can resume.
Thank you, my lord. BTM 01 and 02, I request you to start with your case. Prosecution goes first.
Your Lordship, I'm representing team VTM01. The council would like to seek permission to commence the court proceedings. We are representing the complainant.
Yes,
Your Lordship.
proceed.
So, Your Lordship, the council would like to make the court aware of the facts. So should I commence with the facts?
Yes.
Your Lordship, in the year 2020, Rampal and Surekha, along with their daughter Komal, from Basti moved to the state of Mumbai, and they resided in Chawl number 32 in Indranagar Mohalla. Then they came here for better employment, and Rampal soon gained the employment opportunity in New Trends Garment Store. It was merely 2 kilometers from his house. Rampal left behind his family and his younger brother Arun in Basti. He would call them regularly and maintain a close relationship with them, and take care of them from a distance. Then Surekha, a beautiful and intelligent woman, soon started taking tuitions in the Mohalla, and she also tutored son of accused number 2, Mohan Prakash, that is Ved. Ram Singh was the deceased in this case, who was, along with Javed, his colleague, you would go to Surat occasionally to procure merchandise. Occasionally, he would go there, and they also developed close relationship. And Ram Singh would always share his close life matters with the Javed. Lordship, pardon. Soon it was the Rampal would get into his daily life routine, and he would commence with his employment. And Surekha would also be a very good, tutor in this mohalla. She became very famous. She became popular. As she was very charming, she developed close relationship with Mohan. Mohan also confessed his love for the woman, but Surekha refused. Surekha later on said that he's a good man, but she cannot have a relationship with him. She refused the proposal of marriage. Rampal developed a suspicion because she was acting strange. Then he confided in Javed and shared his feelings about Surekha. Then Javed told about the rumors about Surekha which were going on in the society. The mohalla, the shopkeepers, everybody has seen Surekha with Mohan occasionally. One day, on 9th November, Rampal takes half day and goes to his house. He knocks on the door, but Surekha takes 5 minutes to open the door. When she opens the door, he finds that Mohan was accompanying his wife. Shocked to see this, he could not see this, and he went to Javed. They sat in a resto bar, and Rampal commenced with his story of Surekha, and Javed then confirmed that this was maybe it can be a rumor, but he also gave him assurance to speak about the relationship with Surekha. Further, if we see on 9th November, he comes back at night at 10. Javed leaves him at home, and Surekha prepares dinner for him. The statement of fact states that they had dinner and went to sleep. 10 days later, Arun comes to town worried about his brother. Since there was no calls answered from Rampal, neither the wife Surekha. He asks about the phone, then Surekha replies that the phone was broken and it was gone to repair. Then he goes to the shop and asks about his brother. Then Viju, the proprietor, asks him to inquire for this matter with Javed. Javed gives him a hint and tells him that maybe it would be due to this rumors going around with Surekha and Mohan.
2 minutes left.
All right. Soon, this Arun develops more suspicion and he files a police complaint. Police reports a missing complaint, but when the statement is recorded, the Komal daughter of Rampal and Surekha, they say, she says, कि मुझे कुछ नहीं पता. If I tell you, then I would be put in the same place as my father has been put below the bed. So she blutters out everything. And the FIR is registered and the police recovers the body. The council would like to proceed with the issues if the facts are clear.
Yes.
Your Lordship, the first issue that we are taking up is whether the accused number 1 and accused number 2 were involved in a criminal conspiracy. The council humbly submits that the accused number 1, who was a tutor, but along with Mohan, the civil engineer by profession, they were caught in this act while the police recovered the weapon, but that is the butcher's knife, and they also had painkillers, which was used to induce the deceased to sleep, and so that they can commit the crime easily. The postmortem report also says that the accused, the deceased, had slit throat in his mouth. So that butcher knife is relating to that weapon of crime. Then we also submit that the post-mortem report also shows the sleeping state induced. The co-counsel would proceed now.
Yeah, audible?
Yes.
Hello.
Proceed.
My learned counsel has already cleared the fact of the cases regarding the how the Sureka and the Rampal Singh has come to the Mumbai and start his normal life. And onwards, he has also told regarding the how that Mohan Prakash has come into his picture, that he has seen all the story regarding that. And the total fact of the cases and the accused who has been arrested in this case, how it will be circumstantial evidence will prove that. I would like to examination in chief to investigation officer Jayant Pawar. May I request to the honorable court to give me examination chief to Jayant.
Yes.
Jayant
Yes.
Pawar. Jayant Pawar is there. Hello.
Yes.
Mr. Jayant Pawar, as an investigation officer, how would you how will you get the information of this crime has been happened?
Sorry, can you repeat?
Mr. Jayant Prakash, how you will get the information regarding this crime has been happened?
The complainant Arun Singh first filed a missing complaint on 22nd of November.
My second question regarding that, on what evidence basis, circumstantial evidence basis, you have been arrested the accused?
According to the prima facie, when I reached the crime scene, and the evidences I found and the statement of all the witnesses led me here.
Okay. Then, Pawar, have you given the notice to the witnesses to also to record the witness in the police station?
I would request you to repeat.
Have you given the notice to the witnesses to call the record the statement in the police station? Independent witnesses. Have you given the notice to independent witnesses?
No.
Because as per the CRP section 160, it is a mandatory to give the notice to the independent witnesses. My learned counsel already speak regarding the fact of the cases and the statement given by the accused under the CRP section 313 that he is not present in the crime scene. That it is not possible that anyone come in his house and that dispose of the body. It's not possible. So I would like to rectify this, because this type of crimes, heinous crime, to dispose this body to out of his house, it is not possible, because the recovery of the body from Surekha house, not from the other place. So Surekha is the most probably suspect person in this case, and that Mohan Prakash, most of the time Mohan Prakash has been seen by most of the people who are the independent witnesses in this case. So both are liable, because section 34 attract over here, because they both are most of the time has been seen by the independent witnesses. And even though that before this incident has been happened on 9th November, on this day, that Rampal has already speak this illicit relationship between that Surekha and Mohan Prakash to the visual also. So there may be more possibility that both accused number 1 Surekha and that accused number 2 are involved in this case. That's all, That's all my report. I would like to revert to the speaker number 1.
Yes.
Your Lordship, the council would like to call upon witness Javed. Has Javed been made available?
Am I audible?
Yes.
Yes.
Javed, I would like to ask you a question. That what were the rumors which you heard about Surekha and Mohan?
I heard the rumors that Surekha and Mohan Prakash are in an illicit affair.
And from where did you hear these rumors?
From the neighborhood.
And if you could recall the incident when Rampal came to you at the resto bar, when he saw Mohan Prakash in his house and his wife took 5 minutes to open the door. What was the conversation between Rampal and Surekha? Did he mention anything about that?
Nothing as such.
So what was the discussion between you and the deceased at the resto bar?
The deceased, that is Rampal, he was just very stressed and angry, and I was trying to calm him down. That's it.
He would have mentioned something about the incident in any specific.
Nothing as such.
Okay. My third question to you is that what did he reveal when he was intoxicated, or what was his what was the conversation between you and Rampal when he was intoxicated?
All that I can recall is Rampal was very stressed and angry, and he just informed me that he saw Surekha and Mohan Prakash together in the home. That's it.
The witness, the council would like to call upon Komal.
Am I audible?
Yes. And what was the relationship of your parents like?
They were pretty good parents.
Sorry, your voice is very low. We are not able to hear you.
They were pretty good parents.
All right. Did you find your father to be upset in recent days?
Yes.
Did he say anything that why was he upset?
No, I couldn't recall, but there was something intense.
And when was the last time you saw your father and with your mother?
The time we ate our dinner.
They couldn't recollect that.
the time I saw the incident was before we had dinner together.
And what were they doing at that time?
We all were eating.
All right. The council would like to proceed with the prayers if the court may permit.
Yes.
Your Lordship, in the matter of the this incidents, the evidences are being corroborated by the weapon and the tiles and all the evidence which only relate to these accused. Hence, we pray the court to give them a punishment of life imprisonment under the sections 302, 324, 34, and 201. The council rests its case.
Next.
This is Council BTM02. Council solicits permission to begin.
Yes, please.
Council solicits permission to address the court collectively as Lordship.
Proceed.
Warm greetings to your Lordship. May I please the Honorable Court? This is Council appearing on behalf of the respondent in the instant case of Surekha, State versus Surekha and another. Would your Lordship appreciate a brief perusal of the facts of the case in hand?
Yes.
Much obliged. Rampal and Surekha migrated to Mumbai city along with daughter Komal for better economic prospects. Surekha started taking tuitions to supplement the income of the house. Mohan Prakash, a civil engineer, and the neighbor of the Surekha gradually started developing a close relationship. On 9th November 2021, Rampal came home early in the evening. He saw Mohan in his house. He got angry and left his house. He called Javed and went to the restaurant. Javed dropped him back home at 10 p.m. Accused number 1 went to purchase certain items from the shop nearby. Arun came to Mumbai city on 19th November as he could not contact his brother and sister-in-law since the 8th of November 2021. When Arun asked about the whereabouts of his brother, he stated that he had gone to Surat for business purposes. After not receiving the satisfactory answer, he went to inquire about the whereabouts of Biju and Javed. Javed told Arun about the entire incident. Arun thereafter went to Vadar police station to file a missing report on 22nd November 2021. On 24th November, the investigating officer took the statement of the accused number 1 and 2. And thereafter, Komal said that she doesn't know anything. Her mother will bury under the bed just like she did her father. The investigating officer went to the house and recovered 3 gunny bags, which had blood-stained dismembered parts of human body, butcher's knife, gunny bag, used tile box, and construction tools. Thereafter, the accused were charged under section 302, 324, 34, and 201 of IPC. If the facts are clear, Your Lordship, the Council seeks permission to proceed with the issues in hand.
Yes, proceed.
Much obliged. In the instant case, Your Lordship, the petitioner would be handling 2 main issues of law to substantiate the case, of which issue number 1.A and 1.B would be handled by Council 1, and issue number 1.C, 1.D, and 2 would be handled by my co-counsel. The Council seeks permission to proceed with issue number 1.
Yes.
Much obliged, Your Lordship. Issue 1. Whether the accused is guilty under section 302 of IPC. Your Lordship, section 302 deals with the punishment of murder, and section 300 deals with the definition of murder. Your Lordship, in the case of Prashant Kumar versus State of Bihar, the accused was acquitted as no fingerprint analysis of the weapon was conducted. In the present case, Your Lordship, there was no fingerprint analysis conducted. Hence, the present accused is acquitted. In
You are not audible, counsel.
There's a problem with your internet connection, counsel. VTM02.
Just
Your Lordship, can you use speaker 2's phone?
Yes.
Your Lordship, am I audible now?
Yeah, just switch off one of the devices because there's an echo sound.
Yes, Your Lordship. Is it clear now?
Yes.
Hello.
Yes. Clear.
Sorry for the inconvenience. Your Lordship, the second main thing, the investigating officer failed to conduct a chemical analysis of the blood found on the butcher's knife, which makes it difficult to conclude whether the same weapon was used. Your Lordship, the investigating officer has failed to take the statement of the two main witnesses. The informant number 2, who was a karate teacher of Komal, states that accused number 1 used to come to drop her and stay till she would complete it. She would not leave Komal alone during her classes. Informant number 3, a news reporter, states that she had seen a man and a woman entering the house of accused number 1 with some equipment to dig and drill and some bags. There used to be digging and drilling work going for almost 2 hours daily since past few days, Your Lordship. This proves that the offense has not committed by accused number 1 and 2. Your Lordship, the investigating officer also failed to show the face of the deceased to accused number 1. Your Lordship, the identification of the body is an important element to prove a case. There was no DNA test which took place to confirm whether it was the same deceased or not. Your Lordship, the most important aspect of this case is the post-mortem report cannot be relied on as it states it is contradictory. On one hand, it states that there was full rigor mortis, and on the other hand, it states that the body had started decomposing. According to NCBI, full rigor mortis occurs between 1 to 6 hours of death and lasts up to 36 to 48 hours. Your Lordship, the investigating officer failed to conduct the test of schizophrenia and has concealed an important evidence. If Your Lordship is satisfied with the current issue, the Council seeks permission to proceed with the next issue.
Yes.
Much obliged. Whether the accused are guilty under Section 324 of IPC. Your Lordship, Section 324 talks about voluntary causing hurt with a dangerous weapon. It does not come into picture only as the offense has not been committed by the said accused, as stated by informant number 2 and 3. It was someone else who has committed the offense and not accused number 1 and 2. Hence, both the accused must be acquitted under Section 302 and 324 of IPC. Your Lordship, Council 2 would be handling the next issue.
Yes.
Am I audible?
Yes.
May it please this honorable court, this is counsel number 2 on behalf of the respondent. The counsel seeks permission to address the court as your lordship.
Yeah. Yes.
Much obliged. The counsel seeks permission to begin with the issues.
Yeah.
Much
Proceed.
obliged. Issue 1.c is whether the accused is guilty under Section 201 of IPC. Your Lordship, Section 201 of IPC deals with causing disappearance of evidence of offense or giving false information to screen offenders. Your Lordship, conviction for charges under Section 302 and Section 201 can be given only after it is proved that the main offense, that is Section 302, has occurred. In the present case, it has not been conclusively proved as of yet that accused number 1 and 2 have committed the offense. Thus, the question of hiding the evidence does not arise at all. Your Lordship, as stated by informant number 2 and 3 earlier in the previous issue, the offense has been committed by some other person, and it is not the accused number 1 and 2 who have committed the murder. due to which the question of 201 does not come into picture. Your Lordship, in Surendranath Mohan P. was the state of Orissa, and in Palvinder Kaur case, it was stated that the prosecution must prove two premises. First, that the offence has been committed, and second, they have the reason to believe that the offence has been committed. Your Lordship, in the present case, the offence has occurred, but it has not been committed by accused number 1 and 2. Hence, the accused number 1 and 2 shall be acquitted under section 201 of IQAC. If your Lordship is satisfied with the present issue, the Council seeks permission to proceed with the next issue.
Proceed.
Much obliged. Issue 1.d is whether the accused is guilty under section 34 of IQAC. Your Lordship, section 34 deals with acts done by several persons in furtherance of common intention. In the case of Pandurang versus State of Hyderabad, Mrinal Das versus State of Tripura, and State versus Babulal, it was held that to attract the applicability of the section, the prosecution must establish a common intention.
Some network issue? Can't hear you.
Yes, Your Lordship.
Yes, some network issue was there. I think couldn't hear a part of you.
Am I audible right now? Hello.
Yes, you are audible. Continue.
Yes, Your Lordship. In those cases, it was held that to attract the applicability of this section, it must be established that a common intention and that there was some pre-arranged plan. In the present case, Your Lordship, there was no common intention and there did not exist any pre-arranged plan, as it has been stated by informant number 2 and 3 previously. Your Lordship, accused number 1 clearly stated in the fact sheet that she was against second marriage and had even told the deceased that they were just friends and had a health relation. Hence, the accused number 1 and 2 cannot be convicted under section 34 of IQAC. If Your Lordship is satisfied with the present issue, the Council seeks permission to proceed with the final issue.
Continue.
Much obliged. The final issue is whether the statement of an 11-year-old girl can be relied on. Does it have any evidentiary value? Your Lordship, section 118 of the Indian Evidence Act deals with who may testify. It has been clearly stated that in this section, a person of a tender age cannot testify. Your Lordship, according to an American journal, the tender age is up to 13 years. A child of such a tender age cannot be regarded as a credible witness as they are unable to form a distinct viewpoint and are too young to comprehend the question. Timer. If Your Lordship could give a minute so that the Council could close the arguments.
Yes, proceed.
Your Lordship, Komal was 11 years old and that of a tender age, and she was suffering from a mental illness, that is schizophrenia, in which the patient tends to get hallucinations and they tend to lie. And the same scenario is taking place in the current case. Your Lordship, even the Supreme Court has said that a witness gets common sense or they can progress of the questions what they've been asked for after the age of 13. And they cannot be counted as a rational person if they are not 13 years old. And the current scenario, she cannot be relied on. The testimony given by the witness cannot be taken into consideration as she is suffering from a mental illness and they cannot testify. It's not reliable, Your Lordship. Hence, the 11-year-old child witness's testimony cannot be relied on and does not have any evidentiary value. Much obliged. Your Lordship, under section 137 of the Indian Evidence Act, the Council would like to proceed with cross-examination.
Yes.
Your Lordship, the Council would like to cross-examine I.O. Jayant Pawar.
Yes.
Arun came to the police station on 22nd November in the evening, didn't he?
Yes.
Did you inquire with the neighbors regarding the digging and drilling sound?
Yes, as soon as I received the missing complaint, I started the investigation.
Is it true that there was someone else with informant number 1 who came to the police station to file the missing report?
Could you repeat?
Is it true that there were 2 other informants along with the informant number 1?
Yes.
And it would be correct to state that you did not take the statement of the other 2 informants.
Yes.
And it would be correct to state that you did not get the test of schizophrenia done for the daughter.
Yes.
Would it be correct to state that you failed to disclose certain evidences, certain medical reports of the daughter in the court?
No.
How did you conclude that it was the same weapon which was used for murder?
Because there were bloodstains found on the butcher knife.
Is there any fingerprint analysis which you conducted for the weapon which was found on the murder site?
No.
And would it be correct to state that you did not conduct any blood chemical reports to prove the same?
Yes.
No further questions, Your Lordship.
Yes.
Your Lordship, the counsel for the respondent would like to cross-examine prosecution witness number 2, Komal. Much obliged. The accused number 1 states that you have schizophrenia. Is it true that you get hallucinations? Should I repeat?
Yeah.
Yes, please. The accused number 1 states that you have schizophrenia. Is it true that you get hallucinations? Excuse me. Can you please repeat? The accused number 1 states that you have schizophrenia. Is it true that you get hallucinations? Who is accused number 1? Accused number 1 states that you have. Who is accused number 1? Accused number 1 is your mother, Surekha. No, my answer is no. In your statement, you stated that you woke up to the screaming sound. Is it true that it was in the day? Yes. No further questions, Your Lordship. Your Lordship, the counsel would like to cross-examine prosecution witness number 1, Javed Sheikh.
Yes.
Am I audible?
Yes.
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 Mr. Arun shared everything with you, didn't he?
He shared me the information that he did. I cannot say it was full or not.
Earlier, you stated that the deceased had a drink with you in the fact sheet. But later, in your statement, you state that you have no count as to how many drinks did he have. Is it true?
Yes, I agree.
No further questions, Your Lordship. Your Lordship, as stated by investigating officer, there was no fingerprint analysis which had been conducted to see whether it was the same weapon or not. Later, there was no chemical analysis for the blood stains found on the knife. And your lordship, he mentions that he has taken the statement of the neighbors, or he had inquired, but he even failed to take the statement of informant number 1 and 2 for the actual informants who came to the police station to file the missing report. Your lordship, as stated by Komal, the daughter, she states that when she was asked that was it day when she heard the screaming sound and she woke up, she states that it is yes, which shows that it was some hallucinations which she was going through, and her testimony cannot be relied on. And prosecution witness number 1, that is Javed Sheikh, even he mentions that in the fact sheet he states that they had a drink, but then later he changes his statement and says that he has no count as to how many drinks he had, which proves that the case is false and accused number 1 and 2 are not the ones who have committed the murder, and it is some other person as stated by informant number 1, informant number 2 and 3. If your lordship is practicing, yes, your lordship.
The capability of the child to hear the screaming sound, how do you presume it to be hallucination?
Not hallucinations, your lordship, but it was stated that she woke up with a screaming sound, and then she saw accused number 1 and 2 with a knife and putting something in the gunny bag. But your lordship, when she was cross-examined, and it was stated that it was in the night, but as you saw right now, when she was cross-examined, she clearly states that it was day, which is contradictory itself.
Yes, but the question is, when she woke up to a screaming sound, she says, and you say that it is hallucination. How can you presume that?
Your lordship, in schizophrenia, the patients tend to get hallucinations, which they believe to be true, and they do tend to lie. So she might have seen. Yes, your lordship.
You had also asked her an earlier question about the accused number 1. What was your question?
My question was the accused number 1 states that you have schizophrenia. Is it true that you get hallucinations? Yeah. So in that, she said she does not get.
But she said no.
Yes. But
how
later
do you still
on,
presume that she has no?
Yes, your lordship.
So how do you still presume that she has hallucination? Just because she woke up to a screaming sound, just because she gave the version and it does not support you, so you say it is hallucination. How do you defend that?
Your lordships, in schizophrenia, the patients tend to lie. And currently, that is what she has been doing. She said, no, that I do not get hallucinations. And no person would say that, yeah, I get hallucinations and I am guilty. They just tend to put it on someone else.
Maybe she has laid out the facts honestly or truly. How do we come to the point that that was hallucination itself? Any evidence to show that that was hallucination?
Your lordship, we do not have an evidence because the police, firstly, we have an evidence that the mother has stated that she has schizophrenia. Secondly, the investigating officer has failed to take the test or the reports. So there are no.
What is the importance of accused statement in the court?
Can you repeat, your lordship?
What is the importance of accused statement in the court? Or is an accused statement important in the court? To make it simple, can we rely on the accused statement in the court?
Yes, your lordship.
Okay, proceed.
If we can rely on the statements given by the witnesses, then why cannot we rely on the statement given by the accused?
My brother judge will take command of this for explanation.
Statement of accused used to record it under section 313 of the CRPC, and it is mandatory for the presiding officer to put each and every incriminating material to that accused. And if presiding officer failed to do so, it is the benefit of that thing that certain incriminating material which is in the chief examination of the witnesses not put forward with him, and no chance is given to him to give the explanation on that point. So in that scenario, he can take benefit in the appeal and be acquitted. And in other, it is the general law in respect of the accused statement that accused has a choice to keep mum. He can say that I don't want to give answer to this question or any question, but he may get the adverse influence against his case or against the prosecution case. So, statement is can be used for the limited purpose in the criminal trial.
Your concept is clear now?
Yes, Your Lordship.
My question to the defense counsel is, now in the present case, one of the parents is already murdered and another parent is facing the charge of murder. How we can prove before the court that that girl, Omal, is lying that she is schizophrenic?
If Your Lordship could repeat the question.
Now in the present case, out of one parent of the Omal has been murdered, and another is facing the charge of murder for another parent, means her father. Now, both sides, she is facing the problem that if she wanted to save her mother, how you can prove that she is lying before the court that she is schizophrenic to get the benefit to her mother and the accused? Did you understood my question?
Your Lordship, the voice was cracking.
Suppose Komal is lying before the court. Am I audible?
Yes.
Yes.
So how you will prove before the court that to save her mother is lying before the court? To get the benefit of the schizophrenic patient, she deposed before the court that she is suffering from the schizophrenia. How you can prove?
How will you prove that the mother is lying? Is the precise question.
The mother is not lying, Your Lordship. It is Komal who is lying.
Suppose her mother forced her, tutored her that you should tell in this way before the court. The question will be for the prosecution also. First, defense should give the answer.
Yes.
Your Lordship, Komal, it is Komal who tells that her mother told her all this. But you cannot rely on a statement. Then how can you tell that the mother is lying?
The honorable judge asked you, why will she lie against her mother?
Your Lordship, she is suffering from schizophrenia. She might not lie, but they tend to lie, but they do not know that they are telling a lie in the first place.
Okay.
Your Lordship, may I answer the question now?
Yes.
Your Lordship, the counsel submits that she is the lonely child, the single child of those parents, of which one has been murdered in front of her. Now, the counsel had just said that you cannot rely on the statement of a child. I would like to point out to the court on the Evidence Act, section 118, that under whom it testified and the evidence of a child witness. It states that when the evidence can be corroborated, what the deposition has been done by the child witness, it can be relied upon. So Komal told, she specified the location also. Even if she is schizophrenic, how could she make such a guess and have such a hallucination that the location was such specific where the body was found? So this particular statement that she is lying or she is schizophrenic, for first point, there's no medical evidence produced by the defendant in this court that she is schizophrenic or any
Is there a
other.
medical evidence to show that she is mentally stable? Has your IO, investigating officer, stated that she was mentally stable? Has he given any medical document to prove the same?
No,
It
Your
has not.
Lordship. No, Your
It has
Lordship.
not come on record, right?
No, it is not.
Yes, it is on record that she is a schizophrenic patient, right?
Indeed, Your Lordship.
Hallucination could be a part of it. Could be, would be, right?
Indeed.
Now, a question to you, as you had said about the IO giving notices and calling witnesses in your cross to the IO. Is it mandatory for the IO to give notices only for the witnesses whose statements can be recorded by the IO?
No, Your Lordship.
Yes. Because he was there on the spot. If he is on the spot, he can see, he can find for who are the eyewitnesses, correct?
Correct.
Correct? Has your IO tried to find who's the eyewitnesses or who are?
No, Your Lordship, the IO has not found any first-hand eyewitnesses, but the mere fact that the body was found from the accused itself and from the location where the statement of Komal was done. So it indicates that whatever statement Komal is showing, so I will revert back to that first question that
How can Komal's testimony be reliable when she has no medical document to support the fact that at that point of time she was mentally stable?
Your Lordship, the counsel humbly submits under the section 118 of Evidence Act, whenever the testimony of a child witness has been made and the evidence is corroborated, the deposition can be relied upon and it has to be taken into cognizance. So in this case,
what about the child or the person who is mentally unstable?
Mentally instability is not been even proved yet.
Schizophrenic patient, it's a mental illness, it's a mental disorder, which shows a person goes on a feeling. On a feeling means if I feel that you are now in coma, you are very well active, but the feeling of being that you are in coma, I feel you're in coma, you're in coma. The world is seeing you as active, but I'm feeling that way. It's the sickness that plays that way.
Your Lordship, the counsel would like to submit that this is a mental disorder, and even if it is being produced or being linked to Komal, here there was no medical evidence. And first of all, the symptoms of schizophrenia, early stages, does not involve such high extreme stages of psychosis. The psychosis being experienced by Komal of being seeing his father being murdered it's not a psychosis, it's a real fact which she saw, and that's why she was able to point out the body. Even if it was psychosis, she could have made any other statement that his father has gone on bike, or maybe he has fallen off from the roof, or maybe something else. But she precisely made one fact, that his father was seen put under a bed by the mother. So it cannot be an hallucination in such regard and in such extremes.
How can you presume that it cannot be a hallucination? Because when you have taken the chief of this child witness, she has said they were good parents. She has said they had eaten dinner together, all of them. That was the last thing done. And you precisely asked her, I think you asked her that he was stressed and angry. You wanted to know the reason. She could not give any reason for that.
Counsel, your Lordship, the counsel submits here that Komal is a single child. All the love and affection she gets in the city is from her parents. Now, whether she was able to say that her mother is a bad mother, I think that's a very
in her deposition, when you asked her precisely about the incident, she was not able to mention. She said there's nothing to be mentioned. She has not described.
Yes, but the
But she
statement
has
given.
said everything prior to that, very specifically, that they had dinner together.
Correct.
The last thing done was they had dinner together.
Yes. So, Your Lordship,
Her
I would.
parents were good parents. She hasn't said anything about any quarrels between them.
Your Lordship, when the body was found, just prior to that, she has said, "Yeah, I have seen my mother put the father under the bed," and there has been a substantial time passed after that. She would have been,
Again, coming
coached.
to that question, her version, that body was put this way, there was screams or there was anything. But this is a patient of schizophrenia. Schizophrenia, the medical term, if you search for it, you'll get to know hallucination is a part of it. Emotional upheavals are a part of it. Feelings. It's not a normal person. So how do you emphasize so much on the child witness?
Your Lordship, the sole factor relying on the child witness is that wherever she indicated the body is, it was found precisely at that place. A hallucination cannot be at such an extent that it could be at an XYZ place, but it was found at that place where she indicated. Hence, we submit that it could not be an hallucination. It is a real fact that she witnessed. And now she is deviating from that fact. Maybe she is coached from anybody else, but the fact that remains the same, the body was found where she pointed out. Hence, she is the eyewitness and it can be relied upon the Evidence Act section 118.
Good. When you started with, if I may point out one thing, when you started with your submission, you were not as clear. But after handling the questions or getting into the questionnaire and handling, I found you to be more confident and efficient. That's a good point.
Thank you, Your Lordship. Much obliged. Your Lordship, Council would like to seek permission for rebuttal.
Yes.
Your Lordship, the rebuttal for the section 324, which the respondent had said that there is no link or no bloodstains or no fingerprints. The council would like to point out that it is a fact that the weapon was purchased on the same day by Surekha, accused number 1. Second point, that the fingerprints cannot be a mere evidence for prosecuting or making it a evidence, the primary evidence, because it can be easily be, caused by using gloves or some other fingerprints. In the interest of section 34, common intention, they have said that they didn't have common intention, but they did not fail to make any fact that why there was no common intention, while all the witnesses have said that they were seen roaming around and they would have an illicit relationship. There were high suspicions for them, and even the deceased had suspicions that Javed could, say, and he has testified to that fact.
Suspicion cannot take the place of legal proof.
Indeed, Your Lordship, but in this case, the evidence has been corroborated with that for the suspicion. Hence, we submit that the charge is. Your Lordship, moving ahead, that the deposition
The
made
network
by the
issue.
It seems so. Yes. Lordship, can we proceed?
Yes.
In section 201, disappearance of evidence, there were no facts presented by the respondent that why they should not be tried under this section. Disappearance of evidence means that something has been hidden which was used in this crime. They have categorically put the body, dismembered it, and put it under the bed. We fail to understand that why there was no smell or encountered even 15 days after the deceased was put under the bed in the same premises. The only witness were Mohan and the accused Surekha, who had committed this crime, because Mohan, being a civil engineer, all the equipments used in his profession were found there. Butcher's knife, which was used by Surekha, was also found. The painkiller and sleeping pills, which was prescribed on the same day from the doctor just prior to the incident, was also procured on the same day, and it was found in the body of the deceased. Hence, we submit that all the charges are established, and we maintain that the accused be tried under this sections and given a life imprisonment. The counsel read.
Your Lordship, the counsel seeks permission to rebut.
Yes.
As
But
I
the
heard your
there was one counsel who spoke about post-mortem report. Who was the counsel?
speaker number 1.
Is he on board?
Yes, ma'am.
Yes, Your Lordship.
Can we get him to address the court, please?
I would request the VTM02 speaker 2. If the speaker 1 is with you, kindly allow him to sit with you because we are not able to hear his voice.
Yes, counsel, can you hear me?
Lordship,
If there is some difficulty, your colleague can address. Can you hear me?
Your Lordship, yes, I can hear you now.
Yes. You had mentioned the post-mortem report about decomposition and full rigor mortis, right?
Yes, Your Lordship.
Yes. Now, you had questioned the post-mortem reports that it cannot be this way, right?
Yes, Your Lordship.
Why do you feel it cannot be this way?
Your Lordship, at first instance, the post-mortem report is contradictory in itself. The first reason is that the full rigor mortis, and on the other hand, it states that the body has started decomposing, Your Lordship. According to NCBI, full rigor mortis occurs 1 to 6 hours of death and lasts up to 36 to 48 hours of death, Your Lordship. Therefore, it is contradictory. It is very much important to look into this post-mortem report, which is contradictory, Your Lordship.
Yes. Now, for your knowledge, do you know that rigor mortis is a part of decomposition?
Yes, Your Lordship.
There is rigor, ardor, livor mortis. They are parts of decomposition. So it is a part of decomposition. Decomposition is at various stages. Rigor mortis is something which happens first, that the body gets stiffened.
Yes, Your Lordship.
Getting it? So you have questioned the post-mortem report itself. Are you questioning the ability of a medical expert?
No, Your Lordship. No, Your Lordship.
How is it going to help your case?
Yes, Your Lordship. But full rigor mortis and rigor mortis are different, Your Lordship. In this case, there was full rigor mortis, Your Lordship.
Yes, full rigor mortis in your case, right?
Yes, Your Lordship. Yes, Your Lordship.
Then how is it questionable, even if it is full rigor mortis?
Your Lordship, decomposition, it starts from 1 to 6 hours, Your Lordship. It occurs between 1 to 6 hours and it lasts up to 36 to 48 hours, Your Lordship.
Decomposition of myofilaments, a part of the, you can call tissues or anything, myofilaments, decomposition of myofilaments, it starts after 48 hours of full rigor mortis. But decomposition of other parts, decomposition is in parts. And rigor mortis, altar mortis, or livor mortis, they are the parts of decomposition.
Yes, Your Lordship.
You're getting it? So decomposition in itself is a huge process from start to end. The body smelling is also decomposition. The body going into parts and liquidifying is also decomposition. And the insects eating the body, then only bones remaining is also decomposition. It's a huge process.
Yes, Your Lordship.
Yes. So you have questioned the medical expert. How will it help your case?
Yes, Your Lordship. At the first instance, there were tiles in the room where the body was dug under the room. There were tiles upon that. Therefore, the smelling was not that. It is next to impossible when there is concrete and when there are tiles, and in under that there was body, Your Lordship. Decomposition was there, Your Lordship. It is rigor mortis and full rigor mortis are both. It is part of rigor mortis, Your Lordship.
Do you agree that a medical expert is a neutral witness?
Yes, Your Lordship.
Has nothing to do with the emotions of the case.
No,
Or
Your
the
Lordship.
party.
Nothing to. Yes, Your
Correct?
Lordship. Yes, Your Lordship.
So questioning or creating doubts on the observations given by the medical expert or the postmortem report in itself, without corroboration anywhere, how is it going to help your case?
Your Lordship, could you please pardon the question?
Yes. Questioning independently the postmortem report itself, in itself independently, how is it going to help your case? You have not compared it with any other report or anything.
Yes, Your Lordship. Your Lordship, as far as this report, it is very much contradictory in nature, and also, Your Lordship, it has been.
How is it contradictory?
Yes, it will prove that the death did not take place on 9th November itself, Your Lordship.
What element could prove that?
Because it was full rigor mortis, Your Lordship.
Full rigor mortis?
Yes.
How many hours does it take to have full rigor mortis there?
Your Lordship, it takes between 1 to 6 hours of death and lasts up to 36 to 48 hours, Your Lordship.
So how do you put it to defend yourself?
Your Lordship, it has been 16 to 17 days since the death has taken place, Your Lordship.
And it is a dismembered body, right?
Yes, Your Lordship.
Mention that it is a dismembered body. It is not a full body.
Yes, Your Lordship. Yes.
Right.
Yes, Your
Yeah.
Lordship.
Because this doubt was not created on any other witnesses, but on a witness who had nothing to do with the emotions. So I had this question for you.
Grateful for your question, Your Lordship.
Right? Continue.
Your Lordship, I would like to rebut the rebuttal given by a worthy opponent.
Yes.
Your Lordship, the council stated that the fingerprint doesn't make sense, or you cannot only rely on the fingerprint. But there was a case, that is Prashant Kumar Mehta versus State of TR, where the accused Rinki was acquitted, giving her the benefit of doubt that the fingerprints were not taken on the murder weapon. Secondly, Your Lordship, accused number 1 was against second marriage, and thus the common intention part does not come into picture. And as he stated that there were rumors in the chief itself, Your Lordship, rumors cannot be believed. It just creates some doubt, but it has a reasonable doubt due to which they cannot come to the conclusion that accused number 1 and 2 were involved in this offense. Then, Your Lordship, the worthy opponent even mentions that the section 201 did not prove the point of section 201. But Your Lordship, the offense has not been committed. How will the accused number 1 and 2 hide evidence? The accused number 1 and 2 did not even know that they were, not even for instance, the accused number 1 staying in that house did not know that there was a body over there. Because accused number 2...
That is your defense. That the offense is not committed by accused number 1 and 2, how will they hide? That is your defense. It is not committed.
Your Lordship, the investigating officer.
How do you prove that it is not committed? Should be the point.
Yes, Your Lordship. I'll get back to that. Your Lordship, the investigating officer has failed to take the statement of the two important informants who had come along with Arun Singh. One of them was the neighbor who was the news reporter, and he had stated, he stated that he had seen a man and a woman enter the house with some equipments to dig and drill with some gunny bags. And the last time he saw them was just a few days before 24th. He had seen them enter the house, and after that they did not come. And after that, they did not even see Mr. Rampal. Only Mr. Rampal and Komal were there at home. The accused number 1, that is Mrs. Surekha, had gone out for an hour, and that's the very reason why she does not even know that the body is there. The child witness was terrified, and she did not even tell anyone. Her uncle came on 19th, that is Mr. Arun Singh, but she did not tell him anything before 24th. Why? The uncle did not ask her anything before 24th. She gives a statement in the police station. It may be due to someone else's pressure.
You say that the child witness was terrified.
Yes, Your Lordship.
Then?
She could have informed someone, or when her mother came, she could have told her mother. But she assumed that it was her mother and Mohan uncle who killed her father. That's why she didn't even share it with her mother. And when her uncle came, after 5 days, she remembered to inform her uncle that it was her mother and the neighbor, Mr. Mohan, who actually committed the murder. Before that, from the period of 19 to 24th, why did not she tell the informant number 1 about the same? And it is not possible that informant number 1
said that she was terrified.
Yes, Your Lordship.
You said she was terrified.
Yes, even if she was terrified, it did. Already, see, first thing, if she is telling that on 9th, at night she saw her mother and Mohan uncle kill her father. Then from 9 to 19, she had 10 days. She could have asked help. She could have even told her uncle on 19th. Her uncle came on 19th, but she's telling him on 24th. That is 5 days. For 5 days, what did she do? Is it possible that she did not go to the school or her karate class after the event?
No, now, by your own admission, you have said that she was terrified. So it goes hand in hand that if she was terrified, she was unable to speak.
But for 15 days, Your Lordship, 10 to 15 days.
As you said, she was terrified. So we take it she was terrified.
Your Lordship, even if she was terrified of her mother, because her mother, that is what she claims, that her mother would kill her and put her under the bed. But she was not terrified of her uncle. She could have told it to him.
No, when she is terrified, she's terrified. How do you presume she is terrified of this person and not that person when she has not opened her mouth?
Your Lordship, she stays in a mohalla, and it is not possible that she did not
Time
off
for the button.
If Your Lordship could give a minute.
Yeah. Yes.
Your Lordship, she stays in a mohalla, and she is 11-year-old, which makes it impossible to state that she did not know anyone from the mohalla or she had no friends. And even if we assume that she did not have friends or she did not know anyone from the mohalla, she at least went to school. A 11-year-old goes to school, and she even used to go for karate classes. Over there, she could have told someone. She might talk to someone, the sir, the karate teacher. And it was such a big thing. How could she hide it? And someone knowing that such an event has taken place, how can she keep quiet and stay?
Because she was terrified. As you mentioned.
Yes, terrified, but it is to an extent.
Okay, now it is to an extent. Okay. Good.
You wanted
But
to say that her uncle planted her against her mother.
Your Lordship, I do not state that because it has not been proved as of yet. I'm just defending my client, that is accused number 1 and 2, because it has been clearly proved that it was not them who has committed the murder.
Then it should be your stand that it is since there is a unexplainable delay. So her story is afterthought story. At the instance of her uncle, she has told before the court or before the police. It should be your stand, your defense.
Yes, this is a precious guidance. This is a precious guidance for you, counsel. Are you able to hear it?
Sir's volume is actually a little less. Could you repeat it?
It should be your defense that there is a lot of delay in the giving her statement or disclosing the fact of the crime by her mother. So that delay is not explained by the prosecution. So there is a chance that she is afterthought. She is deposing the afterthought story, means concocted witness or tutor witness. It should be your defense, and prosecution should say that she, because of her age, she is of 11 years old only, and she was scared because of the heinous crime and because of the her mother. So she is unable to disclose it immediately. Whenever her uncle give her take her in the confidence, at that time she could
Yes, Lord.
Yes. And second point, counsel, you gave a citation on the point of fingerprints, but the facts of the case here are different. Here, the body is found in your house, that is the accused number 1. Here, the dismembered body is found under your bed. You and only you exclusively have an access to your house. I'm talking about accused number 1, right?
Yes, Your Lordship, but
these are the exceptions. When the accused and only the accused exclusively has the access to his or her own house, the burden of proof shifts from the prosecution to the accused.
Yes, Your Lordship, but as it has been stated, first thing, they stay in a mohalla, and over there, no one actually cares who enters the house because it's very small and they trust each other. Secondly, the informant number 2, informant number 3, who is the neighbor, who is the news reporter and the neighbor of accused number 1, even states that he had seen a man and woman who entered the house, and they used to be digging and drilling work for almost 2 to 3 hours. And at that moment, the accused number 1 was not at home. So she was unaware about all this haphazard which has taken place. And Your Lordship, as it has been proved by, as it has been stated by informant number 2 and 3, that the informant number 2 even stated that the accused number 1 used to stay till the class used to get over, which gives the person who has committed the offense full 3 hours to do what he wanted or she wanted to do. That is digging, drilling, and all the pre-planned arrangement which was required. And when they found the correct moment, they just did it. They just committed the crime.
Okay. Next.
Your Lordship, the counsel would like to rebut on the point that why the daughter was quiet for 3-4 days or 15 days, she mentioned.
Proceed.
Your Lordship, counsel has missed out a very key factor and very key point here, that which was mentioned by Komal, that she was threatened. Threatening to a certain extent that she would be put in the same place where his father was, which is indirectly a death threat. An 11-year-old child who has been threatened to such an extent, obviously, counsel also admitted that she was terrified. So she has adequately proven that the Komal was terrified and she was threatened. That's why she was not able to say until unless she was under the custody of police or in the presence of police where she felt safe and somebody from outside a close family, Arun, had come where she could confide. Hence, the council submits that she was threatened and she was under the threat of death. That's why she was not able to reveal it at that point of time, but she eventually revealed which made out to be true and has been proven in this case. And the evidence also corroborates to accused number 1 and 2. Lordship, the council reads.
Your Lordship, the council would like to answer the part given by co-counsel, by my worthy opponent.
Okay, continue.
Your Lordship, he said that she was threatened and she told it in front of her uncle. So why was that 5-day gap? She could have told it to him on 19th itself when he came, but she waited for 5 days. And as you mentioned that she felt safe over there and she felt safe when her uncle came. Then why wasn't it told? Why wasn't it confessed, or why wasn't it informed that the incident had taken place on so and so date? I had seen my mother and Mohan uncle do the said offense, and I was terrified. That's why I did not tell. But then why that 5 days gap, counsel? And children have a tendency of sharing each and every small thing with the one with whom they are comfortable. And this was a very big thing. How could she not tell this part and wait for 5 days?
The council humbly submits again and repeats the same thing, that she was threatened by her own mother.
And now,
somebody knocks on the door.
Council, speaker 2.
Yes, Your Lordship.
As you said, children have the tendency to share everything with the ones whom they are near to. Now, this was the incident between the near and dear ones. And when a child is terrified, because you yourself had admitted that she was terrified, so this question came up. When a child is terrified, how long and for how much time a child is terrified, or any person, there is no bar or limit that it should be for 24 hours and not after that. Right?
No, Your Lordship, there is no such thing that they should wait for 24 hours or 48 hours. But then when you tell that they share with a near and dear one, and she did share with her uncle, which shows that she was comfortable with him.
After a passage of time.
Yes, but then if she was comfortable with that uncle, then why did she wait for 5 days and then tell that such a thing had happened and there is something which is there, which even puts a doubt on the uncle that the daughter of accused number 1 and deceased might have told him on 19th that I have seen my mother and father do all this. But the uncle did not believe her because she is suffering from schizophrenia and he thought it is just hallucination. It could be anything, but it has been proved that accused number 1 and 2 have come to the not there was no side on their side.
Yes, your network was a problem, and I think the time is up. Extra time has been taken.
Yes, my lord.
Okay. So, anything else? Next.
The council would like to just tell the prayer.
Yeah.
Your Lordship, the accused number 1 and 2 should be acquitted under section 302, 324, 20. Much obliged.
Okay.
Shall we end this session of the moot court?
Yes.
My lord. I request VTM 01 and 02 to leave this meeting. Your results would be declared after the moot court competition. I request VTM 01 researcher also to leave the meeting. Shall we call upon the next team, my lord, or you need a break?
Yes, we can.
We can? Yeah.
If my learned friend won't break.
Ma'am, you are on mute, ma'am.
Let's continue. Call upon the next team.
Okay. Okay.
ते पाठवा Google पे केलं ते.
We have VTM 03 versus VTM 05. I would just like to read out the moot court rules for these teams. We shall be having the quarterfinal round today, that is the 10th of February 2022. For chief and cross respectively. In the 12 minutes, the mooter 1 shall have his or her arguments for 6 minutes, and the mooter 2 shall have his or her arguments for the next 6 minutes. The rebuttal and the sur-rebuttal shall be at the discretion of judges. Marks shall be deducted for the extension of time without the permission of judges. If the permission for rebuttal or sur-rebuttal is granted, the time for rebuttal would be 5 minutes and the time for sur-rebuttal shall be 3 minutes. The participant shall adhere to the black and white formal dress code when present in any moot courtroom during the competition. The participant shall keep their videos on. Any violation of the rules shall lead to deduction of marks. VTM 3 versus 5. The prosecution goes first.
A very good afternoon. Am I audible and visible clearly?
Yes, continue.
May it please the Honorable Court, the counsel will be speaking on behalf of the prosecution. The counsel seeks permission to address the bench as your honors collectively.
Yes.
Much obliged, your honors. Your honors, the counsel seeks permission to move ahead with the contentions of the case if your honors are well versed with the issues and the facts of the case.
Yes.
Much obliged, your honors. Your honors, there are currently 3 issues for the case. The first two issues will be dealt by my co-counsel, counsel number 2, and the third issue will be dealt by counsel number 1. The third issue is whether the accused are guilty of causing disappearance of evidence or giving false information or screening the offender. The counsel humbly states in the affirmative that the accused are guilty of causing disappearance of evidence and giving false information in order to screen the offender. Section 201 of the IPC states the following: whoever, knowing or having reason to believe that an offense has been committed, causes any evidence of the commission of the said offense to disappear with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offense which he knows or believes to be false, shall, if the offense which he knows or believes to be false and to be punished with death, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also be liable to fine. In Sukhram versus the state of Maharashtra, the ingredients to establish the offense under section 201 of the IPC were laid down. They are as follows. The first is committal of an offense. The second is the person charged with the offense under section 201 must have the knowledge or reason to believe that the offense has been committed. The third is the person charged with the said offense should have caused the disappearance of evidence or given wrong information relating to it. And lastly, the act should be done in order to screen the offender from legal punishment. Your Honors, by stating facts and circumstances, the counsel wishes to establish that all these ingredients have been satisfied. For the first ingredient, Mohan and Surekha, both the accused in this case, used to often meet in Rampal's absence. Even on the 9th of November, Mohan was in Rampal and Surekha's house at 5 p.m. It is humbly brought to the attention of the Honorable Bench that 9th of November 2021 was a Tuesday, which is a working day. Mohan usually returned home after work after 7 p.m. in the evening. The question that arises then is, what was Mohan doing at Rampal's residence during his work timings with Rampal's wife in Rampal's absence? Moreover, when Rampal rang the bell multiple times to enter his house, Surekha did not open the door for more than 5 minutes. And when she did, she could not hide the fact about herself and Mohan any longer from her husband. As soon as Rampal left, Surekha went to purchase a few things to prepare for the said crime. She bought the knife, she bought the sleeping pills. They slipped the sleeping pills in the victim's dinner, and as soon as he was out of his senses, Mohan and Surekha completed their task of eliminating the one barrier that lied in their way. Surekha also lied about Rampal going to Surat for purchasing material for the business. Rampal was always accompanied by Javed for work trips, and here even Viju and Javed were unaware about Rampal's whereabouts. Finally, on the daughter's statements, the police investigated the place of residence. The counsel seeks permission just for a couple of minutes to finish the arguments.
Yes.
Much obliged, Your Honor. Therefore, the first ingredient has been satisfied that the offense was committed. The second is that the offenders knew about the commission of the offense. Your Honors, the fact that the accused had made a complete preparation to commit the crime clearly leads us that they had complete knowledge about it. I mean, preparing to buy meat in order to purchase a butcher's knife clearly fits the chain of events that constituted the commission of the said crime. However, in doing so, the accused have missed out a major loophole. Normally, people intending to cook meat purchase meat which is cut from the butcher itself, because it requires a lot of skill and knowledge to understand how to cut it and which part is edible, which part does not have sinew. Therefore, it is seen that the accused had complete knowledge and reason to believe that the crime was committed. The accused had also lied about the whereabouts of the victim in the case. They had also, the accused has also said that she was not aware from where the body has come and how did it come there.
However, the council would humbly like to bring it to the attention of the Honorable Court that the body was found in the accused's home under her own bed, buried under the floor. There is absolutely no way that she was not aware of what was going on in her own place of residence. Therefore, the council humbly submits to the Honorable Bench that they have caused disappearance of evidence and they have also lied about the same. The last condition that requires is that they had done the same to screen the offenders from legal punishment. Your Honors, the victim's body was buried under the bed with the sole purpose of getting away with the act. Your Honors, can I just get 1 minute to finish? Just 1 minute.
Carry on.
Much obliged, Your Honor. No one can think of first committing a murder and then burying the evidence under their own bed. It will be very difficult to even think that a person could go to such an extent. There have been many murder cases in the past where the victim was burnt or thrown away in the water body. Hence, it would be highly unlikely to frame charges against both the accused if the body were not found that day. It can also be determined easily by prosecution witness number 2's statements, where she reiterates that her mother, accused number 1, and along with accused number 2, had knife and gunny bag in their hand, and she said that she will kill her daughter too if she asks more questions and would bury her too, as she did with her husband. Therefore, the council humbly submits before the Honorable Court that the evidence was caused to be disappeared with the sole intention of screening the offender from legal punishment, and hence it is submitted before the Honorable Court that the accused parties have committed the offense of committing disappearance of evidence and giving false information relating to it in order to screen the offenders. Your Honors, that's all from counsel number 1 side. Counsel number 1 seeks permission to allow counsel number 2 to continue with the further contentions.
Yes, continue.
The council seeks permission to address the bench collectively as your lordship.
Yes, granted.
Much obliged. Issue number 1, whether the accused are guilty of committing the offense of committing murder. Section 302 of IPC entails about murder. In the present case, as per the facts of the various events that took place, and also as per the statements of the witnesses, it can be observed that the actions of Surekha and Mohan matches all the constituents of a murder. The essential ingredients of a murder include intention, that there must be mens rea to cause death, knowledge, that the act committed must be with the knowledge that it would cause death, and bodily injury, the bodily harm caused must be with their intent that would likely cause death. It can be easily deduced by the various statements of the witnesses for how close Surekha and Mohan had grown over time. As per the events, Mohan used to give Surekha frequently, and Surekha, despite being married faithfully to Rampal and being well aware about the consequences of accepting such gesture, went ahead for it. In fact, Mohan even confessed his love for Surekha, and Surekha showed her affection to the same. This clearly speaks a lot about their illicit relationship. To add further, Mohan also used to visit Surekha in absence of Rampal, to which Surekha never protested and gladly invited him. Why would a man gift a woman on frequent basis? Why would someone be so generous of one's company unless he had feelings for her? The alleged accused found an excuse in the absence of Rampal and became closer, thereby forming an illicit relationship. But their wishes were short-lived, as Rampal was in the way, and the only manner through which they could have fulfilled their wishes was to ensure that he was out of the picture. The council would like to take a reference of a precedent to support the current contention. In the case of Nazar Singh versus State of Punjab, the lordship states that no husband would make a propaganda of illicit relationship of his wife, especially when he had a minor children. But that it as may be, the very fact that the accused tried to wrongly divert the complainant and police to conceal the reality related to her husband is a good reason to support the story of her illicit relationship with the other accused, which led to a conspiracy between them to murder the husband. The similar relevance can be seen here as well. It is also to be observed that her behavior toward Rampal had changed in the times when she got closer to Mohan. And when she was confronted by Rampal with the rumors, she didn't give any satisfactory or conclusive explanation. They had a clear mens rea of getting Rampal out of the picture when one day he returned home early and found them together. The door was opened after 5 minutes. The repercussion that came after made it evident to them that things were beyond their control and they were caught and something had to be done. To further support this contention, rather than taking efforts to clear the misunderstanding between herself and Rampal, Surekha went out to purchase the necessary items required for murdering Rampal and getting out of the mess. Which sane person would stroll out to purchase groceries and medicines during such a marriage-threatening circumstance? Instead, she made no attempts in defense and planned for such a vicious act. With the intention established, the purchase of butcher's knife, which was indeed the weapon that was found to have been used, it was very evident that Surekha did not just have an intention, but had clear knowledge as well as the mindset to cause bodily harm to Rampal on his return that would eventually cause his death. In another case, Jai Prakash versus Delhi administration, the court defines intention as the intention is the conscious state of mind that plans to act to achieve the desired objective. Various items recovered after investigation, such as the gunny bags, the tiles box, the cement bag being used clearly tells us that she had received help of Mohan. Being a civil engineer, acquiring such materials becomes very easy for him, and as per any common rationale, the dismembering of body parts of Rampal could not have been done by Surekha alone, as it takes a lot of strength to separate human body parts. Another reference of the case in Tanviben versus State of Gujarat, the Honorable Supreme Court held that if the evidence of the murder is reliable, the conviction can be made, even if the motive is not established. In one more case of State of UP versus Lakhan, the court held that the motive is something that is locked up in the mind of the accused, and therefore it is to be adjudged from the circumstantial facts of the case. The same theory can be confirmed with the statement of Surekha and Rampal's daughter, who said in a scared tone that I don't know, if I say something, my mom will bury me under the bed just like how she did to my father. This is another statement that supports and confirms the act of murder and acts as a circumstantial fact. To further invoke Section 34 of IPC along with 302, it must be established that the criminal act was done by more than one person in furtherance of common intention of all. It must therefore be proved that there was common intention on part of several persons to commit a particular crime, and that the crime was actually committed by them in furtherance of that common intention. The fundamental factor here is a pre-arranged plan to execute the plan for the desired result. It was held in the case of Gopinath versus State of UP that the pre-arranged plan can be proved either from conduct or from circumstances or from incriminating facts. In the present case, the objective understanding of the facts and circumstances clearly proves that the accused number 1 and 2 were having an illicit relationship, as much both express their affection and confess their love for each other. The fundamental, again, as mentioned, is that the pre-arranged plan and its further execution has been very well established by the circumstantial evidences. Accused number 1 brought strips of sleeping pills and a butcher's knife before the deceased returned home at night further. As a part of pre-planning to reach their desired result of killing the deceased, she bought meat. This clearly shows her intention to create evidences to prove her innocence. Your Lordship, if I can get 1 minute to conclude my argument and say the prayers.
Okay, right.
Much obliged. Therefore, it is humbly submitted by the prosecution that the prosecution has proved beyond reasonable doubt about the common intention of the accused by bringing on record that the said acts were committed by several persons in furtherance of their common intention. If your Lordship are satisfied with the contention, the counsel seeks permission to move forward with the prayers.
Continue.
Much obliged. In the lights of the arguments advanced, authorities cited, and facts stated, the prosecution humbly submits that this honorable court may graciously adjust to find and hold the accused guilty for commission of offence under section 302 read with section 334. To find and hold that the accused guilty for commission of offence under section 201 and to convict the accused for the said charges and to pass any order that it may deem fit in the interest of justice, equity and good conscience, all of which is most humbly prayed. That is all.
Your Honours, the council humbly requests to call forward the witnesses for the examination in chief.
Yes.
Much obliged, Your Honours. The first witness that we would want to call upon is Mr. Arun Singh. So, witness number 7, Mr. Arun Singh, you there?
Yes, ma'am.
So, could you please state your full name and your occupation?
I, Arun Dilip Singh, and my occupation is I'm a salesman in Panchayat present.
So could
He
you?
is not audible clearly.
Hello.
Yes.
Hello. I and my occupation is salesman in Panchayat present.
So the voice is still cracking.
Voice is not clear. The witness voice
Hello.
is not clear.
Hello.
Yes.
Yes.
I, Arun Dilip Singh, and my occupation is I'm a salesman in Panchayat present.
So how would you describe your relationship with your brother and his wife?
Yeah, of course we are familiar, and he's like my father because he was my elder brother.
So is it okay to say that both of you all were very close?
Yeah, ma'am.
Did you guys talk to each other on daily basis?
Yeah.
Okay, so when was the last time that he called you? Or did you call him? When was the last time you spoke to him?
On 8th November.
On 8th of November. And after that, you could not contact him at all?
Yeah, I was unable to contact him.
Okay. Mr. Arun Singh.
141, you cannot ask leading question while conducting the chief examination.
Apologize for the mistake, your honors. The next witness that we would want to call is Mr. Javed.
Hello.
Yes.
Am I audible?
Yes.
Yes.
Sir, could you please state your name and your occupation?
I am Javed Sheikh, and I am the manager in New Garment Trend Store.
For how many years have you been working at New Garment Trend Store?
Around 15 years.
And how long do you know Rampal?
Around a year.
Okay. How often do you have to go to Surat for your work trips?
It used to be like around 3 times a year.
3 times a year. And how long is the duration of the trip? Can you please give us the information?
It would take around 1 month.
1 entire month?
Sometimes it would be 20 days, sometimes it would be 1 month, sometimes it would be 1 month and a half.
Okay, and during that time, did you contact your family? Were your families able to contact you?
Of course, yes.
Okay. Was there a moment of time when you or Rampal had to go alone, not accompanying each other?
Since I knew Rampal, no.
Okay. Can you please narrate what happened on the 9th of November 2021?
Yes, so Rampal called me to meet in a resto bar at 7:30 p.m. When I met him, he was quite stressed and angry because he said that he saw Surekha and Mohan Prakash in his house. And we had a couple of drinks, and as he was not in a good mental state, I left him at his place at 10 p.m. where Surekha was waiting for him.
After that, were you able to establish any contact with him?
No.
Okay, so that's all. Your Honor, the next witness that we would like to call upon is Komal.
Am I audible?
Yes. Witness, would you please state your entire name, your whole name, and your age?
Komal Rampal Singh, 11 years old.
Witness, you're not clearly audible.
Komal Rampal Singh, 11 years old.
Okay. Komal, where were you on the 9th of November?
Home.
The entire day?
No, I had my school also and classes and home.
Okay. Komal, can you provide us any background, any medical background that you had?
Please wait a minute. Komal?
I don't know. Yes.
Komal, do you know the meaning of oath?
Meaning of?
Oath, taking oath. Do you understand?
No.
Being 11 years of age, we should ask witness whether he or she understood the meaning of taking oath. And then only we can start with the child witness. Okay,
Your Honor,
proceed.
Your Honor, with your permission, I would like to rectify myself and begin.
Okay, proceed further.
Okay, much obliged.
Just for academic knowledge, I am telling.
We're very grateful for your input, Your Honor. Komal, can you narrate? Komal, can you narrate anything in specific about your medical background?
I don't know.
Okay, that's all. The next witness that we would like to call upon is investigating officer.
Hello, am I audible?
Yes, sir. So can you please state your full name and your occupation?
Investigation Officer Jayant Pawar.
So I just have one question for you. Was the evidence found exactly where witness number two stated that the evidence would be found?
Yes.
Okay, that's all from our side. Thank you, sir. Your Honors, by asking these questions, the council seeks to establish that Arun had spoken to his brother on the 8th, but could not contact him further. However, Rampal, the victim, had called up Javed on the 9th of November when he called him to the resto bar. This shows that the statement that the accused had passed, that his phone is old and is spoiled and it does not work, is absolutely and completely false, as it was working even on the 9th of November. As per Javed's statements, they used to also contact their family members, and therefore the council humbly submits that the accused in this case have provided complete false information and have caused disappearance of evidence. That's all from council number 1 side, Your Honors.
Is VTM 03 done?
We have examination in chief by my co-counsel.
Yeah, please go ahead.
The council would like to call upon Arun.
Yes. Yes.
Can you please state your name and occupation?
I, Arun Dilip Singh, and my occupation is I'm a salesman in Panchayat present.
Okay. I just have one question. Can you describe the relationship between you and your family before and after when you returned and asked about Rampal?
Please, can you repeat it?
Can you describe the relationship between you and Surekha, or how was Surekha's behavior with you before and after when you came to question about Rampal?
Yeah, we are familiar and our relation with Sureka was pretty good. And when I reached at Mumbai on 19th November, so I just inquired about my brother from Sureka, that where his phone and all that.
So during that moment when you were asking her, or during the days when you were trying to find Rampal, how was her behavior with you? Was it the same or was there some difference?
She was scared.
But in general, her behavior towards you, was it hostile or was it the same?
It was same, but due to the facial expression, I I came to know that she was scared and afraid.
That will be all. Thank you.
Thank you.
The council would now like to call upon Kashinath.
Am I audible?
Yes, you're audible. Can you please state your name and occupation?
My name is Kashinath, 51 years old. I'm biomedical owner.
Okay. Can you tell me that how often did Surekha visit your medical shop?
Quite often. Quite often.
And on the said day, on 8th of November, where did she visit your shop in the evening?
Yes.
Okay. And the prescription which she had handed over to you, in whose name was that prescription?
Dr. Sudarshan Naik.
Yeah, but it was prescribed to whom? Like, was it prescribed to Surekha or was it prescribed to someone else?
Surekha.
Okay. And last question. When Surekha visited you, what was her mood? Like, what can you see from her mood or through her behavior? How was it?
Normal.
Okay, that will be all. That is all, your lordship, from prosecutions.
Okay, defense may proceed now.
Honorable Court, I am the counsel of accused side. If the Honorable Court is well versed with the facts of the case, the counsel for the accused would like to proceed with the issues and arguments.
Yes, proceed.
Much obliged. The accused number 1, that is Surekha Singh, and accused number 2, Mohan Prakash, both being very educated and shared a good bond of healthy relationship of friendship with each other. Victim Rampal Singh misunderstood the healthy relationship of friendship of accused number 1 and accused number 2. Secondly, I want to add, accused number 1 is beautiful and intelligent female, and she was well aware about the financial status of her family. She was also aware that Rampal Singh used to do extra work on weekends to earn some extra money. So to help Rampal, she started to take home tuitions of Hindi and math subject. This shows that she is very concerned about her family and she loves and takes care of her family. Thirdly, that the accused number 1 and victim together were making reasonable progress financially because they both were working together. And because of their progress in finance, the neighbors were jealous of their financial progress and started to make rumors about the healthy relationship of friendship of accused number 1 and accused number 2 into an extramarital affair. The prosecution witness number 2, that is Komal, daughter of victim and accused number 1, statement is not firm in exhibit, sir, which demonstrates her medical issue of schizophrenia. Schizophrenia, I just want to give a short explanation on this. Like it's a kind of problem where a person is suffering from this problem, get confused between the assumption and the reality. That the victim used to travel very often with the petitioner witness number, prosecution witness number 1, that is Javed Sheikh, to Surat for purchasing the merchandise for companies. Accused number 1 used to call victim But victim phone is not reachable as victim phone was an old model and had battery problem too. Accused number 1 was not worried about victim because she was very confident on prosecution witness number 1, that is Javed Sheikh, that he will take care of Rampal very well. Sir, we wanted to make in your notice that the exhibits presented in honorable court are incomplete as we can describe. The exhibits A, that is FIR, under section 154 CRPC, FIR number 206/21, dated 24th November 2021, stating that Surekha Singh, that is accused number 1, and Mohan Prakash, accused number 2, for the murder of Rampal Singh, the victim, by the Ayo Jayant Pawar. And Exhibit B, the post-mortem report, dated 25th November 2021 by SI Hardik P and Dr. Ajay Matre, senior autopsy and forensic, stated death caused due to throat slit. In both exhibits, there are no specification that butcher knife is used for throat slit, and there is no blood sample testing report for the blood which was seen on the butcher knife, and there was no fingerprint test evidence as well provided for butcher knife. So the sections which was applied, like as per section 324, voluntarily causing hurt by dangerous weapon or means, as per submitted exhibit, it is not specified that butcher knife was used to slit throat of deceased or used to cut body part of deceased. Neither there is forensic report of fingerprints on butcher knife. Nowadays, sir, butcher knives are easily available in house of non-vegetarian families for cutting meat. 2 minutes left. As per IPC section 34, act done by several persons in furtherance of common intention. As per the exhibit submitted, accused number 1 and accused number 2 were in healthy relationship of friendship, and accused number 1 did not want to break her marriage with victim. So accused number 1 tried to talk and make victim clear that accused number 1 won't talk to accused number 2 if victims don't like it, which shows the victim was accused number 1's priority, then on accused number 2. As per section 302, punishment of murder, as explained above, accused number 1 and accused number 2 should not have been charged under section 3 IPC section 324, section 34 and section 201, and applying section 302 needs strong evidence and proofs to be charged on anyone. That the based on evidence cited above has proved above reasonable doubt that the accused number 1 and accused number 2 are jointly and severally not guilty for the murder on accused number 1. May please the honorable court, further issues would be taken over by my co-colleague.
Yes.
May please the honorable court. May please the honorable court, the councillor would like to proceed with second statement of the issue.
Second statement of the issue.
There is an echo in your sound.
There is a device with you.
Okay, ma'am.
Mute one of the devices. Switch on your video.
My video is on.
Yeah, it's on. Mute one of the devices.
Yeah. Is it okay now?
Yes.
May please the honorable court, the councillor would like to proceed with the second statement of issue.
Yes.
Whether the accused number 1 and accused number 2 are jointly and severally guilty for the offences committed under section 201 of the Indian Penal Code 1860. So it is no, the accused number 1 and accused number 2 are not severely guilty for the offences committed under section 201 of Indian Penal Code 1860. As per IPC section 201, causing discrepancy of evidence of offence or giving false information to a screen offender, whoever knowing and having reason to believe that an offence has been committed, causes any evidence of the commission of that offence to disappear with the intention of screening the offender from a legal punishment.
or with that intention gives any information respecting to the offense which he knows or believes to be false. For this explanation is that there is no proper panchnama with puncher's signature on it, not submitted with the exhibits. How it can be said that evidence stated is not implanted. Hence, evidence, as said, recovered from the accused number 1 and deceased house in under doubt now. Both the accused supplementally plead that with this honorable court that the accused number 1 and accused number 2 have not committed any crime and both are falsely implicated in this case and accusing false charges. If the honorable court is well versed with the issue number 1 of the case of the counsel for the accused, would like to proceed with the third statement of the issue.
Yes.
Much obliged. Whether the prosecution has been able to prove beyond reasonable doubt that the deceased is indeed Mr. Rampal Singh. No, the prosecution has not been able to prove beyond reasonable doubt that the deceased indeed Mr. Rampal Singh. As per the exhibit submitted, recovery report by I.O. Jayant Pawar and postmortem report external examination by Dr. Ajay Mhatre listed below are the findings which creates a doubt whether deceased is Rampal Singh or not. Recovery report states in clothes only deceased shirt was recovered. Postmortem report states external examination report states in clothes white shirt, blue jeans and red sneakers are identified. Body identification report is not submitted and neither it's shown to the accused number 1, that is wife of Rampal Singh. Forensic report fingerprint of accused number 1 and accused number 2 on the recovered evidence is neither identified nor submitted in the exhibits. May please honorable court grant me for concluding my arguments and complete my prayers.
Yes.
Okay. With the evidence report, it clearly shows that there is no exact evidence that proves whether the deceased is Rampal Singh or it's the body of someone else. If the honorable court is well versed with the issues of the case, the counsel for the accused would like to proceed with the prayer.
Yes.
Much obliged. In light of the facts pleaded, issues raised, arguments advanced, and evidences provided before the honorable court, the accused humbly prays that the accused have not committed the heinous actus reus of murdering an innocent adult, and the intention for attempting to murder of an individual is not seen. That the accused had no mens rea behind their action, as both were in a healthy relationship of friendship. That the exhibits submitted against accused are incomplete and not specific for the defames accused in society. That the accused are being parents and without complete investigation, they are accused as murderers. What impact will be on accused children as this will see their parents as murderers only? That this case leads to incomplete investigation, evidence implanting, making innocent as accused for murder leads to defaming their image in this society and ruining accused children's bright future, and hence this honorable court must show leniency to the accused and sentence them to free. As to do justice to the right and to set an example. This honorable court may also pass such suitable orders in the interest of justice as this honorable court may deem fit. The counsel rests for the case.
Okay.
Time out.
Who's next to address?
Do you want to proceed with the cross-examination, VTM 05?
You're on mute, speaker number 2, VTM05.
Okay. May please, Honorable Court, the counsel may proceed with the cross-examination with the prosecution.
Proceed.
I would, the counsel would like to cross-examination prosecution witness 2, that is Komal Rampal Singh.
Am I audible?
Yes, you are. May I proceed?
Yes.
Miss Komal, what is your parents' name and what is your age?
My father's name is Rampal Singh. My mother's name is Surekha Singh. I'm 11 years old.
Okay.
You should be asking counsel. You should be asking one question at a time.
Sorry, ma'am.
These were two questions clubbed in together.
Okay, we'll look into it. When did you, when your dad came home, was Mohan uncle present in your home early evening?
I don't know.
Leading question.
Sorry?
Leading question.
Okay.
Continue.
When you heard screaming sound during day, right?
Pardon?
You heard the screaming sound during day, right?
No, it was at night.
Okay. At that time, was your father present beside you or in the house?
Yes, in the house.
Okay. Ma'am, that's it for witness, petitioner witness number 2. I would like to cross-examine prosecution witness number 1, Javed Sheikh.
Am I audible?
Yes. May I proceed?
Yes.
Mr. Javed Sheikh, on the date 9th November 2021, what were the clothes worn by Mr. Rampal when you met him?
I don't recollect.
Okay, that's it from my side, ma'am. Your Honor. Now my co-counselor will proceed.
May I proceed with the cross? Your Honor. Okay. I'd like to call upon petitioner witness number 7, Ayo Jayant Pawar.
Hello, am I audible?
Yes.
Hello?
Yes.
There is an echo from the witness side.
Can you? Hello, Mr. Jayant Pawar, are you available now?
Yes.
Okay. Mr. Pawar, the council would want to know, like, when you visited at the crime scene for collecting the evidence, have you done the panchanama or not?
Yes. With my charge sheet, there is a recovery report which is attached. Over there, there are sign of 2 punches.
Okay. But Mr. Pawar, you have not attached as an exhibit the Panchnama report.
Hello.
Hello, Mr. Pawar.
Yes.
Along with other exhibits, you have not attached the Panchnama report along with the signatures of the punches.
But there is a recovery report with the signature of the punches.
Okay. When you visited to the crime spot, have you took the photographs or have you called the person to take the photographs of the crime scene?
No.
Okay. Now, from where have you got the Bhuja cement bag?
Under the bed.
Okay, fine. Also, Mr. Pawar, could you just let us know, along with the exhibits, the CDR report of the CDR of Rampal Singh was not attached. Have you tried to find out the last location of Rampal Singh by doing CDR?
Yes.
So why the report was not attached along with other exhibits? Mr. Pawar?
Yes. In
Please
process.
answer.
It is in yes, it is in process.
Okay. Have you took the DNA report of deceased?
No.
Okay. And did you also took the CDR of Javed Sheikh for 9th November 2021?
No.
Okay. And while recording the statement of Komal, was there anyone other present while the female staff in civil uniform? Was she present while recording the statement of Komal Singh, petitioner
Yes.
witness number 2?
Arun
Okay.
Singh was present.
Okay, but was any female police staff in the civil dress was available while recording the
Yes.
statement of Komal
Yes.
in that
Yes.
room?
Yes.
Okay. But in the statement, why the signature of that female police officer signature was not available? Why?
Because I am the investigation officer.
Yes, but while recording the statement of a minor girl, there should be a female police staff available in civil dress, and her signature is mandatory.
I
Have you
signed
took
as an investigation officer.
No
in the
issues.
presence of the uncle Arun Singh.
Time up. Ma'am, honorable court, may I please request you to grant permission for rebuttal to do rebuttal?
Yes.
Your Honors, we humbly request the court to let the prosecution proceed with the rebuttal before the defense.
Yes, proceed.
Much obliged, Your Honors. Your Honors, my learned friend has stated that the victim was accused number one's priority. The question that arises then is why were there traces of zolpidem tartar in the deceased's body, the medicine which was prescribed to his wife? They were not just available in his body, they were available in heavy doses. The same is proved when we recovered the strip of medicines. 6 tablets were missing, 4 were still remaining. The maximum dose of zolpidem tartar that can be given is 10 mg, that is 1 tablet. In this case, it is implied that 6 tablets were given. Next is my learned friend, co-counsel number 2 has counsel number 1. My learned friend, counsel number 1 has questioned the witness statement stating schizophrenia. However, the counsel would humbly like to bring it to the attention of the Honorable Court that it is not schizophrenia, but early stages of schizophrenia. It does not include hallucination. It only includes behavioral changes. Also, if the witness statement is in question, the counsel recollects a case, Kamla Sethi versus the state. It was held that when there is no discrepancy in the evidence given by the witness, the version of such a witness is reliable. Similarly, while examining the investigation officer, we got to know that he found all the evidences at the same place where the witness has stated. Coming to my next point, my learned friend, counsel number 2, had stated about implanted evidence. The question that comes to our mind is how come the accused did not notice the construction tools, the tiling boxes, the broken tiles, the changed tilings in her own house? My learned friend stated that she is a dutiful homemaker. It is every person who, not only a homemaker, a member of the family's person to know what is going on in their own place of residence. It is impossible that the accused did not know what was happening in her own place of residence, in her own bedroom. The fourth point is identification of the body. My learned friend has also questioned the identification of the body, stating that it is not Rampal. However, section number 45 of the Evidence Act clearly states that opinion of an expert is admissible. It is clearly shown in the autopsy report that the body has been identified by the mole on his cheek. My learned friends are trying to create some far-fetched theory and are trying to make accusations of conspiracy. However, they are not even saying who are they conspiring against, who is the conspirator in this particular case. That is all from the prosecution side, Your Honors. And Your Honors, the prosecution, the counsel for the prosecution humbly submits and requests the Honorable Court to consider our case. That's all from our side.
Yes, proceed.
Please,
Defense.
Honorable Court. Okay, ma'am, Honorable Court, I would like to rebuttal all the 3 questions which has been said by the learner friend. As they said, same sleeping pills in a strip, there were 4 tablets left and 6 were consumed. Okay. Now, I would like to put it in notice, how come it was made clear that the pills identity which has been revealed from the deceased body, it was took from the same strip. Whether that strip pills was only used because company manufactures n number of strips, so that only that strip is used for providing tablets from that strips to the deceased, that is not at all clear. Secondly, the learner said how accused did not notice cement bags and other evidences at the crime spot because she is daily staying over there. Ma'am, the IO, Jayant Pawar, they visited at the crime spot. Panchnama report was not clearly or individually as an exhibit was submitted with the puncher's signature. Secondly, while doing the investigation at the crime spot, firstly, a photographer needs to be present over there to click the photos where the evidence has been placed, where it was already at the scratch, where it was already placed, where it was there, and where they have took it from. There was no photographs available. Might be that there is no confirmation the cement bag was at her inside her house only. There is no evidence as that. Thirdly, identification of body. I would like to focus your eye on the postmortem report, Honorable Court. In postmortem report, it is been specified that the body, in external examination, as already explained by my co-colleague, that the body parts, the clothes which were recovered from the body was white shirt, blue jeans, and red sneakers. Okay, and Rampal, any person during night time going to bed, no one will wear red sneakers while sleeping. And secondly, so how, I mean, the identification report, since Surekha, accused number 1, has also said she has been not shown the face of the deceased. She was not clear whether the deceased is her husband or not. Our major concern is like the deceased, he is a Rampal or not. It makes a big question, because during in the evidences record, Ayo Jayant Pawar, they has clearly specified from the body they have recovered only white shirt. Nothing mention of blue jeans and red sneakers. And in postmortem record, they have recovered blue jeans and red sneakers. So it comes to a big doubt whether the deceased is a Rampal or not. And further, the exhibits which has been submitted by the Ayo Jayant Pawar is incomplete as per the cross examination done with Ayo Jayant Pawar. So may I request the honorable court please pass suitable orders in interest of the justice, as this honorable court may deem fair.
Now, counsel, is the identity disputed by the accused number 1 or the brother of the deceased or the daughter of the deceased? Nowhere it is disputed that he is the deceased, right? Is the identity disputed that he is not the same person? He is not Rampal. It is not disputed.
Ma'am, but Miss Surekha, that is accused number 1. She has said like they have not shown her the face. Now how she can tell that the deceased is her husband or not?
His brother, his daughter. His daughter, his daughter was examined on oath, and she was asked a question that when she heard the sound of screaming and she woke up, did she find her father present in the room? She said yes.
Yes.
Right. So that is that is too near to the timing of the incident. What was happening?
Right.
This does not help you. Right.
Yes, ma'am. That's a very strong point. Like when she got up at screaming sound and she said Rampal was present in the house. Then next she said she saw Surekha and Rampal, Surekha and Mohan holding knife and putting something in Gani bag. So if Rampal is present beside her.
In her deposition before the court, she has only mentioned this because she was asked that question. When you woke up with, to a screaming sound, did you see your father present in the room? She said, I saw my father present in the room. Right? Yeah. So
yes, ma'am.
That cannot help your case. Right? And you say no Panchanama was done, but there is a report. No Panchas are there, but there is a report. There are 2 signatures of 2 Panchas. Right?
Yes, ma'am. Along with the charge sheet, they have said in the recovery report, they have took the signature of the Panchas.
So, yes. So, the irregularity, the lacunas of the investigation or the police defaulting in certain things is just a mere irregularity which cannot help your case. You have to give some other strong reasons for it.
Ma'am, as per the evidences and as per the postmortem report, we just came up with the view like the evidences which were collected by Ayo Jayant Pawar and the postmortem. Like if just wanted to make your notice, ma'am, in postmortem report, time of death, it has been stated that about 25 time of death is about 25 days from before the examination. So if postmortem report is done on 25th November and the death is happened, it happens before 25 days from the examination, which means the death should have been happened on 1st November as per the day the body specification which has been provided by postmortem report. So if the death happened on 1st November and Rampal was alive and seen by the other people in Mohalla and company on 9th November, then how can the body be of Rampal Singh?
Now that is not disputed by his brother or daughter or wife, isn't it?
With your honor, with your permission, may I proceed further?
We can just continue. Well, wait a minute. Let me ask a question to this council. Now, council, the items like gunny bag and knife and pills and everything that was purchased, right? That evidence is also there, right?
Can you please repeat?
Yeah. How do you counter the evidence or the allegation that the gunny bags and knife and pills and these things were purchased and used in the crime? How do you defend yourself?
Ma'am, actually, it comes out to the fingerprint statement, like the strips which was been recovered from the crime site, whose fingerprints were there on the strip, it was not specified. And secondly, the same strip tablets were used for used to feel. Used to give deceased to give Rampal, a victim, to fill him asleep. That was also not clearly specified. Thirdly, the butcher knife which was been which was recovered from the crime spot, there was a blood stain of about 8 inches. There is no blood sample report mentioning the blood sample on the butcher knife is of Rampal's only, or it is of accused number 1 Surekha or accused number 2 Mohan Prakash only. There is no clear identification of this. And thirdly, Javed, like as we said, about the evidences, ma'am, we just wanted to clear these things only because there are certain loopholes where it is not clear. Like Surekha and Mohan, they have jointly committed this crime or something, because they are very clear with their concepts. There is about their friendships, and the rumors which were spread all over, that was not accepted. And about the evidences, we majorly want to focus on the evidence, ma'am, because the evidences which has been presented in front of the court is not complete, and it creates a big doubt. And without
Good.
any, I'm sorry for that.
Good defense. One thing to note, counsel, you are for the accused, right?
Yes, ma'am.
Yeah. So, what should be your prayer? You can read it
Our
out.
prayer.
If you have written it, you can read it out.
Thank you so much, ma'am.
You can. What should be your prayer?
Ma'am, it should be that the accused are not guilty and they are not supposed to.
You have an echo, VTM 05 speaker.
There's an echo.
Sorry.
You both are together. You're also a defense counsel.
Yeah, ma'am.
Yeah.
Sure.
So just correct your echo and you can join in.
Yeah.
Just correct
Is it
your
okay
echo.
now?
Yeah. Tell me, what should be the prayer?
The prayer should be that the accused accused have not committed the crime and they are not supposed to be charged under these sections of murder, like 302 with read with 34, and then of evidence act
I would
201.
after submission of one sentence, I would like my brother judge to come in. Sir, the submission of the counsel for the accused was appropriate order may be passed. And the counsel now says, this counsel, what should be the prayer? That they should not be charged. Sir, please come in. What should be the prayer of the counsel?
Your prayer should be that prosecution totally failed to prove their case, therefore accused may be acquitted from all charges. It should be your prayer.
Very important that we are for the accused, that the accused may be acquitted from all charges. Prosecution has failed, may be acquitted. Counsel has said appropriate order may be passed. We should not
from the court to pass appropriate order. You should aware about what you want from the court.
Exactly.
I just wanted to add one thing to your colleague of speaker 1 of VTM 5. Your questions were nice while cross-examining the witness, but you should continue after those answers. Means you have asked to the officer that whether you have collected CDR. He said yes, and then you should prove to him that it was not corroborating to the case of prosecution. Hence, you suppress it from the court or not annexed with the charge sheet. Means from the CDR, it is revealed that he was at some other place, not at the bedroom or at the time of alleged incident. So it should be, circle should be complete. And everyone should remind that while cross-examining the witness, our question should not be open-ending. We should not give chance to the witness to give the explanation, to fill the lacuna. Ask only that question which answer is known to us. So it was my suggestion to all that while cross-examining the witness, we should ask each and every question as a that is leading question while cross-examination. And while we should not ask.
Thank you so much, sir, for the guidance on this. Actually, sir, as you said, yes, ma'am.
Yes, as sir had asked the question to prosecution speaker 1.
Okay.
I continue with questionnaire to her. Yes, you had taken out a very precise, minute details about. It was a Tuesday. That was an interesting research on your part. That it was a Tuesday. He's a civil engineer, and he should be on work. It was a good research, but you fell a bit short of things. A little bit of more research you should have done. That it was 9th of November 2021, and it was a work from home situation due to Corona. What would you like to say on this?
Very grateful for your question, Your Honor. Your Honor, however, 9th of November 2021, it was not that all the offices were closed. Civil engineers, even engineers, are always required to be on site for any work that comes up. Similarly, it is a fact that he used to drop his son over there and he used to pick him up at 7. If the accused themselves are stating that this was their routine, current in the particular scenario, it is contradicting.
Okay. If you say that was not too much of a Corona panic situation or something, but again, counsel, 9th of November was a Diwali week. So there were holidays for working people. So it is natural, and his child was taking tuitions from this lady. So it was natural. It wasn't much of a discrepancy or something that would help the prosecution case.
We are very, very grateful for your question, Your Honor. But Your Honor, the council is not aware on which day, the main day of Diwali.
Can you hear me? Am I audible?
Yes, Your Honor.
Yeah. Continue.
I'm very sorry if I interrupted you.
Continue, please.
Much obliged, Your Honor. Your Honor, the council is not aware on which particular day the main day of Diwali was. However,
no, main day of Diwali was 4th of November, but it is a Diwali week. The week itself goes into a holiday.
Your Honor, not all private offices have holiday for the entire week. People who are lucky get a holiday for the main day, that is Lakshmi Pujan day, maybe till the 3rd day of Diwali.
But it is not in your evidence either. It is not in your evidence. So you cannot take a brownie for you. That's not a brownie point for the prosecution. Secondly, in your cross, because you're asked, as my brother judge said, good questions. But in that, you had asked a question. Was the evidence found exactly where the PW2 stated that the evidence was found?
Yes, Your Honor.
This doesn't make clear any point as to any point or position or location where it is found. IO was before you, and it's a guidance that when IO is before you, you mention the spot of incidence in chief because it is in chief.
Yes, Your Honor.
And one more thing I would like to point out to you, which needs correction ahead of this, as you all will go on experiencing with increasing experience, you will take care of that, is drinking water twice in front of the court without permission is not called for. Right?
Really
Because
apologize for the mistake, Your Honor.
I'm also hungry, but I cannot eat on the dais, right? With the permission of the court, yes, could go on. Yes, we move further now about this. One important question which I had for the defense also, the PW2 said that father was in the house present at night when she heard screaming sound. She has deposed on oath, right? On oath, in the witness box, she has said, father was, when she was asked, when you woke up to the screaming sound, was your father present in the room? She said, yes, father was present in the room. Right?
Yes, ma'am.
Yeah. Now, in this part, there is a discrepancy in this part. There is a discrepancy in her version. She hasn't said it before the police this way. Right? If you see her police statement, what you all had narrated and mentioned, it hasn't come that way, that she woke up to the screaming sound and she has seen her father, something. It is not there. So this is a major discrepancy or major improvisation, which gives a benefit of doubt to the defense. This will help the defense. What do you have to say?
Yes, Your Honor.
Yeah. And PW2, when her statement was being recorded by the police, the signature of the lady police officer might not be there, but the police officer in the witness box told that she was present with her uncle. So he was present there. Right?
Yes, Arun, his uncle was present.
The minor was not alone. So these points are some points which help the defense for acquittal. Right? So that is it.
Ma'am.
Just to give you a guidance on it.
Thank you so much, ma'am, for providing guidance to us on this. And as guided by this, so should we
because
proceed with the
the
prayer?
points, if they are helping the defense, how will it help the prosecution? As prayed by you to give him life sentence, what points do we take out to nail the accused or to fix him?
Your Honor, was the question for the prosecution? You were not heard very clearly.
I said all these points which now have come up, I have told, they help the defense for acquittal. How would it help the prosecution for sentencing him? Your prayer is that award him life sentence. But how would these points help in fixing the accused?
Yes, Your Honor. Your Honor, the counsel would like to take reference again to the facts that are present in the case and the statements that my learned friend has stated. He stated that it could not be the same strip of zolpidem tartar. However, the last person to see the victim was Javed Sheikh. After that, the deceased was found with an overdose of the same medicine, was found where the accused resides. Therefore, all prima facie evidence point out to the fact that the accused have for sure committed the crime, as they even had motive that they were caught red-handed by the husband. Moreover, what incentive did the accused have to go and purchase the butcher's knife on the same day of the crime, just a few hours before the crime. Secondly, my learned friends have stated about the red sneakers. The sneakers can be put up on the body even after the crime has been committed. So therefore, they do not have any weighty evidence that says that the accused have not committed the crime, as all prima facie evidence goes against the accused.
Good submissions.
Much obliged, Your Honor.
Yeah. So we can end it here.
VTM 03 and VTM 05, are you done with your submissions?
Anything for rebuttal by the defense? I think we can end it here.
You are on mute. VTM 05, speaker 1, you are on mute.
Apologies for the same, ma'am. Ma'am, I just wanted to say that as my friend said, that Mohan victim, when he came to house and he caught accused number 1 and accused number 2 in together in different, in not a proper position. But my question is, Rampal visited house and he misunderstood, because the rumors which were going on in the neighbors, and as stated in the fact, Rampal also communicated with Javed on the same. So Javed also said, okay, fine, I have also saw them in the market. So all those rumors were already going on in victim's mind, because of which when he visited home without asking anything, like why Mohan Prakash is in our house, what is he doing, without asking anything, he just left from there. And later when he came back, accused number 2 took the initiative, because being a right, she took the initiative to explain him, to let him know, so that he don't overthink much and don't get stress of the thing which is not in existence. So when he came home at 10 p.m., she tried to communicate with him. She tried to let him know the truth, like what he was doing exactly at the house, why he came, and the things which is going on, the rumors which is going on, everything is false, nothing is true. So just to make him understand, to save her relation, she was trying all those things. This shows that she was very caring for her husband, Rampal, victim, and she can't do, I mean, accused number 1, accused number 2 can't do anything to...
But how about the aspect of finding a body in her house under her bed? Body cut into pieces.
Ma'am,
Read section 106 of the Indian Evidence Act. It's about onus of, because it is within your premises. Onus is upon you to explain how body came at your bedroom.
Sir, actually, in the fact, it was mentioned that they were residing in a mohalla. Mohalla is something like, it's a complete
but they were residing in the house. They were residing in the house, na? House is in the mohalla. They were not residing entirely in the mohalla.
Yes, ma'am. In the house which is in mohalla, and she used to go to taking to drop her daughter for karate classes, which continues for 3 hours. So that would be the moment someone has to, because someone has come and dig the hole under the bed and would have put the deceased body under that. But
yes.
Your Honor, does the counsel for the prosecution have a chance to rebut the same?
You can in very short.
Okay, Your Honor. Your Honor, my learned friend states that the accused was out of her house for 3 hours. However, it is not possible to dig a hole 3 by 4 feet in the span of 3 hours. A similar incident had happened in Dahisar, Mumbai, last June 2021, wherein it took the police 12 hours to recover the body. It was a very similar situation. Therefore, the 3 hours time frame does not exactly match with their contentions. The next point that the council would like to state is that my learned friend already admits that the victim found his wife and accused number 2 in an obscure position. After that, who would be in their senses to wait over there and argue? My learned friend states that his wife was so dutiful that she wanted to console him and to make sure that she will never betray him again or such like that. She should have stopped him then and there.
For a moment, she did not say that he found them in obscure position or some position. She fell short of words of explaining the thing. I was also going to question on that, but she did not express the word, so I held back.
Okay, noted, Your
She
Honor.
never said that he found them in compromising position or in obscure position. She did not. She was trying to find words that not so position, that she said. Means she wants to say not objectionable. Maybe.
Yes, Your Honor, the council is grateful for your inputs. However, Your Honor, the council submits that if she wanted to rectify matters with her husband, she should have done it then and there and not 5 hours afterwards. She should not have gone to prepare for the crime, to buy the meat, to buy the butcher's knife, buy the medicines, etc. So that's what the prosecution is trying to convey.
Ma'am,
Ma'am,
I would
if
like
you
to.
permit.
Ma'am, with your permission,
Yes.
may I give the answer?
Yes. In short.
Yeah, Your Honor, as per my opponent, she should have stopped him then and there. But I would suggest that if she would have stopped Rampal over there then and there, then I don't think Rampal would have agreed to whatever she said. Everything needs time to take it slowly and peacefully. So she waited for the night when he came back, and then she made a good atmosphere at the home by cooking good food, and then they had the talk over the dinner, and then they peacefully went to the sleep, as per the statement of Komal, where she specifies that we had dinner and we went to sleep.
Honorable ma'am, I just want to add a few on my co-colleague's statement.
Yes.
Like as the my learner friend from, sorry, ma'am,
Proceed.
as from the learner, my learner friend from prosecution side, as she said, Surekha, accused number 1, should have stopped Rampal Singh at the same moment and would have tried to explain him. Ma'am, at that moment, since there are certain things going on in his mind, he was not at all in the condition to stopped by anyone, because once he saw Surekha open the door after 5 minutes, he without thinking, without giving a second thought, he just moved immediately from there. And as stated by Javed Sheikh, petitioner witness number 1, that he was in angry mood. So at that situation, he was not at all in a condition anyone can stop him. So that was the thing. He went immediately from there, and so accused number 2, she just tried, okay, fine, when the moment he will come back, I will try to make him understand, because she always thinks of Rampal's good, and she always tried that he should not take any unnecessary
but
tension.
As my brother judge has said that section 106, burden of proving facts, especially within knowledge. That is, when the body is found in her house, how do you defend yourself? Yes, speaker 2.
Your Honor, as per the section 106 that you asked the question, I guess it is the job done by the investigation officer, how the body came there?
Body is found in the house of accused number 1. It is
Yes.
her house. So how do you defend that situation? You cannot put it on the investigating officer. You are answerable. As the burden is on the prosecution in other things, the burden is on the accused to explain, because the house is of the accused exclusively. Without the permission of the accused, no one can enter. Yes. Without the
Ma'am, I would like to
Yes. Tell.
Yes, ma'am.
Proceed.
I'm with you. Yeah, ma'am. Actually, the thing is like, as we said, the body was recovered from that place, and it was as stated in that hole. The body was from 9th till the 24th November, till the body was recovered by I.O. Jayant Pawar. By that time, anybody, because in postmortem report it was stated that it was about to, just a minute, ma'am. In the postmortem report it was mentioned the body was about to rotten, started to rotten or decompose.
Can I have the submission in Marathi or Hindi, whichever language you are very easy with? Marathi?
Hindi, ma'am.
Which language are you comfortable with?
Ma'am, Hindi. Am I audible, ma'am?
तो हिंदी में मुझे सबमिशन दे दो कि बॉडी जो है, यस, हिंदी में मुझे ये सबमिशन दे दो कि ये बॉडी जो एक्यूज नंबर 1 के घर में मिली है, तो
आपका आवाज गया।
Yes.
Am I audible now?
Speaker 1, please continue with your submissions in your comfortable language.
Am I audible?
Yes, now audible.
You are on mute.
Okay.
Yes,
ma'am. Yes, ma'am. आपकी आवाज आ रही है अभी?
हाँ,
Actually,
और मैं हिंदी में सबमिशन चाहती हूँ।
ओके मैम, एक्चुअली ये जो जैसे कि मैंने बोला था कि जब भी आयो जयंत पवार क्राइम स्पॉट पे गए थे रिकवरी के लिए, तो उन्होंने बॉडी रिकवर किया। एंड आपका जो क्वेश्चन था कि वो बॉडी इतने दिनों से वहां पे घर में थी तो उनको पता क्यों नहीं चला। एंड एज पर पोस्टमार्टम रिपोर्ट, जब भी वो बॉडी उनके पास आया तो वो सड़ने के लिए वो स्टार्ट हो गया था, जिसका मतलब ये था कि बॉडी से स्मेल आनी चालू हो जानी चाहिए थी, जबकि बॉडी से स्मेल आ ही नहीं रही थी। मतलब अगर वो घर में लगा पड़ा है तो उसको स्मेल आना चाहिए था, सुरेखा और कोमल दोनों को स्मेल आना चाहिए था। अभी मेरा कहने का मतलब ये है कि इन्होंने जब भी पंचनामा किया और वहां पे जो जो डेटा मिले उसका प्रॉपर एविडेंस ऐसा कुछ उन्होंने बनाया नहीं है। मतलब मेरा क्या मेजर क्वेश्चन है कि जो बॉडी उन लोग को मिली है वो भी रामपाल का है कि नहीं है, वो बड़ा डाउट है। एंड सेकेंडली, ये जो बॉडी उनको क्राइम स्पॉट से मिली है, जस्ट बिकॉज वो प्रॉपर तरीके से एविडेंसेस को कलेक्ट नहीं किया है, बॉडी को कलेक्ट नहीं किया गया है, तो ये भी नहीं बोल सकते कि ये जो बॉडी है वो
रामपाल की है ना?
नहीं, वो बॉडी रामपाल की नहीं है, वो बॉडी किसी और की है। लेकिन वो मैम कोमल ने भी तो अभी तक बताया नहीं था कि कुछ स्मेल आ रहा है या फिर वो बॉडी यहाँ पे ऐसे स्मेल क्यों आ रहा है। मतलब
आपको कहना है कि बॉडी किसी ने प्लांट किया है वहाँ पे, ऐसे आपको कहना है, इसीलिए घर वालों को और नेबर्स को भी उसका कुछ स्मेल आया नहीं, ये आपको कहना है।
सर ये तो हाँ, ये तो कहना ही था, बट मेरा सिर्फ ये था कि कोई आके प्लांट करके गया। वो जो कराटे क्लासेस में 3 घंटे के लिए जाती थी, उस टाइम ड्यूरेशन, क्योंकि वो लगातार दिन भर तो ट्यूशंस लेती थी, वो ये टाइम था जब वो घर से बाहर जाती थी, तो उस टाइम पे आके कोई प्लांट करके गया लेकिन जैसे कि सीमेंट यूज किया गया था, टाइल्स यूज किया गया था, माइट भी उसके वजह से जो स्मेल है वो बाहर नहीं आ पाया और सुरेखा और कोमल को पता ही नहीं चल पाया कि बेड के नीचे ऐसा कुछ किसी को काट के गाड़ा गया है। क्योंकि अगर वो ओपन सिर्फ मिट्टी करके ओपन होता तो माइट भी स्मेल बाहर आती, बट अगर उसको सीमेंट से और ब्रोकन टाइल से पूरा पैक किया है तो माइट स्मेल आने का चांसेस ऑलमोस्ट नील हो जाता है मैम, इसलिए उनको पता नहीं चला।
Ma'am, I would like to add some points to this.
Yes.
म्यूट कर दीजिए ना।
Speaker one, please mute.
Yeah.
Good.
Ma'am,
Good
it was not
submission.
even.
Good submission by the council in Hindi. I'll come to that point later. Bolo, aap bolo.
Ma'am, I would like to add something. It is that it is not even specified that how big, how deep the hole was dug. So, if it is just the upper layer, then it is very easy to hide the body within 3 hours and cover it up. If it is not that deep, and as per the tiles, I think there is not much layer required for the tiles to get layered. So within 3 hours of span, it can be easily buried under that.
Correct.
When yeah.
Correct. Now, prosecution speaker one. Now, telling you why I allowed her to submit in Hindi. Let me change the language. कोर्टाची खाली सेशन्स कोर्टाची शासकीय भाषा मराठी आहे. हा, तुमचं हे कोर्टासमोर, मुंबई कोर्टासमोर तुमचं हे ट्रायल चालू आहे. शासकीय. Are you comfortable with Marathi or Hindi? Should I turn to?
Ma'am, I'm most comfortable with Hindi and English, but Marathi I do understand. I can speak, but I am more comfortable with English and Hindi.
Main language is for arguments, for trials. The main language is not English. Main language is Marathi. Hindi is also allowed, acceptable. आप अगर जाओगे ना बैंड्रा कोर्ट में देखोगे तो आपको पता चला हिंदी में आर्ग्यू करते हैं. सेशंस कोर्ट में आपकी चार्जशीट, माय ब्रदर जज विल एग्री विथ मी, चार्जशीट में मुझे लगता है 60% प्लस तो मराठी में रहता है. शासकीय भाषाच राज्याची ती असते. आप गुजरात में जाओगे तो गुजराती में आर्ग्यू करते हैं. Getting it? And I told her to argue in Hindi because knowledge, good knowledge cannot be rejected because of selection of language. Getting it? वो जब हिंदी में अलाउ किया तो उसके सबमिशंस एकदम विद कॉन्फिडेंस और मोर मैं बोलूं कि बहुत अच्छे लेवल बन गए उसकी. See now, for me, I think in English, so English is very easy for me and I come out with the English thing. अब मैं हिंदी में बोल रही हूँ, वर्नाक्युलर में मैं भी थोड़े डिफिकल्टीज फेस करती हूँ कि क्या लफ्ज डालना है. जब वो आपने वो लफ्ज पकड़ा था कि कोई आपने बोला था ना क्या पोजीशन में, ऑब्सक्योर पोजीशन. हाँ, so these are very fine and very high quality English words that we use within our conversations. लेकिन लैंग्वेज बैरियर होने की वजह से अच्छा नॉलेज रिजेक्ट नहीं किया जा सकता. और जहां आप जिस राज्य में हो वहां पर तो आप देखोगे, व्हेन आई इयर्स बिफोर जब मैंने प्रैक्टिस शुरू की थी तो मुझे खुद को मराठी पढ़नी नहीं आती थी. एंड कैसे करूं क्या करूं, लेकिन वो फॉर्मेट्स में बराबर हम एक्सपर्ट हो जाते हैं. गेटिंग इट? तो इसलिए उसका वो कहना नहीं था जो हम, क्योंकि द मोमेंट she started to say, my brain added that word, compromising position, because our English is good and वो ऐसे आ जाते, ऐसा नहीं, her English is also good, but वो जो words हमें फटाफट आते, वो कभी कभी बहुत इंटेलिजेंट लोग रहते हैं, वो अपनी लैंग्वेज में सोचते हैं.
Yes, absolutely.
While your argument, जो वर्ड उन्होंने बोला नहीं है, वो कह रही थी कि ऐसा नहीं कि ऐसे पोजीशन में है, ऐसा नहीं, ऐसे वो हाथों से भी बता रही थी, मुंह से भी बता रही थी. सो यू कैन नॉट पुट अ वर्ड एंड देन यू कैन नॉट आर्ग्यू कि यही पोजीशन था, जस्ट इन ऑर्डर टू गाइड यू ऑल कि कैसे होता है. बिकॉज आप जब कोर्ट में बाद में जाओगे, आपको तो लैंग्वेज इंग्लिश छोड़ के दूसरे लैंग्वेज में आपको उतरना है. समटाइम्स इट इज प्योर मराठी जहाँ पे बोलना ही पड़ता है उस इसमें. तो ये चीजों का ख्याल रखा जाए. Getting it? We can twist the words, no doubt. We can twist the words. लेकिन सामने वाला जो बोल रहा है, उसको अगर आपने twist कर दिया, तो आप ही के इसमें से उसको points मिल सकते हैं. Getting it?
Yes,
so I think with this we can end on this.
Your Honor, just if I get the permission, just one fact. My
Yes.
learned friend stated, Your Honor, I can try
Can
to
I,
say in Marathi.
can I get the submissions from you in Hindi if it is easy for you?
मी मराठीत पण प्रयत्न करू शकते मॅम.
Sweet. And that which will not hamper your submission. It just Hindi में मैं क्योंकि your English is super fine. इसलिए वो I would like to see कि कोर्टाने सगळं आता मराठी मध्ये घेतलंय, हिंदी मध्ये घेतलंय, तर ते सबमिशन कसे होतात काय? हिंदी would be good for you.
ओके मैम. मैम सबसे पहले तो उन्होंने कहा, मेरे माय लर्नेड फ्रेंड, उन्होंने कहा कि स्मेल वहां से अलग बास आनी चाहिए, बिकॉज वहां पर उसको डिग करके रखा था, वो डीकम्पोज होने वाला था. पर मुझे सिर्फ एक फैक्ट पर ऑनरेबल कोर्ट का ध्यान व्यतीत करना है कि वो रिगोर मोर्टिस के स्टेज पे था, वो प्यूट्रिफैक्शन के स्टेज पर नहीं था. प्यूट्रिफैक्शन के स्टेज पर ही बॉडी डीकम्पोज होती है, उसमें मैगेट्स लगते हैं और उसके बाद ही स्मेल आती है. सेकेंडली, जब वो कंक्रीट के अंदर बरीड था तो उसका डीकम्पोजिशन प्रोसेस स्लो हो जाता है, बिकॉज वो एयर से या कोई भी और ऑर्गेनिज्म से इन कांटेक्ट नहीं होता है. सिमिलरली उन्होंने कहा कि वहां पर जो टाइल्स लगाए थे, जो होल डीप नहीं था, वो 3 फुट बाय 4 फुट का होल था, और टाइल्स लगाए हैं तो सीमेंट गीला होना चाहिए. उन्हें समझ में आना चाहिए कि टाइल्स कब लगे हैं. दूसरा कि सुरेखा के घर में और किसको एक्सेस हो सकता है अपार्ट फ्रॉम सुरेखा एंड हर हस्बैंड, और किसी के पास में वहां जाने की अनुमति नहीं हो सकती है. तो उसे पता होना चाहिए कि उसके घर में क्या हो रहा है. और दरवाजा खोलने की बात जब करते हैं तो मेरी दोस्त ने कहा था कि वो इनअप्रोप्रिएट पोजीशन था, जैसा मैंने परसीव किया, बट आई कैन बी रॉन्ग योर ऑनर. बट 5 मिनट उन्होंने क्यों लगाए दरवाजा खोलने, अगर एवरीथिंग वाज क्लीन?
वो प्रिजम्पशन पे जाएंगे हम. वो अगर आप बोलोगे क्यों लगाए तो प्रिजम्पशन है, लेकिन आपके पहले पॉइंट्स जो है रिगर मोर्टिस और वो बहुत स्ट्रॉन्ग पॉइंट, स्ट्रॉन्ग सबमिशन है आपके. अब इसमें मजा देखिए, जब आप हिंदी में उतर आए तो वो वर्ड्स निकालने के लिए और मिलने के लिए मैं देख रही थी कि यस आपके पास कंटेंट बहुत स्ट्रॉन्ग आ गया आपके दिमाग में, पर हिंदी में उसको, क्योंकि वी थिंक इन इंग्लिश, तो आपने उसको लेकिन आपके सामने व्यतीत करना, उसको वक्त लगा के फिर आपने किया. दैट्स अ वेरी गुड अटेम्प्ट बाय योर साइड. गुड. ये 5 मिनट का जो टाइम स्पेन जो आपने बोला, तो वो प्रिजम्पशन में जाएगा कि वो क्या कर रहे थे, तो उसको क्यों लगा. बट आपके अर्लियर जो पॉइंट्स थे, दे आर स्ट्रॉन्ग पॉइंट्स. गुड फॉर दैट.
थैंक यू.
कैन वी नाउ एंड विद दिस, क्योंकि आपके रिबर्टल अगेन एंड अगेन हो चुके हैं. Yeah. Okay.
I request VTM 03 and VTM 05 to please leave this meeting. Your results should be declared by the end of the moot court competition. You will be intimated in the WhatsApp group.
Thank you so much.
Thank you.
Thank you so much.
Shall we proceed with the next moot competition, or we need a break, ma'am, sir?
My brother judge would tell you.
We take break of 10 minutes.
Yes, sir.
Okay.
Ma'am, your connection was maybe a bit unstable. You were not audible.
My connection?
Yeah, you are not audible, ma'am.
We take a break of 10 minutes. Okay. My brother judge has said. So we continue in 10 minutes.
Okay. Okay, ma'am. Okay. We'll start by 2:45.
Shreya Lal. Shreya Lal. Shreya Lal. Yes, thank you. Tausif Sheikh. Yes, thank you. VTM 08. I request you to please ask your co-counsel to join in immediately.
Yes, ma'am. Just give me 1 second.
Please pass, because the judges have been waiting since the last 10-20 minutes.
Yeah, but I was not been allowed by the host to get in. So I'm trying for last one hour and more.
Yeah, but sir, you will have to rename yourself as your team code, and only then
I
you will be allowed.
renamed, I put up the code, everything was there, but still,
And there
like,
was
it was
another competition going on. There was another Moot competition going on. So hence you were not allowed.
Yeah, fine. So
yeah,
we were told you get in.
Co-counsel.
I'll just ask her. I'll just tell her, just give me 2 seconds.
Yeah.
By then, let me read out the moot court rules to you. We shall be having the quarterfinal round today, that is the 10th of February 2022. The rules for the quarterfinal round are: each team shall be given a time of 20 minutes. Each team shall be given a time of 20 minutes. The bifurcation of 20 minutes would be 12 plus 8 minutes. 12 minutes for argument and 8 minutes for chief and cross respectively. In the 12 minutes, the mooter 1 shall have his or her arguments for 6 minutes and the mooter 2 shall have his or her arguments for the next 6 minutes. The rebuttal and the sur-rebuttal round shall be at the discretion of the judges. Marks shall be deducted for the extension of time without the permission of judges. If the permission for rebuttal or sur-rebuttal is granted, the time for it would be 5 minutes, rebuttal would be for 5 minutes and sur-rebuttal would be for 3 minutes. The participants shall adhere the black and white formal dress code when present in any moot court room during the competition. The participants are requested to keep their videos on during the moot competition. Any violation in the rules will lead to deduction of marks. Thank you. We are good to go. VTM 07 and VTM 08. The prosecution goes first.
With the permission of the chair, can I start?
Yes.
Yes. Yes.
Thank you, my lord. Here we see Surekha, a very well-known tuition teacher in her mohalla, and having a very good background, nice family, happy family. Husband also working very hard at the end of the weekends also to just satisfy or just fulfill the demands of the family. He also goes out on Saturday, Sundays also, which is weekend, and then he works hard and fulfills the demand and try to maintain the family. You just give him the supporting hand. Surekha also she started taking tuitions and she became very popular in the mohalla. Specifically, it is mentioned she was very beautiful and intelligent, educated also. Husband Rampal also was very educated, but later on, as soon as they got Mohan Prakash, a single parent, as soon as he came and his son started taking, Ved Prakash starting taking tuitions from Surekha. They went into and they got attracted to each other. They got into relationship. One day when he comes back, the husband Rampal, early from the duty, he finds Ved Prakash there in the room. Surekha takes 5 to 7 minutes to open the door. So any husband like Rampal, a lower middle class husband, definitely earlier also there were all these talks which they felt as a rumors and which he also took as a rumor. But as soon as he found Ved Prakash in the room with his wife, not also their daughter Komal, 11 years old, she was present there. So he found something fishy already. He was known about the facts which was there at the back of his mind. He just went away from there. When he comes back, he went and sat in a restaurant and bar. Naturally with his friend Javed, very heavily drunk because of this all topics and what he saw personally with his own eyes. And when he comes back, he's again been pacified by his wife. There is nothing. Don't take it wrongly. I will explain you. I will never meet Mohan Prakash again. And next day we find no sign about him. So when the brother comes there, he asks Surekha about that. Surekha, pretending she doesn't know anything, nowhere about them. How this is possible when there is a happy family life, husband every day coming. His boss has sent him to Surat for a merchandise, what regularly goes. When the brother comes back on, whether brother comes in Mumbai on 19th, and he has been told from 9 days, no sign about or no message about or nothing to hear about her husband. Her mobile is also there. She said it has been kept for repairing, 10 to 12 days for the mobile to be repaired. And so then a missing complaint is filed on 22nd of November, where daughter is also present. On the base of complaint, when the IO, from our side, state side, I was investigating, the brother-in-law of Surekha just had a word with the daughter, and she said, if at all, if I speak anything, then my mother said, I will also bury you below the bed, as I did with your father. So I don't think there is anything else to mention, because earlier day also, she went in the market, she got a butcher's
2 minutes
knife,
left.
she got a butcher's knife, sleeping pills, painkillers, all those things. And then from 10 to 19, she says no word about her husband. She could have gone to the shopkeeper, the boss or the employer of Rampal, and asked about his nowheres, why he is not come back from past 9 days. But no sign of that. She was just plain and calm, nothing explained. She did not have an explanation. And when all these things were found, the tiles were found in the house below the bed. And then when they took out, IO investigated. When they took out, they found 3 bags with a dead human body. And definitely it was Rampal. So without any hesitation, without any arguments, my lord, I feel both have to be punished, a lifetime punishment, and whatever the charges and are in which both are booked. So please go along with that. We strongly recommend you not to allow a bail also for both the people, because as soon as they go out, the daughter's life can be in problem, because as she can kill her husband, she can kill the daughter also, whom already she has given a threat. So this is our request, my lord, to not to consider any bail, and definitely with all the evidences, whatever we have got, she's definitely accused, and she and more, because it is not a case of one person who can, like, kill a person and then make 3 pieces of a human body and bury it. So definitely when both were into relationship, so surely with all the evidences, it has been seen that she and Mohan Prakash both are accused in this case, and they are liable for murder. Thank you, my lord.
Time up.
VTM 08, I had requested you to please ask your co-counsel, but we don't see him here. So shall we pass on the turn? Shall we proceed with the...
You please pass on. She will not be able to join. Whatever is there, I have to take up everything. So you can pass on. I have made my arguments. So
you
please
can go ahead with the chief examination with the permission of the bench if you wish to, sir.
No. I'll take a second round. Let the defendant side make his argument. Further, will like to continue.
After the chief of the prosecution, the defense will come into, right?
Yes, my lady. VTM 08, you are requested to take the chief examination, as only after that the defense will have to present their side.
Yes, my lord. Yes, my lord. Just give me 1 second. There is some technical issue. Just one thing. I think in the chief examination part, I need to be much more updated, As this is our first time
You
from
can,
my college.
you can, no, that's no problem. That's no problem. You can just call the witnesses, any of them. There are 7 witnesses. You can just
Yes, yes.
call any of the witnesses. You can just ask them a couple of questions, 2, 3, whatever, and that's it.
Thank you. Thank you, my lord. Thank you for helping me. So the best part to call is Javed, because Javed was very close to Rampal. They used to travel for their garment purpose also. And if at all we examine Javed, if I ask
Correct.
some question to
Correct.
Javed was
Yes,
very
yes.
friendly. So anybody is
Yes, call him.
paying Javed here, ma'am?
Yes, yes, call him.
Okay, so can I please call Javed as a witness here in the courtroom? I will ask permission from my lord to call Javed
Yes.
first.
Yes, yes.
Thank you, my lord. Thank you. Oblige. So, Javed, whenever Javed also has seen so many times Surekha and Mohan Prakash together in the marketplaces, unknown, hiding this fact from Rampal. He thought it was very odd for so many times a person, 2 people meeting in the same marketplace where they have only the relation of a tuition teacher and a single parent. So if at all I ask Javed, when you revealed the facts in front of Rampal, what was the first reaction of Rampal? And when there were
Yeah,
rumors spread,
you can directly
I can
question him.
only play Javed.
Yeah, no, you can call other witnesses also.
VTM 08, please look at the screen of HVPS. You have the witness Javed present over there. You can start your chief examination with.
Okay, Javed, can you be unmute? You're on mute.
Am I audible?
Yeah.
Yes.
Javed is here. Javed?
Yeah, I'm Javed.
Yeah, okay. Sorry. Javed, when you first told about the rumors, or you have seen so many times Surekha and Mohan Prakash in the marketplaces, what was your first reaction? What you felt about them?
First, I just saw Surekha and Mohan Prakash once in garden. And the fact relating to the rumors, I said Rampal about it, and Rampal dismissed it because he believes in Surekha.
So when again Rampal asked you, when he personally saw Mohan Prakash available on 9th of November, when he came back early from his garment showroom, and immediately he called you up and you both were there in restaurant and bar, you were strongly aware that there is something fishy going up between Surekha and Mohan Prakash, which he did not believe earlier, right?
When I met Rampal, I advised him to go and talk to his wife.
You advised him to go, but what was his reaction? Was he not very angry in the sense, or was he not very disturbed, or very much not in a good mental stage when he literally saw Mohan Prakash in his house alone
He
with
was stressed and angry
Surekha?
about it.
He was, pardon please, he was?
He was stressed and angry about it.
Yeah. So what was his reaction? Did he disclose anything what he's going to do with Surekha or something?
No, he did not.
Or is he going to punish her?
No, he did not say anything or as such.
So do you believe that a person like Rampal can do anything and go away? So much time he was so silent there. And when you told him to took up, again you told him to took up very lightly in the restaurant and bar and have a word with Surekha, right? Which I'm not mistaken.
Yes.
So after that, Rampal suddenly going away, found nowhere. And now when you find his body here, what you feel acha, does Rampal had any grievances or any fights earlier or any enemies there outside? Have you recalled from his talks whenever you both met?
Nothing as such, I know.
Okay. So what you feel about this? If at all a person 9th November is going, you are leaving him, you are the last person to see Rampal going into the house, and from 10th he is not there in your shop also. So why don't you came ahead and try to communicate with the family and find out where Rampal is?
You cannot ask this question.
Sorry.
You
Okay.
have to,
So
you
from
have
this,
to get
from
from
this,
the witness about the knowledge that he has about the incident or before the incident.
so what is the relevant,
Why
like,
he has not
I want to
taken
come to
any
the,
action should not be questioned.
okay, ma'am. So what can be questioned? Because see, I also want to know out the facts from Javed as a dearest friend, as a very near one.
My
Javed,
brother judge will take over in this.
okay, fine. Thank you.
How you should address a witness.
Okay,
You should not
thank you.
question.
Okay. I'm really very sorry since this is my first time.
No problem.
I'm
No
trying to
worries.
Apart from the competition, everyone is in the process of the learning. So, being a public prosecutor, you never, you should not ask any leading question. Means as per section 141, 142. Section 141 of the Evidence Act, there is a definition of leading question. Leading question is question which suggests answering that question. And similarly, the answer is in format of yes or no. That is called the leading question. So during the chief examination, we cannot ask, party cannot ask the leading question. So you have to frame the question. Each and every question, was very good questions, but formation should be in different way. Means suppose you can ask to Javed. Javed, tell me from how many days you were knowing to the disease. Thereafter, he will, after his answer, he can form your another question. Then, when you lastly seen him, then after his answer, you can again ask, yeah, yes. After that, when you able to see him, whether he has disclosed anything about his and his wife's relationship between you, between them to you. In such way, you can ask in chief examination.
Sir, just one query. If at all you don't mind, I can ask you.
Only, yes. And you should not ask कि आपको जानकारी थी तो आपने क्यों नहीं एक्शन उठाया? ये नहीं.
नहीं. What I meant, see, as a public prosecutor, I am representing state, right? Also, I am representing the investigation officer, whatever he has done on the ground level work. As a public prosecutor,
you are not representing IO.
Okay,
you are only representing to the state and the victim's family. IO is something different. In many cases, there are examples that IO have done the malafide practice by taking the bribe from the either or side. So your role is only to find to help to the court to find out the truth, not to get the conviction of the accused.
Okay, sir. Because sir, what happens since victim, as normally when I visit so many courts, I see like always the defendant side represent, the lawyer always represent. For example, I am Surekha, so like
Yes, you will see a PP represents the state of Maharashtra. The police works for the state of Maharashtra. Police will give their investigating report and details to the PP. Accordingly, the PP will question or bring out the truth. It is that way.
Okay.
But you will not do the work of the IO. Now you asked him that you are knowing that, you were in knowledge of that fact, then why didn't you take an action? That is what IO does in the police station. तुमको मालूम था, तुमने क्यों नहीं किया, तुमने क्यों नहीं बताया? PP will say, okay, तुमको उसके साथ पहचान कब से थी, आखिरी बार कब मिले थे? Neutral.
Okay, fine. So because I wanted to come to the fact that Javed is the only key person and Komal is the only key person.
Yes,
like just the eyewitness dekha. Sorry, ma'am. Sorry to interrupt.
Yes,
please
witness is the guest of the state.
Okay.
What facts you want, where the defense and the prosecution, they have to give the respect to the witness and whatever the witness tells. Neither can the defense nor the prosecution, they cannot threaten the witness, they cannot question the witness abruptly. Whatever comes out of that, questions are just like, sometimes what you want doesn't come out from the witness.
Yeah.
So it's fine.
Right.
And you have a limited time. So you'll have to call other witnesses. So you limit to some good 2-3 questions like.
Okay,
every
fine.
witness. So you can call other important witnesses.
Yeah. So thanks a lot. Thank you very much. I was not knowing. Okay. I would surely like to call the Ambico Medico owner of that.
Kashinath.
No, sorry.
I think he's
Arun-
Kashinath. Amba
Kashinath,
Medical.
yes. Kashinath.
KW7.
You may proceed.
Yeah.
Witness number 7.
Thank you, madam. So
Am I
Kashinath is
audible?
there. Yeah,
Yes.
yeah. So Kashinath, whatever medicine Surekha used to take from your medical shop, did she anytime took all the medicines on the prescribed by a physician, or directly she used to come to your shop and ask for the medicines?
Yeah. Let me describe you. Zolpidem tartrate. It's a tablet name, which is Surekha. It's a sleeping pills, which prescription by Dr. Sudarshan Naik, and Surekha takes sleeping.
You are not audible. Hello. Are you there, Kashinath?
Some network problem from the witness side.
Yeah. So next witness is Viju, the proprietor of New Trend shop, where Rampal was the
PW3.
employee. Yes. Witness number 3.
I think there's some network issue from the college side.
Because Javed also, with your permission, my lord, can we call a minor? Or since Komal is minor, she can also be called in the witness box for.
Yes, she can be called. Child witness can also be called in the witness box. But first, you have called witness number 3. We will complete that.
Viju, yeah. No, he was not there. I think there was network issue.
There is some network issue at the
Yeah,
college.
sorry, there was a network issue. Can we proceed from the question of Kashinath?
Witness number 3 is called in the box.
Witness number 3. 3 is, yeah, Viju. Viju is there?
Yes.
Yeah. So Viju, as an employer, when you had so much trust on your employee, you did not find him from 10th of November. So what is your normal practice? Usually what you do? Does these people take any permission from you then, or give you any communication when they do have not to come to your job or something, or employee as an employee part, as an employer part?
What is your question?
My question is
short question.
Yeah.
What is your question?
So he was not available after 9th of November at the job. So did you find any facts about, or did you try to find any facts about him, about Rampal?
No, ask him that was he regular on job? Then ask him on 9th of November, after 9th of November, was he there on job? Ask him.
Okay. So yeah, thank you. Thanks a lot, man. So will you tell me, after 9th of November, was Rampal there on the job?
No.
And at the time of whenever he used to come to the job, or whenever he was working with you, how was his behavior, or was he very active and a good employee?
Yeah, he was an active and a good employee.
Okay, fine. So after 10th of November, he was not at all there present.
Yes, After 10th of November.
My last witness, I would also, I have some time, ma'am.
Yes, yes, you can, with the permission of the court.
I would like to call Komal.
Am I audible?
Yes, yes. Since Komal is 11 years, I can come down to that level of how we treat a child, and we can talk, or I should be very straight, sir.
No, simple. You have to have that concern what question you are asking.
Yeah, because that's why. Since she is 11 years old, a child, she immediately she will get, she will not be comfortable in the court, or she will get afraid or something. So
for that, you ask one or two simple questions first to know that she is answering well as to what is her name.
Komal, are you comfortable in the courtroom? Komal, did you see your daddy's body when you woke up from the sleep that night?
This question cannot be asked.
This question cannot be asked. Okay. Because she only revealed, if at all I say anything from my mom said, I will also make you bury you below the bed.
Did you see? Now you asked her, did you see your daddy's body after you woke up? She said no. But this question cannot be asked. It's a leading question.
Cannot be asked. Okay. So in normal stage, ma'am, for a minor, how can we treat a minor? Because major
judge their mental capacity by asking simple questions. My
lord. Yes, my lord.
My brother judge will take over. He has explained once.
Komal, what is name of your school? What you used to like for it? Which is your favorite cartoon? And then you can start to the main point. Now, where is your father? Then she will
that type of question. Like that.
Nice. That he is no more now. Then where he is, when he died, how he come to know. Then she will come to your point that on that day, so and so thing was happened.
Okay.
Now you start.
Thank you, my lord. Thanks a lot. So, Komal, which school are you in?
HVPS.
You see television also, right? Which cartoon do you like? What is your favorite part in the cartoon? Which is the favorite character?
Doraemon.
Wonderful. So every day evening, dad comes home and you also have a chat with him to go with him out, right? So now is your dad there at home?
No.
Okay, you miss your dad? Okay. So please, can you tell me that day what you saw in the house at night when you woke up from your sleep?
That night, my mom cooked for us. We ate, and then I went to sleep. Then I wake up by a screaming sound. I saw my mom with Mohan uncle having a knife, putting something in a gunny bag. And then when I asked, so she threatened me, I shouldn't say anything or she will just take me under the bed where my father is.
So, my lord, it is said in our Indian culture also कि बच्चे कभी झूठ नहीं बोलते. Whatever they see, they always reveal the facts. Whatever they see, they say. So this was my evidence. This was my role, which I'm praying in front of the honorable court to give justice to the victim and the most punishable part on both Surekha and Mohan Prakash. Thank you, my lord.
Yes, defense counsel.
Good afternoon, honorable judges. it is a matter of great pride and honor
Voice,
to
the
be
voice
in
is not
front of
audible.
the honorable. It may please the council likes to refer as
Can't hear
collectively as
you.
your lordship. Am I audible to you?
Not clear.
You are lagging.
Hello.
You are lagging.
Am I audible to you?
You are audible but lagging. Your internet connection is poor, it seems.
VTM 07 speaker 1, please stay still.
Is it okay now?
Yeah. Yes.
Yes, continue.
Yes, if it may please the bench, the council seeks the permission to refer the bench collectively as your lordship.
Yes, continue.
Much obliged. Lordship, the Defense Council presents before this honorable court in the case of the state of Maharashtra versus Sureka and Mohan Prakash. So the council seeks the permission to present the facts of the case before the court.
Continue.
Yes, your lordship. The case is about a married couple, Miss Sureka Singh and Rampal Singh, who used to reside in the Basti village earlier, and soon after that, Mr. Rampal Singh decided to move towards the city to earn to have a better livelihood. So Rampal Singh migrated to the city, uh, and he joined a new garment shop of Mr. Viju, where he worked, and he used to work sometimes on weekends to give a better future for his family. Accordingly, to supplement the income of the family, Mr. Rampal's wife, Miss Sureka, used to give tuitions, and since they were newly started with the tutorship, she got very much famous in the neighborhood house, in the nearby residencies. So one of the neighbor student, Mr. Ved Prakash, was being tutored by her, and the father of Ved Prakash was Mr. Mohan Prakash. So since Sureka was a young and charming, was young, intelligent, and had a charming personality, she got mixed up well, gelled with all the employees, gelled with all the neighbors, and thereafter, even as a tutor, as a teacher and a parent relation between the Sureka and Mohan Prakash, they used to contact each other laterally, which they uh, tried meeting, and Mr. Mohan Prakash tried to uh, explain the affectionate he had for her, and thereafter many people in the society started becoming jealous of their progress, and even some rumors were spread about their relations, and thereafter everything was going okay, and thereafter Mr. Arjun, brother of Mr. Rampal, he came from decided to contact his brother, as he was unable to have word with him, since he was his family member. He had care for him, and since he was not able to connect with him, he tried to visit Mumbai, and upon reaching Mumbai, he asked his brother's wife about the whereabouts of his brother Rampal Singh, to which Sureka replied that that Mr. Rampal oftenly used to visit to Surat, to Saurat, because of his office work, and which somehow seemed unsatisfactory answer to Mr. Arjun. Thereafter, Arjun still waited for few days, and since he was hesitant and was worried about his brother, he tried to file a missing complaint, to lodge a missing complaint in the nearest Vadar police station. And since after
2 minutes left.
even after filing a missing report, there was no news about his brother, so he decided to lodge an FIR. And after getting FIR, he was much more worried, so he tried to contact the place where he used to where his brother used to work. So upon going there, he came to know about Javed, and even Javed used to Javed used to he was his colleague. So he told him about the difficulties Mr. Rampal was going through. So soon he visited even more neighbors, and thereafter, after visiting neighbors, he tried to call them in the police station, and he inquired Komal, the daughter of Rampal, to which she said that uh, her mother would hide her in the bed, just as like she hid her brother. So since the dead body was found, and this was a case of murder, the Rampal, Miss Sureka Singh and Mohan Prakash have been punished under Section 302, 324, and Section 24 and 102 of IPC. And further to this, the council seeks the permission to present issue of the case.
Yes, okay.
Yes, the issue I would be talking about is whether the relation between the Sureka and Mohan was illicit. So to so so I would be explaining about this issue. So the allegation is based on the Mohan and Sureka's relationship. It was not an illicit relationship, because
Time
I
out.
would like to throw the council seeks permission of few minutes to complete my issue part.
Quickly.
Yes, much obliged. So I was talking about the definition of illicit relationship, which clearly speaks any sexual activity between a man and woman who are not married to each other. So, this has been explained under the Section 497 of Indian Penal Code 1860 as adultery. And to fulfill the conditions of adultery, there are few ingredients, of which the first ingredient speaks as a sexual intercourse by a man with a woman who is and who knows a reason has to believe the wife of another man, and also such a sexual intercourse would be without consent or convenience. So to put on the issue part, I would like to call the witness, Miss Pooja.
We do not have Pooja in the list of witnesses. The moot court clarifications provided give you a list of 7 witnesses. Please go through.
Okay, so
there is Pooja PW4.
Ma'am, we have also provided moot court clarifications, wherein
Okay.
we have taken Dr. Ajay Matre and the IO instead of Pooja and Sultan.
Okay.
Okay, so fine. I would like to call the witness Javed Sheikh with the permission of the lordships. Am I audible?
Yes.
Yes, the council seeks the permission to call the witness Javed Sheikh.
Am I audible?
Yes, you are clearly audible. Javed, what I would like to ask you is, how did you know Rampal?
Rampal is my colleague. We work in the same workspace.
Okay, and so since you are his colleague and you used to work at the same workplace, can you please throw some light on the relationship he was a relationship problem he was facing through from his wife and between his wife and Mohan Prakash?
Throughout the tenure I worked with him, I did not see any specific problem that he faced with his wife.
Okay, and since he was since you used to visit with him for Saurat, so did he any time discussed about Mohan Prakash with you?
No, he never discussed Mohan Prakash by himself.
Okay, so as you said by himself, so did you ever asked him upfrontly about him?
Yes, once.
So yes, can you please throw light to what was the discussion and what did he replied in that question?
I once saw Surekha and Mohan Prakash together in a garden, and I also heard numerous rumors about them being together. So I once informed about it to Rampal, and Rampal immediately dismissed it because he says that he believed in his wife.
Yes, Lordship, the a point to be noted, as the witness has said that they just only used to roam somewhere in the garden. So I don't think like just roaming in the garden can be a ground for proving the illicit relationship, as like two people can just even casually roam anywhere, and it can also be a coincidence. So I would also say that just upon the statement of witness that the two people used to roam together, that doesn't mean that they are in illicit relationship. So to proceed with the further issues, I would pass on to my co-counsel to deal with the further issues.
Okay.
Yes. Can I start?
Proceed.
A very good afternoon, Your Lordship. This case is about murder of
Your voice is not clear. Your voice is not clear.
Just a minute.
Hold the mic near you.
Now my voice is clear, ma'am.
Yes.
Okay. So this case is about the murder of deceased Rampal. According to prosecution, accused number one, wife of Rampal, that is Surekha, and accused number two, the neighbor of Singh family, Prakash, Mohan Prakash, killed deceased Rampal. But the defense counsel will prove that respondents are not guilty. According to defense counsel, someone has taken a benefit from rumors of Surekha and Mohan relationship and kill Rampal. To prove this, I will examine a witness of Mohan and Javed and then move towards the issue number 1 and 3.
Yes.
Okay. Can witness number 5, prosecution witness number 5.
I didn't get you. You're going to examine Mohan?
Yes.
Mohan Prakash is the accused and he's not the witness. Hence,
Sorry, not Mohan Prakash. I want to cross-examine Arun, the brother of deceased. Sorry for that.
Okay.
Is he here? Arun?
But I can see 7 witnesses which does not have Arun. The chief is done of Javed and Komal and Viju.
So he's a complainant. Can I examine him?
Yes.
Okay. So Arun?
Yes.
Okay.
Yes.
So Arun, you on which day you come to Mumbai?
I approached Mumbai on 19th November.
Okay. So you stay for 5 days in Mumbai at Indiranagar Mohalla.
Yeah.
So, Komal, did you tell the statement that she made in police station to in between these 5 days?
Sorry, can you elaborate it?
Yeah.
आप लैंग्वेज कन्वीनियंस के लिए आप हिंदी में बोल सकते हो, बिकॉज कोर्ट की ऑफिशियल लैंग्वेज मराठी है, हिंदी भी चल सकती है, एंड इंग्लिश इज नॉट द मेन लैंग्वेज फॉर सेशंस कोर्ट.
ओके, थैंक यू मैम फॉर दैट. सो अरुण जी, आप बताइए कि जो कोमल ने जो स्टेटमेंट दिए, विटनेस स्टेटमेंट की मुझे कुछ नहीं पता, कि नहीं तो मम्मी मुझे भी बेड के नीचे डाल देगी, तो वो आपको इन 5 दिनों में कोमल ने पहले कभी बताया था? 5 दिनों में जो आप 5 दिन वहां पे रुके थे उसके उनके घर पे?
No.
नहीं. तो और आपको ये किसने स्टेटमेंट बताया कि सुरेखा एंड मोहन हैज इलिसिट रिलेशनशिप?
Yeah, Javed Sheikh has told me.
जावेद शेख. एंड आपके ब्रदर कैसे दिखते हैं? वेदर ही हैज एनी आइडेंटिफिकेशन मार्क इन हिज बॉडी जिससे
No,
कुछ
I'm not
आपको
aware about it. No, I'm
कि
not
आपको
aware
पता
about
नहीं है? सो कोर्ट प्लीज नोट दिस. ओके, तो अरुण जी आपका यहाँ पे ठीक है. माय नेक्स्ट विटनेस इज जावेद, प्रोसिक्यूशन विटनेस नंबर 1.
Hello, am I audible?
Yes. So Javed, when you joined the shop, that means how many years you have been working there?
Around 17 years.
17 years. So who goes Surat before Rampal start joining with you?
Before Rampal, I was the only one to go Surat.
Surat, okay. So how much duration of trip of Surat takes? How many days the Surat trip takes?
Can you be more specific about the tenure you are asking about?
The Surat trip, trip, how much days it take, or how much duration it takes, that trip, Surat?
It used to depend, approximately around a month.
Yes, okay. So on 24th November, Arun, Komal and others, they recorded their statements. So on which date you record your statement in police station?
On the same day itself.
24th November. Okay.
Yes.
So why you told Arun that Surekha and Mohan have illicit relationship?
Because I've had heard the rumors about it, and I just made him aware about the rumors.
What rumors you heard?
That Surekha and Mohan Prakash have illicit relationship.
But in any other witnesses don't talk about this. Only you tell Arun that they both have illicit relationship. Other witnesses tell.
You cannot argue with the witness. आप witness के साथ नहीं argue कर सकते. वो arguments आप कोर्ट को बता सकते हैं.
ठीक है मैम. So my next question is for him. What is your salary?
My salary is 50,000 a month.
50.
Yeah, 50.
Okay. So I have one more question that it take means Arun is missing. Rampal is missing from 10th November, and Arun meet you on 22nd November. So in these 12 days, why you not go to check to Rampal's home? Why he's not coming?
Because when I met Rampal on 9th, that is the last day I saw him, I asked him to communicate with his wife about the problems that he had, and that's it. I thought that they would talk about it and get sorted.
No, but
ऐसा क्वेश्चन नहीं पूछना चाहिए. क्वेश्चन ऐसा पूछना चाहिए कि 9 तारीख के बाद क्या आप उससे मिले वापस? आप लास्ट उसको कभी मिले? आप क्यों नहीं मिलने गए, क्या वजह थी उसकी, ये आप इनको नहीं क्वेश्चन कर सकते विटनेस को.
Okay. So whether he taken any action to communicate with Rampal?
Can you please elaborate your question?
In these 12 days, whether you take any action to communicate with Rampal?
No, I did not.
Okay, so it's ma'am, witness is clear. So now I want to come to issue number 1. That is whether prosecution witness number 2, Komal, daughter of deceased, can be eligible as a witness or her statement admissible in the court or not. So according to counsel, Komal cannot stand as a witness and her testimony cannot be valid because she is not competent person to be witness. Komal is suffering from early stage of schizophrenia. Schizophrenia is a term used to determine a mental characterized by abnormalities in the perception or expression of reality. And I think, like a defense counsel thing, the Komal has been provoked and tutored by Arun and Javed to speak statement for proving this. Means Javed and Arun, they provoke Komal to speak that statement, which Komal made in the police station. To prove this, I will narrate some facts.
To prove this, you will have to call her in the witness box. You'll have to cross-examine her. Then you should argue.
Okay. So can I call Komal to the witness box?
Yes.
Okay. Komal?
Yes,
What is your full name?
Komal Singh,
And in which standard you are?
6th standard.
Okay. So who told you? No, not like that. मैम कैन मैं हिंदी में पूछ सकता हूँ इसको?
Yes. मैंने वही कहा है कि कोर्ट की ऑफिशियल लैंग्वेज जो है वो मराठी है, हिंदी चलती है. आप लैंग्वेज के बैरियर में मत रहिए. इंग्लिश इज नॉट इम्पोर्टेंट. हम सेशंस कोर्ट में जाते हैं तो वहाँ मराठी हिंदी में ही मैक्सिमम चलता है. मराठी तो मैक्सिमम.
ठीक है मैम.
तो हिंदी में स्टार्ट कीजिए.
कोमल, आपने इन 5 दिनों में अरुण जी को कुछ बताया कि जो इंसिडेंट हुआ था उसके बारे में?
जी हाँ.
इन 5 दिनों में जैसे 19 नवंबर को अरुण जी आए थे विलेज से मुंबई और वो 24 को एफआईआर रजिस्टर हुआ. तो इन 5 दिनों में आपने कुछ उनको बताया था इंसिडेंट के बारे में?
मुझे डेट याद नहीं है लेकिन मैंने बताया.
आपने 24 नवंबर को पुलिस स्टेशन में उनको वो स्टेटमेंट की जो आपने बोला कि मम्मी मुझे भी मार देगी करके, राइट?
डेट याद नहीं है लेकिन हाँ.
ठीक है मैम. विद दिस आई कंक्लूड विद द विटनेस एंड नाउ आई वांट टू आर्ग्यू.
ओके. और कोई विटनेस बुलाने हैं या आर्गुमेंट करनी है?
नहीं मैम, नेक्स्ट इशू में नेक्स्ट विटनेस को कर सकता हूँ मैम.
ठीक है.
So ma'am, yes ma'am. So Rampal is missing from 10th November. On 19th November, Arun come to Mumbai. On 22nd November, Arun meets Javed. There Javed told him about Sureka and Mohan having illicit relationship. Same day, Arun filed a missing complaint in police station. And on 24th, just a minute. Yes, ma'am. On 24th, while police taking statement of Sureka and Mohan, Arun talked with Komal. Then Komal told him the statement of मुझे कुछ नहीं पता, मम्मी ने जैसे पापा को बेड के नीचे डाला मुझे भी डाल देगी. So Arun came to Mumbai on 19 November and he stayed there for whole 5 days. While that time Komal did not tell about this earlier to Arun, like she said, why she did not say, because she did not know anything about that. And Javed knows about the Komal's health condition, because Javed is a very friendly with Rampal, and they share the family and professional thoughts with each other. So Javed knows about the Komal condition, and when Arun talked to her, he must ask about the Sureka and Mohan relationship to Komal. Then her illness, because of her illness, she must made it in her mind and told the statement that she made in the police station. And next, I want to some case law to this statement. Nirmal Kumar was the state of Uttar Pradesh on 18 February 1992. The Supreme Court stated that the child's evidence should be scrutinized carefully. The testimony of child witness is very likely to taught and should be accepted only after careful consideration because of fear and temptation. The child may testify about things he may not seen. The court must carefully consider whether the child witness is under any teaching influence. And second judgment is Nivrutti Panduranga Kokate and others versus State of Maharashtra. On 19th February 2008, the Supreme Court held that the child witness testimony must be scrutinized to ensure that it was not given under duress or undue influence, and that it must also corroborate other evidence. So with above fact, I stated the Komal mental health condition is not good, and even Arun tries to temper the witness by exchanging word without official record in front of the police or magistrate. So with this, I conclude my issue number 1. If any question is there, the court can ask.
Now, counsel, उसको जो चाइल्ड विटनेस है उसको बॉक्स में लेके आपने ही बताया कि आपने पुलिस के सामने ऐसा बोला है ना?
यस मैम.
तो वो बोली हाँ, है ना? तो अभी आपने वो एडमिशन ले लिया जो कि क्रॉस में नहीं लेना चाहिए. गेटिंग इट?
यस मैम, बट मेरा पॉइंट था कि मैम उसे पहले पता नहीं था. एक्चुअली 24th को उसको बताया गया कि ऐसा ऐसा बोलो करके.
हाँ, आपका पॉइंट वो था, लेकिन आपने वो पॉइंट छोड़ के आपने वो बोला कि आपने पुलिस को बताया ये ऐसा, आपने पुलिस को ये ऐसा ऐसा बताया कि माँ ने ऐसे किया, माँ ऐसा बोला. तो ये प्रोसिक्यूशन का पॉइंट पक्का हो जाता है उधर. ये एडमिशन आपके खिलाफ आ जाता है. ये क्वेश्चन ऐसा नहीं पूछने का है. आपको जो पूछना है वो क्वेश्चन अलग से पूछना है कि उसके चाचा को उसने बोला, तो उसके चाचा को कब बोला, वो आपने अलग से पूछने का.
ओके.
पुलिस के सामने आपने ऐसे बोला, ये बता दिया तो ये फिक्स हो जाता है. मेरे प्रताप जज इस मामले में आपको बताएंगे जो है. सर
जी, आपका क्या सवाल था? मेरा जरा
इनका ऐसे है कि PW2 जो चाइल्ड विटनेस है वो बॉक्स में आई, तो इन्होंने उसको कुछ सवाल पूछा, उसके बाद दूसरा सवाल ये पूछा, आपने पुलिस के सामने ऐसे बताया कि तुझे भी पापा की जगह पे डाल देंगे. तो हाँ बोली वो. तो मैंने कहा कि ये जो सवाल है ये ऐसा नहीं पूछना चाहिए क्योंकि ये आपके खिलाफ है. एडमिशन आ गया. तो उनका ये क्या सवाल था काउंसिल का कि नहीं, मैं आपका क्या सवाल था, क्या पूछना चाहते थे, मतलब आप क्या बाहर लाना चाहते?
मैम मैं उसको पूछना चाहता था कि इन 5 दिनों में आपने किसी को कुछ कहा, क्योंकि शी इज अ पेशेंट ऑफ
तो
शिजोफ्रेनिया।
वो सवाल कैसा फॉर्म होना चाहिए वो आपको मेरे ब्रदर जज बताएंगे।
ओके,
ये ऐसा है, इसमें दो एंगल है। एक तो आपका जो एक पॉइंट 5 दिन तक किसी को क्यों बताया नहीं,
यस,
तो उस पे आपको फोकस देना है। 5 दिन तक बताया नहीं इसका मतलब ऐसा कुछ उसने बोला ही नहीं, इसलिए बताया नहीं। 5 दिन के बाद या उसके बाद बताया, क्योंकि अरुण ने उसको रिपोर्ट किया, इसलिए उसने उसके बाद बताया। ये एक एंगल हो सकता है। और दूसरी जो बात है कि जो चीफ में नहीं आया है वो पर आप अगर क्रॉस कर लेते हैं और वो मीटिंग है तो फिर आपको कन्विक्शन से कोई बचा नहीं सकता है। देखा जाता है ना,
मैम एक्चुअली जो मेरा नेक्स्ट इशू है वो उसी के बारे में बोलता है, क्योंकि जो मर्डर किया है वो जावेद ने किया है, ऐसा डिफेंस काउंसिल के एलिगेशन है। तो जावेद एक्चुअली उसको बताया उस दिन कि बेड के नीचे आपके पापा की बॉडी है, क्योंकि मैंने जब विटनेस जावेद जब विटनेस बॉक्स में आया तभी मैंने उनको पूछा कि आपका टेस्टिमनी कब रिकॉर्ड हुआ, तो उन्होंने भी बोला कि 24 को हुआ। तो तभी कोमल भी वहां थी और कोमल ने ही सॉरी जावेद ने ही कोमल को ये प्रोवोक किया कि आपके पापा की बॉडी वहां पे है। और अरुण ने
तो वो पॉइंट के लिए आपने उसको अलग से पूछने का कि बेटा तेरे को कुछ सिजोफ्रेनिया की दवाई लेते हो तुम, ऐसा कुछ अलग से पूछने का। बेटा उसके बाद जावेद अंकल से मिले थे, उनके साथ थे, ऐसा कुछ पूछना था। ये वो सब आपने दिल में रखा कि उसमें से हम स्ट्रेटेजी फॉर्म करेंगे, स्टोरी फॉर्म करेंगे। और पूछा सवाल ऐसा कि तुमने ही जाके पुलिस को बताया ना, अभी लड़की ने बोला मैंने ही जाके बताया है पुलिस को, तो यानी वो कंफर्म्ड हो जाता है ना।
यस
ऐसा है वो।
और आपको मैसेज डाला है ऑर्गेनाइजेशन ने कि आपका क्रॉस का समय समाप्त हो गया है।
ठीक है सर, मैं इशू नंबर 3 के ऊपर आ सकता हूँ सर? सर मैं इशू नंबर 3 कर सकता हूँ आगे बात?
यस यस
ओके, तो मैम इशू नंबर 3 है कि who kill रामपाल सिंह। सो रामपाल सिंह मीन्स कि डिफेंस काउंसिल का मानना ये है कि अकॉर्डिंग ये है कि किसी ने बेनिफिट लिया रूमर्स ऑफ सुरेखा एंड मोहन रिलेशनशिप एंड किल रामपाल। तो वो कैसे हम प्रूव कर रहे हैं मैम? फैक्ट के बारे में थोड़ा फैक्ट से हम ये कर रहे हैं। रामपाल सिंह एंड हिज फैमिली शिफ्टेड टू मुंबई मैम आपकी परमिशन है मैम, मैं कंप्लीट कर दूं इशू नंबर 3?
क्विकली, जल्दी करो।
यस मैम। तो मैम जब रामपाल यहाँ पे आए तो विद इन अ 1 पीरियड ऑफ टाइम, विद इन अ 1 ईयर पीरियड ऑफ टाइम उसने जो विजू ओनर है उनका ट्रस्ट जीत लिया। और उसके वजह से मैम जावेद के दिल में उसके लिए जेलेसी तैयार हो गई थी, पर उसने वो दिखाया नहीं, वो सिर्फ फ्रेंडशिप का एक्टिंग कर रहा था वहां पे। और जब उसे मौका मिला तब उसने वहां पे उसका मर्डर कर दिया। और 9 नवंबर को द लास्ट पर्सन who met रामपाल एक्सेप्ट हिज फैमिली, तो वो जावेद था। तो जावेद 9 नवंबर से 24 नवंबर तक क्यों चेक करने नहीं गया वहां पे कि रामपाल क्यों नहीं आ रहा है करके, कि उसको पता था कि रामपाल का खून हुआ है, कि उसने इंटेंशनली रामपाल को उतना पीने पे प्रोवोक किया था, या ही टेकन एडवांटेज एंड किल रामपाल। तो ऐसे 3 प्रश्न तैयार होते हैं बिकॉज ऑफ द बिहेवियर ऑफ जावेद, बिकॉज वो मिलने नहीं गया उसे उसके घर पे। एंड देयर आर मेनी अनसॉल्व क्वेश्चन इन द केस। तो फर्दर इन्वेस्टिगेशन की मैम होनी चाहिए थी अच्छे से, पर पुलिस ने की नहीं।
यस हो गया आपका?
यस मैम।
आपकी स्ट्रेटेजी मुझे अच्छी लगी, जो स्ट्रेटेजी आपने ले की थी, लेकिन उसको आपने विटनेसेस के क्रॉस में क्वेश्चन की तैयारी नहीं थी, ऐसा है। वरना आपने स्ट्रेटेजी जो आर्ग्यूमेंट में ली है वो अच्छी है, पर वो कनेक्ट नहीं हुई है कि क्रॉस जिन जिन की ली है या क्या क्रॉस लिया है, वो हिसाब से।
एक ये भी एंगल हो सकता था आपकी स्ट्रेटेजी को जो सपोर्टिव है कि जावेद और ये सूरज जाया करते थे जिस परचेस के लिए, बहुत पैसा होता था, तो पैसा को जिसने गड़बड़ किया और इसको मार डाला, ऐसे एंगल हो सकता है।
नहीं सर, ये भी हो सकता था कि वो पहले अकेला जाता था, तो वो मे भी उसमें से कुछ कमीशन करता रहेगा, और ये हॉनेस्ट था रामपाल, तो उसके ऊपर भी उसका जेलेसी, क्योंकि रामपाल की वजह से उसको कुछ करने नहीं मिलता होगा, और जेलेसी के ऊपर उसने किल किया, उसका मर्डर हुआ गया।
स्ट्रेटेजी अच्छी थी, पर क्रॉस में एग्जीक्यूट नहीं किया आपने, ऐसा है।
ओके मैम।
हाँ, क्रॉस में वो एग्जीक्यूट करते तो बहुत बहुत अच्छी स्ट्रेटेजी थी ऐसे।
ठीक है मैम, तो प्रेयर बोल दूं?
जी।
Okay. So, in light of issue raised and argument advanced, the authority cited, may this honorable court kindly be pleaded to the respondent number 1 and number 2 are innocent. Honorable court may release them from judicial custody. They will attend all proceeding if court may ask them to, and they will appear in front of police if police call them for the investigation, and pass any other just and equitable and further appropriate relief in favor of, and for the time and for this act of kindness and justice, the respondent shall is in the duty. Yes ma'am.
आप जो अभी ऐसे हुआ है कि दो बातें हैं इसमें आपके प्रेयर में। आपने इस कदर वो पढ़ लिया कि जैसे हम कोई न्यूज़पेपर पढ़ते हैं ना, द टाइम्स ऑफ इंडिया, तो उसमें हेडलाइन पढ़ते हैं, बराबर?
यस मैम।
मैटर समझने के लिए, बराबर? तो आपने पढ़ना शुरू किया द टाइम्स ऑफ इंडिया, वेडनेसडे सो एंड सो डेट, ऐसा, जिसकी जरूरत नहीं है। वो जो आप लास्ट में पढ़ रहे थे ना, एंड फॉर दिस एक्ट ऑफ काइंडनेस द एक्यूज शैल एज इन ड्यूटी बाउंड एवर प्रे, वो हर एप्लीकेशन में जाता है।
ओके मैम, तो
आपका प्रेयर, अभी आपने प्रोसिक्यूशन का भी यही फॉल्ट था, दोनों काउंसिल को इक्वली मैं एड्रेस करती हूँ, कि आपका प्रेयर, आपने पूरा ट्रायल लड़ा है कि उसको बाहर निकालने के लिए, बाइज्जत बरी करने के लिए, निर्दोष साबित करण्यासाठी पूर्ण ट्रायल लढलं, आणि शेवटी बेलचा प्रेयर मागितला की त्याला बेलवर सोडा। आपकी हिंदी अच्छी है कि मराठी अच्छी? विच लैंग्वेज शुड आई कंटिन्यू?
मराठी।
माय ब्रदर जज विल टेक ओव्हर ऑन दिस। मला मराठीमध्ये हे समजावून सांगा की त्याने अख्खा ट्रायल लढल्यानंतर बेलचं प्रेयर आहे सर।
ट्रायल पूर्ण ट्रायल संपली, ज्यावेळेस आपण एव्हिडन्स कंडक्ट करतो ना, ती ट्रायल साठीची एव्हिडन्स असते। तर ट्रायल तुमची संपली, त्यानंतर तुम्ही सांगायचं की प्रॉसिक्युशनने त्यांची केस प्रूव्ह करू शकले नाही, त्यामुळे कम्प्लीट ऍक्विटल आम्हाला द्यावं सगळ्या सेक्शन मधला,
ओके,
अशी प्रेयर पाहिजे। आणि जर बेलची आहे तर त्याच्यामध्ये अशी पाहिजे की इन्व्हेस्टिगेशन कंप्लीट झालेलं आहे, आता पुन्हा आमच्या गरज नाही म्हणून आम्हाला बेल देण्याचा, मग त्या अल्टरनेटिव्ह गोष्टी आहेत, आम्ही कोर्टात राहू, पोलिसांना सपोर्ट करू, विटनेस ला धमकवणार नाही, एव्हिडन्स टॅम्पर करणार नाही, हे सगळं त्यानंतर येणार।
हा एक खूप महत्वाचा पॉइंट आहे, ज्यामध्ये बरेचसे काउन्सिल रॉंग जातात मूट कोर्ट मध्ये। माय ब्रदर जज विल थ्रो लाईट ऑन दिस की बेल आणि एक्विटल ह्या दोन गोष्टींमध्ये काय फरक असतो? कारण आता आपण पाहिले की हे काउन्सिल्स, काही काउन्सिल्स जे आहेत, बरेचसे काउन्सिल्स, त्यामध्ये मूट कोर्ट मध्ये ह्यांना पूर्ण ट्रायल लढल्यानंतर त्यांचा प्रेयर जो असतो तो बेलच्या दिशेने असतो। बेल आणि एक्विटल ह्या दोन गोष्टींमध्ये काय फरक आहे हे यांना जरा मराठीत आपण जर समजवलं, कारण तो गायडन्स गरजेचा आहे, जो आपण फर्स्ट हँड बिफोर कोर्ट आपण प्रे करत असतो।
बेल म्हणजे काय तर ट्रायल तुमची सुरू राहणार, पेंडिंग राहणार, आणि जोपर्यंत ट्रायल पेंडिंग आहे तोपर्यंत जेलमध्ये आम्हाला ठेवू नका, आम्हाला बेलवर सोडा. ही बेल प्रेयर असते ती अरेस्ट केल्यावर केसी झाल्यावर इमिडिएटली करू शकतो, चार्जशीट फाईल झाल्यावरही करू शकतो, किंवा कुठल्याही स्टेजला करू शकतो. आणि ट्रायल संपल्यानंतर ट्रायलचा आरोपी बेलवर पण असू शकतो किंवा जे ज्युडिशियल कस्टडीत पण असू शकतो. त्यामुळे तो फरक एक समजून घ्यायचा की जरी ट्रायल चालू आहे आणि बेल झाला तरी कोर्टात तुम्हाला तारखांना यायचंच आहे प्रत्येक तारखेला, पण ट्रायल सगळं संपलं, पुन्हा
हा
कोर्टात
एक मोठा फरक आहे की बेल मिळाला तरी तुम्हाला ट्रायलला यावं लागतं, म्हणजे कोर्टात यावं लागतं, तारखांना यावं लागतं, तारीख पे तारीख. परंतु एक्विटल मिळालं म्हणजे बाइज्जत बरी होणं, म्हणजे त्यानंतर कोर्टाचा रस्ता संपला, कोर्टात जाण्याची आवश्यकता नाही. इसलिए प्रोसिक्युशन काउन्सिल ऑल्सो तुम्ही जे सांगितलं की रिक्वेस्ट नॉट टू कंसिडर एनी बेल, आपका प्रेयर ये था. आपको हिंदी कंफर्टेबल, मराठी कंफर्टेबल?
चालेल मॅडम, कुठली भाषा चालेल, मराठीत बोला, एकदम कम्फर्टेबल, काय प्रॉब्लेम नाही.
अच्छा, व्हेरी गुड. मी मुद्दाम ती भाषा ठेवते कारण कोर्टाची शासकीय भाषा ती आहे.
नाही हो, कल्पना आहे मला.
हा, तर त्यामध्ये तुम्ही पूर्ण केस जी आहे चीफ लढलात आणि आपल्याला त्याला प्रॉसिक्युशनला एक तर माणसाला फासावर चढवायचं किंवा लाईफ सेंटेन्स द्यायची किंवा मॅक्झिमम सेंटेन्स द्यायचे, ते त्यांच्या ह्याच्यात करतात न्यूट्रली. तर तुम्ही हे म्हणालात की रिक्वेस्ट नॉट टू कन्सिडर एनी बेल, तर तो बेलचा पोझिशनच नाही. आपण जिथे ट्रायल फाईट करतो तिथे फायनल याच्यावर की याला सजा द्या. बेलची पोझिशन असते जिथे ट्रायल चालू होत नाही. जनरली स्पेशल कंडिशन्स मध्ये ती ट्रायल नंतर, ट्रायलच्या दरम्यान असते, पण जिथे ट्रायल चालू होत नाही तिथे ते बेलवर तोपर्यंत. जसे माझे ब्रदर जजने सांगितलं की ट्रायल चालू व्हायला आता 5 वर्ष लागतात, 7 वर्ष लागतात, मग माणूस आतमध्येच राहील का? समजा एखाद्या गुन्ह्याची सजाच 4 वर्ष आहे तर तो 7 वर्ष थांबेल का ट्रायल चालू व्हायला? मग कोर्टाला सांगतो तोपर्यंत बेलवर सोडा. आणि ट्रायल नंतर जे असतं ते कन्व्हिक्शन असतं किंवा एक्विटल असतं, हे 2 शब्द आहेत. एक्विटल म्हणजे सोडून देणे, कन्व्हिक्शन म्हणजे त्याला सेंटेन्स देणे, असं आहे. आलं लक्षात? तर ते तुमचा युअर प्रेयर वॉज ऑल्सो फॉर बेल, तुमचा बेलचा प्रेयर होता. तुमचा प्रेयर हा असला पाहिजे. नाव ते सुद्धा माझे ब्रदर जज तुम्हाला सांगतील की प्रॉसिक्युशन काय सांगतं, त्यांचा प्रेयर काय असतो. सर प्लीज टेक ओव्हर.
प्रॉसिक्युशनचा सगळ्यात आधी बिंग अ पब्लिक प्रॉसिक्युटरचा रोल पाहिजे की आरोपीला शिक्षा करण्यासाठी तुमचे प्रयत्न नाही पाहिजे. काय खरं आहे हे कोर्टासमोर आणण्यासाठी कोर्टाला मदत करणारे तुम्ही अधिकारी आहात. युजली गैरसमज असतो की पीपी म्हणजे त्याचं काम आहे की सिक्युअर करणं हेच काम आहे, असं नाही. हे झालं ट्रायल दरम्यान. आणि ट्रायल नंतर ज्यावेळेस कोर्ट म्हणतं हे झालं, कन्व्हिक्शन त्याला होतंय, त्यावेळेस तुमचा रोल असला पाहिजे की मॅक्झिमम पनिशमेंट त्याला द्यायची.
सर आवाज मध्ये ऑडिबल नव्हता, प्लीज 2 सेंटेन्स परत बोला.
त्यामुळे तुमची ज्यावेळेस कोर्ट सांगते की कन्व्हिक्ट केलंय, त्यावेळेस तुमची प्रेयर असली पाहिजे की सगळ्या जे काही पुरावे आहेत ते पाहिल्यानंतर कन्व्हिक्ट केल्यावर आमचं असं म्हणणं आहे की याला जास्तीत जास्त शिक्षा देण्यात यावी. ज्या सेक्शन साठी कन्व्हिक्ट केलंय त्यामध्ये जी प्रोव्हिजन आहे त्यातली मॅक्सिमम पनिशमेंट शुड बी ग्रँटेड, अशी तुमची प्रेयर तेव्हा असली पाहिजे.
गुड. ये तुमच्या गायडन्स साठी होतं, कारण तुमचा एस्पेशली प्रॉसिक्युशन साईड तुम्ही तयार नव्हता अजिबात, तुमची तयारी नाही आहे ह्या गोष्टी, परंतु तुमचा जो हजरजबाबीपणा आहे तो आम्हाला फार आवडला की तुम्ही रेडी होता की ठीक आहे मी चीफ घेतो, माहित नाहीये कोण काय, तुमचे पेपर्स हरवले वाटतं, कोण कलीग जॉईन होऊ शकलं नाही, तर तुम्ही यू स्टूड बाय इट, यू डिड नॉट रन अवे. and it was a very good way that you handled it in. That composure was there. Their calmness was there. Although nervousness was there, calmness. I understand it comes with wisdom, and wisdom comes with age. तर ते आपल्या एज मध्ये ते जरा चांगल्या रीती देतं. मुलांच्या एज मध्ये ते आपण अपेक्षित करू शकत नाही, परंतु इतर मुलांनी हे शिकावं की आपल्याला आलेल्या परिस्थितीमध्ये तो काम मेंटेन करायचा. आपला काय पार्टनर जुडू शकला नाही, पार्टनरचा प्रॉब्लेम झाला की पार्टनर हाफ ह्याच्यातूनच गायब झाला. पेपरवर लिहून आणले ते पेपर सगळे विस्कळीत झाले, ते मिक्स अँड मॅच झाले, ते कुठे सापडले नाही. आता विटनेस कोणता बोलवायचा? तुम्ही बोलवलं, तुम्ही केलं, यू स्टूड बाय इट. दॅट वॉज अ व्हेरी गुड अप्रोच फ्रॉम युअर साइड. नाही तर तयारी नाहीये, हे नाहीये, आणि अर्ध्यातून काहीतरी दाखवायचं की नेटवर्क नाही चालत, हे नाही चालत, आणि ऑफ. तसं तुम्ही केलं नाही. दॅट वॉज अ व्हेरी गुड अटेम्प्ट. खूप छान, दॅट वॉज गुड. आता मला सांगा, तुम्ही कन्व्हिक्शन साठी म्हणजे सजा लावण्यासाठी तुमच्याकडे काय पॉइंट्स आहेत तुमच्या आर्ग्युमेंटमध्ये?
जसं माझ्या मित्राने सांगितलं का स्किझोफ्रेनिया म्हणून हा जो रोग आहे ज्या कोमलला होता, फॅक्ट्स मध्ये कुठे असं मेन्शन केलंच नाही का कोमल एक पेशंट आहे किंवा कोमलला रेग्युलर त्या कुठल्याही आजूबाजूच्या मेडिकल शॉप मधून तिला औषधं चालू होती, कुठल्या डॉक्टरकडे तिचं ट्रीटमेंट चालू होतं. व जेव्हा सुरेखाचं आयोनी स्टेटमेंट घेतलं, त्या स्टेटमेंटमध्ये तिने फक्त मेन्शन केलंय स्ट्रॉंगली, आणि ती बोलली का मी मेडिकल सर्टिफिकेट जे आहे तिचे ते तुम्हाला आणून देते. मेडिकल सर्टिफिकेट आजपर्यंत मिळाले नाहीये. नंबर 1. नंबर 2, असं म्हटलं जाते तिने तिच्या स्टेटमेंटमध्ये असंही सांगितलंय का मी 3 तास कराटे क्लाससाठी माझ्या मुलीला घेऊन गेली होती. स्किझोफ्रेनियाचा जो पेशंट आहे, जो मेंटल डिसऑर्डर असतो, त्याच्या ट्रीटमेंटमध्ये मेंटल डिसऑर्डर साठी समजा एखादी मुलगी 9 तारखेला रात्री झालेले इन्सिडेंट आहे, या टाईपचे पेशंट आहे ना, ऍक्च्युली नॉर्मली सगळ्या गोष्टी विसरतात, म्हणजे इरेज होतो त्यांच्या सिस्टम मधून, आणि मग नवीन गोष्टी पुन्हा भर होतो, पुन्हा आणि एक स्टेबिलिटी नसते त्यांच्या स्टेटमेंटमध्ये. इथे तिला जेव्हा जेव्हा विचारलं गेलं ना, एक 9 तारखेची गोष्ट, 22 तारखेला पोलीस स्टेशनमध्ये भले आयोसमोर नाही पण आपल्या काकासमोर जेव्हा काकाने विचारलं तेव्हा तिने उत्तर दिलं. त्याच्या आधी ती घाबरामध्ये होती, आईने घाबरून ठेवलं होतं. एकही बघा घरात कसा आईचा रुबाब चालतो, आईचा वट चालतो. पोलीस स्टेशन मध्ये गेल्यानंतर आई असो, काका असो, मामा असो, नाना असो, कोणाचं चालत ना, आयोचं चालतो. आणि हा एकदम सिरियस मॅटर होता, मर्डर केस होता. त्यावेळेला जेव्हा सगळं माहोल बघून काकाने जेव्हा प्रेमाने, जसं मला आमच्या सरांनी जसं मला सांगितलं का काय क्वेश्चन तुम्ही रेज करू शकता एक छोटीशी बाळला, 11 वर्षाच्या मुलीला, तर त्याप्रमाणे जेव्हा बघा कुठल्याही मुलीला आपल्या नातेवाईक जे असतात त्यांच्याशी अटॅचमेंट थोडाफार असतो. 5 दिवस ती मुलगी का बोलली नाही, कारण काकाने कधी तिला विचारलंच नाही. समोरून एक तर घाबरा घरातला, आईने तिला सोडली पण नसावी, आई नेहमी बरोबर घेऊन, बिकॉज कारण का हा बिचारा भाऊ आहे, तो हिंडत फिरतो शॉप मालकाकडे किंवा मित्रांकडे, बाबा माझा भाऊ कुठे आहे, तो सापडत का नाही, सुरतला गेला, सुरतला 1 महिना लागतो का, याच्या आधी 1 महिना कधीच लागला नाही, कुठे मेन्शन केलं नाही. ओके, सो 3 तासाच्या कराटे क्लासमध्ये कोणतरी येऊन तुमच्या घराच्या टाईल्स उघडतो, खड्डा खणतो, 3 बॅगा गाडतो, परत टाईलचे एव्हिडन्स मिळतात आयोला, टाईल्स फ्रेश लावलेला तिकडचा बॉक्स आणि काही तुकडे सापडतात. घरात एवढं मोठं काम झाल्यानंतर 3 तास आल्यानंतर कोणाला कल्पना देखील नाही का माझ्या बेडच्या खाली काम झालंय. कन्स्ट्रक्शन कामाला आपण वैतागतो, सिमेंट रेती, याच्याने एका दिवसात कुठलंच काम आपलं झालं नाही, हे 3 तासात काम होऊन गेलंय. तर जावेद जेव्हा रात्री 9 वाजता सोडतो आणि मग पुन्हा तो मर्डर करून कुठेतरी बॉडी ठेवतो, मग हिची वाट बघतो कराटे क्लासला जायची, मग आणून बॉडी गाडतो, याच्यात काय तथ्य मला या स्ट्रॅटेजीमध्ये काय वाटलं नाही. So still my prayer will remain. Now ma'am, I'm trying to say prayer in front of you. खरे prayer तुम्ही बघा आणि मला करेक्ट करा. नक्कीच I will need your opinion and corrections. It is written Surekha and Mohan Prakash to be sentenced for life imprisonment under section 302 of IPC 1860. Mohan and Surekha to bear all expenses of daughter Komal until she is independent to take a decision in life. That means until she becomes major. असे दोन प्रेयर लिहून पाठवले आहेत.
पहिला प्रेयर योग्य आहे, कारण आपल्याला सजा द्यायची असते.
हो.
आणि हे सेकंड प्रेयर जो असतो ना तो फॅमिली कोर्टातला असतो.
अच्छा.
हा, तर फर्स्ट
तर
प्रेयर
याच्यामध्ये आपण या कोर्टामध्ये या क्रिमिनल ट्रायल मध्ये आपण
नाही
कोर्टाला
नाही, त्याबद्दल मागू शकत नाही. ते रेपचे वगैरे विक्टिम्स असतील इतर असतील तर ते कम्पेन्सेशन स्टेट कडून वेगळ्या प्रकारे मागू शकतो, यात नाही. आणि तुमचे हे सबमिशन्स जे आहेत, सम ऑफ दी सबमिशन्स व व्हेरी गुड, चांगले, खूप चांगले सबमिशन होते, परंतु एक स्ट्रॉंग सबमिशन तुम्ही करू शकला असता. तुमच्या सबमिशन्समुळे मला ते लक्षात आलं, जे तुम्ही नाही केलं, की ती सिझोफ्रेनिक पेशंट आहे असं यांचं म्हणणं आहे. तर तुम्ही हा आर्ग्युमेंट पण घेऊ शकला असता की सिझोफ्रेनिक पेशंट जर आहे तर ती कराटे क्लासला जाते. हे एक चॅलेंजिंग स्पोर्ट्स आहे. हे चॅलेंजिंग स्पोर्ट्स कसं काय ती करते मग? इफ शी इज
माइंडची गरज असते.
हा, आणि इफ शी इज सिझोफ्रेनिक तर एग्रेसिव्ह स्पोर्ट मध्ये टाकणार पण नाही.
बरोबर.
एडवाइजेबल.
येस येस येस, करेक्ट मॅम, व्हेरी ट्रू.
मॅम मी उत्तर देऊ शकतो याला?
हा प्रकार होतो. नंतर मग ह्याच्यामुळे हे सिद्ध होतं की शी इज नॉर्मल अँड नॉट सिझोफ्रेनिक असं तुम्ही घेऊ शकला.
मॅम मी उत्तर देऊ शकतो याला, या स्टेटमेंट? मॅम
बोला बोला.
येस मॅम. तर त्यांनी जे सांगितलं की सुरतला जायला 1 मंथ लागत नाही, तर जावेदने त्याच्या स्टेटमेंटमध्ये आता जेव्हा विटनेस बॉक्समध्ये आला तेव्हा तो बोलला की 1 मंथ लागतो करून. ते एक झालं. आणि ते बोलतात की कोमलची विटनेस मी बोललो की टेस्टिमनी घेऊ शकत नाही, पण जर ती तुम्ही ऍडमिसिबल करत असाल तर तिने तिच्या विटनेस स्टेटमेंटमध्ये एक सांगितलं आहे की आईने जेवण बनवलं आणि आम्ही सगळे जेवून ते झोपून गेलो. पण जेव्हा पोस्टमॉर्टम रिपोर्ट झाली तेव्हा त्यामध्ये सांगितलं गेलं की त्याच्या पोटामध्ये काहीच नव्हतं, त्याचा पोट पूर्ण मोकळं होता. तर जर जेवून झाले असतील तर त्यांच्या पोटामध्ये काही ना काही अन्न राहिलं असेल. पण पोस्टमॉर्टम रिपोर्टमध्ये सांगितलं गेलंय की तिथे त्यांचं पोट पूर्ण मोकळं होतं. म्हणजे हे सिद्ध होतं की त्यांचा खून 9 नोव्हेंबरच्या रात्री झाला नव्हता करून. जर तुम्ही कोमलचं स्टेटमेंट ऍडमिसिबल करत असाल तर हे असं सिद्ध होतं. एक
दॅट्स ऑल्सो अ गुड पॉइंट. चांगला पॉइंट आहे तो. तुम्ही जे सांगितले तुमचे 2 पॉइंट चांगले त्यातले जे सांगितले. पण आता ह्यात ओनली थिंग व्हॉट हॅड मॅटर्ड इज तुम्हाला, आय विल मेंटेन इट अगेन, तुमचे पहिल्यापासून स्ट्रॅटेजी खूप चांगली होती. स्ट्रॅटेजी मध्ये नंतर आपण क्वेश्चन्स काढायचे असतात आणि लिहून ठेवायचे असतात की आपल्याला कोणत्या विटनेसला विचारायचे.
मॅम ते सगळं केलेलं पण इंग्लिश मध्ये थोडं झालं नाही.
आणि कधीही तुम्ही आलात ना कोणत्या कॉम्पिटिशनसाठी तर एक प्रयत्न करायचा कोर्टासमोर की कोर्ट विथ माय लॉर्ड्स काइंड परमिशन मे आय सबमिट इन मराठी. मध्ये त्या भाषा रेग्युलर आहेत की मी मराठीत विचारलं. खालच्या कोर्टात जेव्हा आम्ही बोलतो तेव्हा मला तर विचारावं लागतं, मी इंग्लिश मध्ये विचारलं तर चालेल का, तुम्हाला समजेल का? कारण विटनेसेस तुम्ही इकडून तिकडून आणणार, फिटर, मेकॅनिक, हे ते वगैरे, तुम्हाला काय वाटतं सगळे इंग्लिश मध्ये बोलणार? ते सगळे त्यांच्या वर्णॅक्युलर, एक तर हिंदी ना तर मराठीमध्ये बोलतात. कळलं? त्यामुळे क्वेश्चन, कारण तुमचा लँग्वेज बदलल्यानंतर तुमचा फ्लो ऑफ थॉट किती सुंदर झाला, छान झाला. आणि आय मेंटेन इट की बिकॉज ऑफ लँग्वेज गुड नॉलेज शुड नॉट बी रिजेक्टेड. लँग्वेज सबऑर्डिनेट आहे. आपण या राज्यात राहतो, या देशात राहतो आणि इथली मेन लँग्वेज काय आहे तर त्याच्यात सगळं कामकाज चालू शकतं. गुजरातीमध्ये आर्ग्युमेंट्स आणि फाईट्स होतात.
येस मॅम.
त्यामुळे
कॉम्पिटिशनचे रूल्स होते की इंग्लिश मध्ये हे करायचं करून प्रेझेंटेशन.
अच्छा, पण देन इट इज क्वेश्चन जर तुम्ही लिहून ठेवलं ना तर तुम्हाला क्वेश्चन हेल्प करतो. म्हणजे तुम्ही बघून सुद्धा बोलू शकता.
येस येस.
तुमचे क्वेश्चनच वेगळे गेले है ना. बट इट वॉज अ गुड अटेम्प्ट, व्हेरी गुड अटेम्प्ट.
थँक्यू मॅम.
सो इट इज ओव्हर नाउ, वी एंड इट.
येस येस
एक शेवटचं छोटं 2 सेकंड साठी विचारू का मी? इफ यू डोंट माइंड, इफ यू परमिट मी, देन इट नो इट्स दॅट फाईन. माझ्या मित्राचं ऑब्झर्वेशन थोडंसं चुकलं. Internal examination point number 2, where it is written, the intestines are unremarkable and carry partially digested matter. That means it was not fully digested what was earlier had consumed, but it is partially digested. That means partially it was not digested. So that means the cooked food, they cooked the food and they had something in the night, and then they all went to sleep. So here also Komal was not wrong, which I wanted to just make a note of that point, which is written here. That's all. Thank you. I have taken a lot of your time.
म्हणजे तुम्हाला काय सांगायचं होतं?
का ते जेवले कोमलचं स्टेटमेंटचे जे चुकीचं बोलले होते ना, का जावेदनी मर्डर केला. जावेदनी मर्डर न केल्यास ना, मर्डर इथेच झाला आहे घरामध्ये. तेव्हाच ती बॉडी जेव्हा कापत असताना कोमल आई
एकत्र जेवले असं तुम्हाला म्हणायचं, बरोबर?
जेवले म्हणजे कोमल
तुम्ही जसं तुम्ही म्हणालात की ते तुडुंब पिला होता आणि पिऊन तो घरी आला होता, बरोबर, लिकर. मग ते त्याच्या पोस्टमॉर्टम मध्ये किंवा इतर याच्यात सापडलं नाही, लिकर नाही सापडलं. गोळी जी घेतली ना स्लिपिंग टॅबलेट्स, त्या स्लिपिंग टॅबलेटचं काहीतरी नाव दिलंय ते सापडलं, बरोबर. तर ह्यावर तुमचं काय म्हणणं आहे?
See, even urinary जो मेन्शन केला पॉइंट नंबर 1, the urinary bladder contains approximately 656 cc of urine. तो जो युरिनचं प्रमाण जास्त आहे ना, समजा त्यांनी बियर कन्झ्युम केली असेल तर बियर दिस प्रोडक्ट गेट्स कन्वर्टेड
केली, परंतु लिटर त्यांचं ब्लड मध्ये सापडलं नाही, हा माझा मुद्दा आहे. युरिन मध्ये पण नाही लिहिलंय का कुठे लिकर? नाही ना, कुठेच नाही लिहिलंय.
नाही, लिकर कुठे लिहिलं नाही.
तुम्ही सांगितलेलं तुडुंब भरले, पण लिकरचं कुठे लिहिलेलं नाहीये. नाव फॉर युअर आर्ग्युमेंट, तुमच्या आर्ग्युमेंटसाठी, आता तुम्हाला क्रॉस करायचं म्हणून मी विचारलं, पण तुमच्या आर्ग्युमेंटसाठी तुम्ही म्हणू शकता की लिकर जर घेतलेला असेल तर लिकरचे ट्रेसेस मला वाटतं काहीतरी 8 ते 12 तासामध्येच मिळतात, 6 ते 8 तासांमध्ये मॅक्झिमम, कुठे कुठे 72 तासापर्यंत, नंतर मिळत नाही, नंतर ते ब्रेकडाऊन होतात. यू कॅन टेक दॅट फॉर आर्ग्युमेंट, असं आहे. गेटिंग इट? कारण तुम्ही जेव्हा म्हणालात की तुडुंब पिऊन गेलेला आहे, मग तुम्ही बघायचं की रिपोर्ट मध्ये आहे की नाही. मग नाही आहे तर त्याचं मग आर्ग्युमेंट काय, ह्याला रेडी राहायचं. It was a good try given on the spot by both the parties. So we can end here.
Yes, ma'am. Thank you, ma'am, for your kind words.
Thank you, ma'am.
Yes, ma'am. Thank you, my lord. Thank you, my lady. We can end here. VTM 08 and VTM 07. You are requested to leave this meeting. You will be asked to join for the result declaration. Please leave.
Yeah.
Ma'am and sir, sir has already WhatsApped me the results. Ma'am, you can also WhatsApp me the results.
Yes.
Please.
So, can we leave the meeting now?
Yes, sir. Thank you so much. Thank you so much, ma'am and sir, for your time and guidance.
Good evening, everyone. So we are here for the results, the long awaited results since morning. So in today's day, we had moot court competition, think logically competition, and the law quiz. Results for the same are being announced. Starting with, give me a minute. Starting with think logically competition. The people who would be going ahead from the think logically competition the people going in the next round for think logically are VTT01 and VTT02. Congratulations, VTT01 and VTT02. All the best for your next round. The law quiz results. The teams going ahead in the next round are VTQ04, VTQ01, and VTQ02. I repeat, the teams going ahead in the next round are VTQ04, VTQ02, and VTQ01. Congratulations to all the three teams and all the very best for your next rounds. Coming to the moot court competition results. The teams that would be going ahead are VTM05, VTM02, VTM03, and VTM04. I repeat, the teams going ahead in the moot court competition are VTM02, VTM03, VTM04, and VTM05. Congratulations, everyone. Wishing you all the very best for your next rounds. I request the other people from the law quiz, the think logically, and the eliminated people from the moot court competition to kindly leave this meeting. We'll have the draw of lots round in the next 5 minutes. For VTM02, VTM03, VTM04, and VTM05. We shall have the draw of lots in the next 5 minutes. I request the others to please leave. So starting with the draw of lots. So we are starting with the draw of lots. The chits picked up by the girl would be for the appellant, and the chits picked up by the boy would be for the respondent. I repeat, chits picked up by the girl would be for the appellant, and the chits picked up by the boy would be for the respondent. The first chit is VTM05. Appellant VTM05 versus VTM02. VTM05 versus VTM02. Respondent. Next. VTM03 appellant. VTM03 appellant versus VTM04 respondent. VTM03 appellant versus VTM04 respondent. Thank you. See you tomorrow. All the very best. The memorials for the opposite. The memorials for the opposite teams would be shared with you by 7 p.m. today evening. The memorials for the opposite teams would be shared with you by 7 p.m. today evening. Thank you. We end the meeting here.